court may enter such judgment as law and justice may require. Think about that for a second. We're talking about proceeds, the property or its proceeds. See, the complaint security and the citation have value. You gave them value. They negotiated those instruments and they got your credits, which are their credit liabilities. So now their books show a debt due and owing. The debt due and owing is evidence of their credit liability due and owing to you, which means they owe you the proceeds for what they transferred, because remember, it's general tangibles and general intangibles. What's the new money under the 73rd Congress, First Session, Volume 77, Part 1 again? Notes, drafts, bills of exchange, bankers' acceptance, trade acceptances, and contracts, letters of credit. What are they doing in the court? Notes, drafts, bills of exchange, bankers' acceptance, trade acceptances, letters of credit, and contract.
It's almost like a premature probate.
Didn't we say in 40 statute of large 411, Section 7E, that trade is a form of payment? And that in 40 statute at large 411, Section 7E, we didn't say trade is a form of payment. That was up higher in 40 statute 411, which is legal evidence of the law. But 40 statute at large 411, Section 7E, the certificate that you're granted is a full acquittance and discharge. So
It
you
is a
did do something wrong. It says in 40 statute at large 411, Section 7E, it's a full acquittance and discharge, and you cannot be held liable in any court for any reason pertaining to anything in maritime admiralty jurisdiction, because all obligations are obligations of the United States under Title 18, subsection 8.
You said the registrar is a
Under Article 1, Section 10, they can't demand any specific specie because that violates public law and public policy. And yeah, they did away with House Joint Resolution 192. But you know what they didn't get away with? 4848 Statute at Large 112, which is verbatim House Joint Resolution 192. The only difference is 4848 Statute at Large 112 was never repealed. And it's a statute at large. And it's legal evidence of the law pursuant to Title I, United States Code 112-113. And as we learned in 40 statute at large 411 section 7E, anything done, omitted by any rule, regulation, or policy or procedure of the president by order of the president of the United States is a full acquittance and discharge. So how are you going to jail again? How is it they're warehousing your body?
Voluntarily.
You can bring forward the birth certificate and prove your interest in the funds that they're holding, and you've got the highest claim because you're arguing through title, not against title. They're in constructive possession of decedent estate property that belongs to you, and the evidence of that is that you are holding the certificate that entitles you to it.
Really?
When you release your beneficial interest in the matter and you relinquish it all to them, and they just say, okay, get out of here, instead of negotiating. Hold on, we'll show you where it says negotiating, because this is ancillary process, or because it is intangible property in the hands of a person who has not been. Is it the trustee? Are you the executor of the estate?
Yes.
Giving him notice as the trustee of what he's to do with those rents, profits, proceeds, futures, and annuities that he's in constructive possession of?
Statement of interest.
Have you given your statement of motherfucking interest and followed Rule E5 and Rule C6? Statement of interest? When the unflappable was looking at me from the bench during sentencing, and you sure you don't have anything you want to file? He was looking for me to file my statement of fucking interest, which is exactly what Smoking Baby teaches you guys with the fucking W4. You wouldn't believe how many people, it didn't work. Like they're the only person in the world. Like you file something and tomorrow morning it's just going to show up at your fucking doorstep. It might take 2-3 years and it'll show up. And the sad thing is they won't even know what to do with it when it does show up. You only have to make an observation, create a record, and report it. You create the new money under the new law, that define what new money is, and you're responsible for reporting who's in constructive possession of it so they can go tax the motherfuckers and you can get a recoupment on it, which isn't too much to ask. And you can turn around and recycle it year after year after year, quarter after quarter after quarter after quarter. All right, let's see what it says here even further. Proceeds to show cause why it should not be delivered into the custody of the marshal. So the marshal is nothing more than a glorified collector. If you guys don't know that, the marshal can go anywhere in the world and they're nothing more than asset protectors and collectors. That's what they do. That's what marshals do. They go and they collect. Or other person or organization having a warrant for the arrest of the property. A warrant for the arrest of the property. This is where the warrant is a put call. It's evidence. It either is the check or it's evidence of the check that they're holding in abeyance and keeping from you, the actual funds, or paid into the court to abide the warrant, to abide the judgment. So wait, having a warrant for arrest of the property or paid into the court to abide the judgment, and after hearing, the court may enter such judgment as law and justice may require. Now remember, there ain't no such thing as justice because they didn't take the Article 6 oath. So this is just strictly fucking business. So you have a right to know the nature and cause, and part of that nature and cause is the full accounting of the securities they're negotiating and the advance they got from the Treasury so we can ensure the taxes are paid. Now, nobody qualifies for 11th Amendment immunity from the IRS, and as I explained to you earlier, because they're operating under the executive and legislative branch, which is exactly why all your alleged judges are registered with the Secretary of State because they're engaged in doing business, they must abide by and are subject to Title 26. They can get hammered for tax evasion, ladies and gentlemen. See, if they were actually operating in a judiciary, they'd be untouchable. But the fact of the matter is, they're operating underneath the executive branch administering a bankruptcy. Responsive pleadings, interrogatories, statement of interest, answer, in an action in rem. Everything they're doing is in rem, dealing with things, whether tangible or generally intangible. A person who asserts a right of possession or any ownership interest in the property that is the subject of the action must file a verified statement of right of interest.
Or interest, yeah.
Now, why is that? Remember when the district attorney handed the complaint security to the clerk? What was one of the prerequisites? It had to be verified, right? But he couldn't possibly fill out a verified complaint security because he doesn't actually have an interest in it.
Yeah, he can't certify the charges. If he can't
He
certify
did
the
it
charges,
on your behalf.
yep.
Get a draw, hoping to God you'd abandon it. And then you'd get guilt of the mind. Oh yeah, well I was speeding. Yeah, yeah. Oh yeah, I was. Oh, I'm guilty as a whore in church. Oh, absolutely. I'm so bad. I feel so bad. And to cover up what they're doing, they hit you with some benign fee or fine while they whisk away the rents, profits, proceeds, futures, and annuities of a very large investment from the advance they got from the Treasury, and then they turn around and invest it into like the S&P 500 or the foreign currency exchange or through the court registry investment system that's invested in all these different fucking things.
Chicago Board of Trade, futures
And
contracts.
to make it look like it's legitimate and you're being punished, we're going to issue a $500 fine. Well, that's all fine and dandy as long as it's complies with Article 1, Section 10. Yeah.
Yep. Okay, real quick, Derek. Let's take a break. It's 11:33 Pacific Standard Time. I'm going to stop recording.
You're gonna want to re-record because I haven't.
Yep,
even-
it's
I haven't
11:30.
even-
It's restart 11:33 p.m. Pacific Standard Time. We are recording again on my side. Thank you. Go ahead.
I haven't even got to the good part yet. Responsive pleadings, right? Interrogatories. Statements of interest, answer. So it's a statement of interest. Not I didn't do it, affirmed, denied, without knowledge. No. You didn't make a statement of interest because there's no verified complaint before the court. And they took your precious value time commodity and your signature and created a complaint security which has actual cash value. And they failed to disclose the full accounting. And under the Sixth Amendment, you have the right to know the nature and cause, and best of all, to face your accuser. And look, when they do the complaint security, it has to also have what? An affidavit. There has to be an affidavit attached to it. In rem action, a person who asserts a right of possession or any ownership interest in the property. The property is what? The docket number, the case number, and the advance from the Treasury. That is the subject of the action. How do you prove it? Well, you've got that birth certificate, which is power of attorney, and proves that you're the attorney, in fact, on behalf of the principal, and you have the whole world in your hands. You have complete autonomous control over it. Must file a verified statement of right of or interest within 14 days after the execution of process, or within the time that the court allows. Who are you going to file your statement of interest or notice of interest to? The clerk of the court. And you're going to do it how? Registered mail.
I hope you people are getting this. This is so important.
Certified mail, not fucking licking a duck's ass and stamping his pecker on the fucking mail. You're going to be doing it registered mail. Because why? Because the law says that securities must be accompanied by armed guards and kept under lock and key, and you must have evidence of chain of title. There can be no break in the chain of title if you seek to enforce it, because that gives them plausible deniability that a security may have been lost, and therefore they go, oops, it got lost. So under the securities laws, we can apply for a new one. We can just draft and draw another one. Isn't it funny how bankers come to foreclose on you and they go, yeah, our client, and they're fucking stupor and ignorance somehow lost the only thing that would have given them standing. So we filed an affidavit of a lost note, Your Honor. But even in our ignorance, we still are entitled to performance. Isn't that fucking nuts? If you lost a $100 bill and then you came up to me and said, hey, I lost a $100 bill and you need to give me that $100 bill, I would laugh my fucking ass off. I would laugh. But somehow these fucking banksters proclaim they lost the very thing that would give them fucking standing, when we know damn good and well they did it through an assignment after the trust had closed. They separated the note and the mortgage, and they did an assignment for an advance because their little happy asses couldn't fucking wait. So they peddled it for less than the value that it was worth, and then still have the audacity to attempt to come and foreclose on you and go to the court and grovel and say, we lost it. We filed an affidavit, but we're still the real party in interest and have standing. Well, guess what, Scooter? If you lost the tickets to the show, good luck getting through the gate, because they're going to say, yeah, we've heard this 10,000 times before. Sure, you bought these tickets to come see Ozzy Osbourne, but guess what? No tickets, no show, right? But somehow the banksters get away with it, right? But have you filed your notice of interest? Do you have the ability to foreclose on them? Because by foreclosing on you, they're actually admitting that they owe you a performance, because they're saying there's a debt. And if they're alleging there's a debt on their books, that means there's a credit liability owing to you. And that's why the books aren't balanced. And the court is doing the same fucking thing to you. The statement of right or interest must describe the interest in the property that supports the person's demand for its restitution. I like that word, restitution. It's a lot like prostitution, but without all the work. Or right to defend the action. An agent, bailee, or attorney must state the authority to file a statement of right or interest on behalf of another. Guess what? Guess what? Who's the beneficiary in this matter? Is it you?
Yes.
Bullshit. Wrong. You fail. We're taking your shit. Go to jail. Who's the beneficiary in this matter? Because we've been looking at this system all ass backwards. The beneficiary is the Social Security juristic person.
For the air, yes.
Okay? And the evidence of that is the fact that you have a certificate that was issued by the president making you the attorney in fact, proving that you have power of attorney. And again, ladies and gentlemen, it's approved in all courts, whether federal or state or otherwise, and to be received by the state registrar and any clerk of any office or administration. Remember that? Here, let me pull it up again. Can you see that?
Mhm.
This is the Trading with the Enemy Act, 40 Statute at Large 411, Section 7E. No person shall be held liable in any court for or in respect to anything done or omitted in pursuance of any order, rule, or regulation made by the President under the authority of this Act. Keep in mind, this has never been changed. We're talking about payment, conveyances, etc., to the custodian, a full discharge of obligations, no legal liability for acts hereby authorized, execution of release, delivery of notes, etc., by custodian, certificate of authority, legal effect as evidence, mortgages, etc., of enemy tribunal, terminable on notice, demand, etc. So you got notice and demand, right? Contract terminable on notice, disposal of property after default, etc., by notice to custodian. So look, right here. Whenever any such certificate of authority shall be offered to any registrar, clerk, or other recording officer, federal or otherwise, within the United States. Is that a United States venue? They're way outside their jurisdiction, but is it a United States venue? Yes or no? Did they go into private contract with your city, county, municipality to be there, to rent the courthouse? Yes or no?
Yes.
Damn right they did. Do they have the authority and the right to do that? Under the 14th Amendment, they sure the fuck do, don't they? Damn right they do. Any right you have, they have. You have the right to create business. You have the right to take that business and go into cooperative agreement and contract and create joinder and shit with other businesses and create joint business ventures and shit, right? So do they. Okay? Such officer shall record the same in like manner as power of attorney. What document do you think that is? Remember, who issued it?
President.
The president shall issue to every person so appointed a certificate of the appointment and authority of such person, and such certificate shall be received in evidence in all courts within the United States. Whenever any such certificate of authority shall be offered to any registrar, clerk, or other recording officer, federal or otherwise, within the United States, such officer shall record the same in like manner as the power of attorney, and such record or a duly certified copy thereof shall be received in evidence in all courts of the United States or other courts within the United States. So we got courts of the United States and we got courts within the United States. That's your indemnification certificate. It's proof that you are separate and distinguished from the in rem proceedings. It's also evidence that you are the attorney in fact on behalf of the principal, and you understand that the principal is the beneficiary and you're just there to collect, which puts you in the position of making an observation, create a record, and reporting them. And By exercising your fiduciary duty, you're entitled to being paid because every man is worthy of his hire, number one. And number two, they have to pay you for your performance because you're not volunteering. I'll show it to you here in a second, where it says in the transportation code that the employer is the state. So when they're charging you up in Article 1, Section 8, Clause 9 in their special star chamber venues outside the judiciary, because it doesn't exist because they didn't take the Article 6 oath, they are saying what Smoking Baby's been saying for fucking years that people just can't seem to get through their head, that you are gainfully employed by the state. And if you're gainfully employed by the state, don't you think it's time to send them an invoice? Maybe W-4 them? I mean, they've gainfully employed and created a bareboat charter for your Social Security juristic person and estate. An agent, bailee, or attorney must state the authority to file a statement of right or interest on behalf of another. Remember, all actions are dependent upon a right. A right has to exist in order for you to have a cause of action. All right. And if I have a right, who knows what has to occur in order to have a right? In order for a right to exist, what else has to exist?
Standing.
If I have a right, that means somebody else has a fucking duty.
An obligation, a duty.
An obligation. That's how suits are won, by the way. People go in there and put all this emotional jargon and horse shit. If I have a right, that means somebody out there has a duty. If somebody out there doesn't have a duty, then I don't have a fucking right, do I? Okay? So if you're making a claim about a right that you have, then you have to prove that someone else had a duty and an obligation or interest on behalf of another. And a person who asserts a right of possession or any ownership interest must serve an answer within 21 days. Well, isn't that something? That's the same thing as the Federal Rules of Civil Procedure. But they're going to push that court date out 30 days, much like the bank does on your first fucking payment on your car. Huh. And you don't do a statement of interest and notice of interest within the first fucking 21 days. And they say, you know what? You don't even have to make your first payment for 60 days. Why the fuck did they tell you that?
They want you to abandon your interest.
They want you to fucking default.
Yep.
They want you to abandon your shit. You didn't give them a statement of interest, a notice of interest. You didn't secure your rights, titles, and interest. You're the undisclosed third-party investor, the undisclosed third-party beneficiary. You are now going to be in the books as the accommodation party who abandoned their interest and decided to be the surety for the secondary conduit loan because they pledged your asset as collateral to get a loan, and they never gave you the proceeds from it.
And now you become the trustee and they're the beneficiary.
Well, they swap positions with you, but trustees get paid too. The issue with it is you become a trustee who's derelict in their duty. Taxes aren't paid, transaction hasn't been reported properly. You got all kinds of fucking problems, and your securities intermediary fucked you over. They were only took transaction fee, and they took the whole fucking king caboodle.
They get caught with the capital gains.
Not if you don't know what you're doing.
They
They
have to pay
it
it.
all the time. They just turn it into an investment and wash their hands of it, and then they reap the rewards of stipends and dividends. Because remember, so long as it's a commodity and it's in motion, it's a non-taxable event until it stops and lands in the account. It's called unrealized gains. There's no taxes due on unrealized gains.
So do we have to file the notice of interest within 21 days of the original citation, or can we file it at any time?
What it's saying right here, a person who asserts a right of possession or any ownership interest must serve an answer within 21 days after filing the statement of interest or right. Interrogatories. Interrogatories may be served with the complaint in an in rem action without leave of court. Answer to the interrogatories must be served with the answer to the complaint. Note of Advisory Committee on Rules. And what's interesting about this is what do they tell you that the complaint has to have right out the gate, right at the fucking top? It tells you right here. When available, an action in rem may be brought to enforce any maritime lien. They put a lien on your on the Social Security juristic person without your express written consent. That's the evidence that there's a debt, is the fact that they put a lien on it. Okay. B, whenever a statute of the United States provides for a maritime action in rem or a proceeding analogous thereto, except as otherwise provided by law, a party who may proceed in rem may also, or in the alternative, proceed in personam against any person who may be liable. The district attorney is the one who's liable, by the way. So you're going to come in personam, expressing the trust, holding them liable for breach of their fiduciary duty.
Counterclaim.
Mandatory
Cross complaint. Yep.
mandatory counterclaim under Federal Rules of Procedure, Rule 13. This is all going to be done via paper. You're not going to go into a courtroom in front of the peanut gallery and look like Perry Mason. They will shit all over you. They're going to tell you to file your paperwork privately, send it via registered mail, and shut the fuck up. The statutory provisions exempting vessels or other property owned or possessed by or operated by or for the United States from arrest or seizure are not affected by this rule. When a statute so provides, an action against the United States or any instrumentality thereof may proceed on in rem principles. Complaint. In an action in rem, the complaint must be verified. And that's why you have your cause of action. The complaint is not verified. Therefore, the rents, profits, proceeds, futures, and annuities you got from the complaint security hypothecating the credit belong in my constructive possession. I'll take her from here, Scooter. And as soon as you walk out the door, you go from being the attorney in fact to the beneficiary, because you can wear multiple hats. You got to describe with reasonable particularity the property that is the subject of the action. The property that is the subject of the action is the advance they got from the Treasury that the judge, who's the trustee, is holding in abeyance in a discretionary trust, in escrow, in a disputed ownership fund. The only question is, what's there? And how much do they need for making the transaction? Because they're entitled to a transaction fee, right? That's what they're entitled to. See, there's no need to be hostile with the guy sitting on the bench. He's just a fucking banker. It's the DA that's fucking you. And you don't even have to talk to the guy sitting on the bench, because it's going to tell you here in just a second that you're supposed to be negotiating all this with the clerk of the court. Oh, where is it? Right here. Interrogatories, subsection 1. This rule is designed not only to preserve the proceeding in rem as it now exists in admiralty case. See, we went from a maritime lien to an admiralty. And everybody thought I was full of shit when I told them that they flip-flop jurisdictions, and then they'll even dip into equity to help themselves if they don't think you know what you're doing and they can pull game on you. This rule is designated or designed not only to preserve the proceedings in rem as it now exists in admiralty case. See, first they got to get the jointer. First they got to get your consent. Then they can roll it over into an admiralty proceeding under military, okay, and treat you as a private or a militia member. But to preserve the substance of admiralty, Rule 13 through 18, the general reference to the enforcement of any maritime lien is believed to state the existing law and is an improvement over the enumeration in the former admiralty rules, which is repetitious and incomplete. Ergo, there was no reference to general average. The reference to any maritime lien is intended to include liens created by state law, which are enforceable in admiralty. The main concern, and again, this is all in the public, guys, this is all about insurance and assurance administering the bankruptcy. That's what all this is. This is all about mortgages, foreclosures, and um, administering the debt, excise taxes. Because there's only four things in the economy: excise taxes, bonds, securities, and insurance. The main concern of Admiralty Rules 1318 was the question whether certain actions might be brought in rem or also, or in the alternative, in personam. Essentially, therefore, these rules deal with questions of substantive law, for in general, an action in rem may be brought to enforce any maritime lien, and no action in personam may be brought when the substantive law imposes no personal liability. These rules may be summarized as follows: cases in which the plaintiff may proceed in rem and or in personam: suit for seamen's wages, suits for marital men for
Material men.
material men for supplies, repairs, etc., suits for pilotage, suits for collision damages, suits founded on mere maritime hypothenication. What is it to hypothenicate something? Didn't they do an overlay over the land and pretend that everything's under the sea? Are you a seaman? I mean, didn't you go to the party with your dad, get shot out of a cannon, go home with your mom, and 9 months later you came back, and at first you started out as a little fucking swimmer? Didn't they call you a seaman? A little sprout, right? A little squirt, whatever the fuck it was, crotch goblin, so on and so forth. Suits for collision damages, suits found on mere maritime hypothenication, suits for salvage. Is your vessel abandoned? Have you made claim to it? Do you have a financial interest in that vessel, that United States vessel that you have been given under the law of salvage? That's why the district attorney is actually charging up your estate, because it's abandoned. You've never made a formal claim to it. Men make claims, corporations file complaints. You've never made a formal claim to your lost or dead at sea vessel that's out there floating in the sea of commerce. And so, under the laws of salvage, they're attaching themselves to it. The case in which the plaintiff may proceed only in personam: suits for assault and beating. Cases in which the plaintiff may proceed only in rem: suits on bottomry bonds. What's a bottomry bond?
That's a bond on the keel. When the keel is laid, it's put into the creation of the log for that boat.
Like that bond when that doctor smacked me on my ass when I came out of my mother's womb.
Oh, that could
Bond.
be a bottomry bond. Yeah.
I mean that fucking um, commemorative birth certificate they slapped to my ass and my feet. That
And your hands.
card.
Yep. Your handprints and footprints.
They took something of value of mine and didn't give me anything in return, huh? But they
Clip,
invested,
your little penis. Yep.
They invested that, didn't they? Sure they did.
Yeah, the placenta, the umbilical cord, they're selling those now for like $111,000. Placenta and umbilical
Incredible.
cord.
I pissed off a doctor recently with a gal who delivered a baby, and I was like, "Look, let that motherfucker pump
Them
it."
and that goddamn warehouse receipt.
I told him, "God doesn't make a mistake. You let that thing pump until it's done pumping, then cut it." I said, "But by natural law, you would just leave it there until it fell the fuck off. So when these people tell you, who listen to Dr. Fauci and a bunch of dipshits, that it can poison your baby," I said, "Let me tell you the statistics here. God has never made a mistake except for creating man. And to redeem his mistake, he put his only begotten son down here to hear his heir. That's it. That's the only mistake he's ever made." And she looked at me and goes, "Good point. I think I'm going to go with God on this one." And the doctors were pissed. And I said, you want to really piss them off? Tell them you need a bucket. Well, what
Mhm.
for? I said, tell them you're going to take the placenta home.
Yep.
Because
Salvage
they didn't
operation.
inform you that they could cryogenically freeze those stem cells because they were going to get a fuck ton of money for you abandoning it, thinking it's trash. And they intentionally did not tell you about that because you have to schedule that months in advance to get that done if you want to do it. But they intentionally do not tell you that. Their shit breaks at hospitals. It's just a private financial institution. In fact, everything is a financial institution. That's why I know bills of exchange work for acquiring things, because if the IRS accepts bills of exchange, then so does every other motherfucking business. The coverage is complete since the rules omit mention of any case in which the plaintiff may proceed in rem or in personam. The revision proceeds on the principle that it is preferable to make a general statement as to the availability of the remedies. There's that sweet, equitable fucking word. See, they never got rid of equity. They just told everybody that they got rid of equity. But see how they changed from justice to remedy? Remedy is an equitable word. When they're talking about a notice of interest and a statement of interest, that's all trust law, ladies and gentlemen. When they're talking about rights, that's all trust law. And if somebody's got rights, somebody else has got duties. Leaving out conclusions on matters of substantive law, clearly it is not necessary to enumerate the case listed under item 1 above, nor to try to complete the list. The rule estimate, the rule eliminates the provisions of Admiralty Rule 15 that actions for assault and beating may be brought only in personam. A preliminary study fails to disclose any reason for the rule. It is subject to so many exceptions that it is calculated to receive rather than to inform. A seaman may sue in rem when he has been beaten by a fellow member of the crew so viciously as to render the vessel unseaworthy, or where the theory of the action is that a beating by the master is a breach of the obligation under the shipping articles to treat the seaman with proper kindness. And a passenger may sue in rem on the theory that the assault is a breach of the contract of passage. You know, that birth certificate also grants you safe harbor and free passage. The Western state to say that an action for money damages may be brought only in personam seems equivalent to saying that a maritime lien shall not exist, and that in turn seems equivalent to announcing a rule of substantive law rather than a rule of procedure. Dropping the rule will leave it to the courts to determine whether a lien exists as a matter of substantive law. In fact, as a matter of right. That's what they mean by substantive law, as a matter of right. The specific reference to bottomry bonds is omitted because, as a matter of Hornbook substantive law, there is no personal liability on such bonds. I want to show you, where did it go?
Uh, oops.
6, is this section E yet? This is such an interesting section. I highly encourage everybody to read this from tip to stern, because this is, in fact, what they are doing. And you just have to wrap your head around it. A new provision.
Yeah, you know, from a standpoint of a district attorney going forward and not responding to stuff, they could be brought up on charges of treasons as the conduct unbecoming an officer of the court.
And the court is a vessel in dry dock, isn't it?
Yeah,
they
and
have
it's also
the
putting
maritime
it.
admiralty, and they're administering United States vessels and domestic United States trusts, and they're not doing
It's a disruption of commerce
Mm-hmm.
by officers of the court by conduct unbecoming the officer of the court. Wow, that's interesting.
Some proceedings governed by the paragraph, the statement of file, and the person claiming a right of possession or ownership. Hold on, I'm looking for something very specific. It's going to. I haven't looked at this for. Here we are. It's E. I knew it was E. All right. Rule E. This is the important section. Everybody should read this entire section. Again, this was supplemental rules that were implemented, and there's special supplemental rules that were implemented in 1966. Rule E, actions in rem and quasi in rem. What's a child support again? Oh, that's a quasi judicial action, right? It mimics it has a judicial nature, but it's not judicial, it's quasi judicial. All right, actions in rem and quasi in rem general provisions. Applicability, except as otherwise provided, this rule applies to actions in personam with processes of maritime attachment and garnishment, actions in rem, and uh, pit. How do you say that?
Peditory.
Petitory, possessory, and partition action, supplementing Rule B, C, and D. Complaint security. What did they just call a complaint again?
Security.
This is actions in rem and quasi in rem, general provisions. So these generally apply all the time unless there's some type of exception, right? These are general provisions which generally apply. Yes? You follow me?
Firm.
This is fucking huge. A, complaint, which is a security. A security is what? New money. Complaint, in action, right, that you have a vested interest in. Complaint, in action to which this rule is applicable. The complaint shall state the circumstances from which the claim arises. Now, it went from a complaint security to a claim. Claim check, right? What happens? Put a security together, give them a security, they give you a receipt, then you have what is known as a claim check, right? Which the claim arises with such particularity that the defendant or claimant will be able, without moving for a more definite statement, bill of particulars, to commence an investigation of the facts and to frame a responsive pleading.
Holy shit.
Where's that bill of particulars again?
Holy shit. That is so powerful right there, my God.
Hold on, it gets better. I don't even know if I should be sharing this because somebody's not gonna be paying attention and take this and run with it like it's fucking gold, and they're gonna butcher the fuck out of it and get slammed up for 5 years. You got to understand Trading with the Enemy Act. It is the trust indenture. B, secretary for security for costs. Security for costs. Remember, there's transaction fees that are due owing because you're your securities brokers and they're entitled to a transaction fee. Subject to the provisions of Rule 54D and relevant statutes. Why are the statutes important? Because every statute is what?
Bonded.
Bonded. Thank you. So statutes are money.
Securities.
Money. The court
Money.
may, on the filing, may. That's not must. That's not shall. It's not might. They may. Depends on how good you do the Russian nutcracker and put their nuts in a vice and let them know that I will remove my consent from those securities that you just negotiated, and I will leave you holding the fucking ball. You have all the power. Now, I can tell by your chuckle, Thomas, that you understand what the fuck I'm talking about.
Oh, this is
Others,
gold.
they probably don't fucking comprehend a damn thing that I'm saying.
This is gold, baby.
Why Would it be so detrimental to them if I removed my implied consent for them to put a draft or a draw together and make a withdrawal from the Treasury? What's so damning about that, Thomas?
Because you have a superior beneficial interest in the securities because they use you as the grounding agent or the charging agent to go ahead and access that trust to get
Without my
the
express written
written consent and get the draw
which
from the
means
Treasury.
they engaged in criminal activity and they can't benefit from their own wrong because that's called unjust
Enrichment and a
You think
failure
I
to
got
provide
their balls in a vice, Thomas?
failure to provide an honest service. Because you guys come forward with a complaint. Okay, I'm going to accept the complaint and I'm going to go ahead and issue my statement of interest, and I'm going to come back forth in a cross claim, counterclaim to make the claim on the securities. And I'm going to go ahead and make sure you guys get your costs because you need to get paid for your little thing. But I'm the principal, I'm the beneficiary, and I'm the
You know
paramount security interest party holding all of the equity.
when the disinterested third party law firm comes in to represent Bank of America, Wells Fargo, or U.S. Bank to foreclose on you, that they're not a real party in interest. And in fact, they hypothecated your credit into existence in the form of a complaint security and lodged it with the clerk of the court. And you can do the exact same thing with them that are trying to foreclose on you. And you can now foreclose on them because they were without the authorization to put a draft or a draw in from the Treasury.
I'm rubbing my hands like a person about to sell a blind Greek a used rug. Hey, Rocco.
On the filing of the complaint or on the appearance of any defendant on underneath the AO 430 form, does anybody know what position the defendant holds?
The AO 430?
Yes.
Creditor.
Yeah.
Shut the fuck up. Are you serious? So the plaintiff, that would make the plaintiff the defendant.
Correct. It's
Oh,
reversing it.
that would make the plaintiff the debtor making the offer, and they need something from me as the creditor. And
Your signature.
I get to stipulate the terms and conditions of my performance, don't I?
Yeah, well, you call it the AO 45?
AO 430.
Oh, AO 430.
On the filing of the complaint or on the appearance of any defendant. Now, is the defendant you? The defendant can appear by way of paper, right? By way of special appearance, right? See, you've got to disassociate yourself with this fucking entity that people have become quibbling twats about. And they're like, it's mine, it's my precious. It's like the Lord of the Rings, it's mine. Little fucking Smeagol's everywhere, little crotch goblins that are 60-years old running around going, mine, mine, mine. No. Remove yourself from that thing. On the filing of the complaint or on the appearance of any defendant. Well, shit, that's easy enough. 4 corners of the paper. Derrick S. Gonzalez is going to appear by special appearance. Okay? And Derrick S. Gonzalez is going to have a statement of and claim as a right, which means the opposing party is going to have a duty to perform to balance the books, right? Because they're alleging there's a debt, which means they are clearly in constructive possession of what? A credit liability due and owing to me. See, everybody runs around, denies the debt. Oh, I don't know that debt. That debt ain't mine. Okay, that's exactly what they need for you to abandon your shit. And the judge just goes, okay, well, I guess law firm and bar association rats, you are free to run off with the cheese. They're going to deny the debt. They're going to abandon the debt. They got everybody thinking debt's a bad thing. Debt is not a bad thing, or people wouldn't fucking be buying it.
Are they issuing it for value?
On the filing of the complaint or on the appearance of any defendant, claimant, or any other party, or at any later time, require the plaintiff, defendant, or claimant, or other party to give security. You mean they've got to bond their shit? I can compel them to perform and bust out their checkbook. That's why the district attorney has to carry his checkbook in the courtroom because you can compel him to perform, claimant, or other party to give security. Listen to it again. Rule 45D and other relevant statutes, the court may, it's not an absolute, on the filing of the complaint. See, who filed the complaint? The district attorney did. So when you come in there demanding to be indemnified and that they place security on the record, bond, or on the appearance of any defendant, claimant, or any other party, or at any later time, require the plaintiff, defendant, claimant, or other party to give security or additional security. Well, we don't mind doing that because our notes, drafts, bills of exchange, bankers, acceptance, trade acceptance, letters of credit, they're as good as gold. In such sum, remember, what did they say earlier that trade is payment? So if I release the beneficial interest that I may have in that birth certificate, which is a certificate is another word for security, it indemnifies me and it covers all the costs, doesn't it? Security and additional securities. Additional securities? What additional securities? Well, you got a security by order of the president. They issued you a security. In fact, you can go get as many of them as you want from the clerk of the court. From the state registrar. In such sum as the court shall direct to pay all costs and expenses that shall be awarded against the party by any interlocutory order. What's an interlocutory order? It's an order made before final decision, isn't it?
Yeah, it's interlocutory order or interlocutory appeal.
Right, which happens before what?
Before the final ruling.
Before the render, settling, and closing of the account. You guys got to start using banking terms. There's no dismissal. There's no acquittal. We're rendering, settling, and closing. That's what bankers do. We're going to render the account, which means we're going to do the full accounting. We're going to settle the taxes, and we're going to close the matter. We're going to render, settle, and close the account. Order or by the final judgment. Judgment and decree is, again, banking language. Final judgment and decree. Or any appeal by the appellate court process. In admiralty and maritime, proceedings process in rem or of maritime attachment and garnishment may be served only within the district. Issuance and delivery of process in rem or of maritime attachment and garnishment shall be held in abeyance. Now you guys understand why I'm always telling you that they're holding shit in abeyance in a discretionary trust. Because even though you are, on the private side, the beneficiary, okay, if you don't know how to handle your affairs as trustee, does he have to give you the cheese?
No.
Sure the fuck don't. In fact, he can say, in the name of safety and public interest, that fucking dipshit will kill himself if I give him what he's entitled to, and I have a duty to protect the interest of the estate. And
he's
non-compass on the estate, so that's why they throw your ass in jail, to give you a rest, to make sure you're good, because you're the little battery, the Energizer Bunny that keeps their system fucking afloat. And
yeah, you're non-compass mentis. They determine your non-compass mentis.
But guess the most powerful position, at least in my mind, is the beneficiary, and there's only one reason why.
Yep, absolutely.
Because the beneficiary can do something nobody else can do, and that's demand a full accounting and list of the assets the trustee's in possession of. And if he fails to perform, then you become grantee absolute.
You know, Chris Hauser's been talking about this for 3 years now. Yeah. He doesn't want to. You don't want to settle that account, boy. You're holding liability.
Shall be held in abeyance if the plaintiff so requests. The plaintiff is who? The state, the district attorney operating on behalf of the state. But really what he's doing is he's collecting on behalf of the county, which goes into the CAFR, the Comprehensive Annual Financial Report, for funds that they get to use. And of course, he doesn't get it all because he's got to share it with who? Who do the courts belong to?
Judge, the
Clerk.
clerk.
No, no. Who do the courts belong to? The
Oh,
DOD and the Army Corps of fucking
yeah,
Engineers.
engineers.
Because they're in
Indeed.
charge of the fiat, Federal Reserve script, floating rate notes. When you read, and we're going to get to it in a minute, this is going to end up turning into a fucking week-long seminar. This is a bad thing, Cool Fox. I should have never. Boy, we're going to have to really schedule the next one properly. I mean, this is going to be a long motherfucker. I can tell already. So
We could take a hiatus for 4 hours.
no, we can't. We got to go till I drop, and then I'll recharge later. All right. So now you're in full comprehension of the control of the currency, the 73rd Congress. You're fully understanding that this is in rem proceedings. We're under maritime admiralty law. We are under martial law, and the trust indenture is the Trading with the Enemy Act. Everybody come full circle with that so far? Because we got more information, and I'm going to prove it even further that Trading with the Enemy Act actually is the trust indenture through the Libra Code. I'm going to show it to you. It's unfucking deniable. So
Yep. It
I'm going to
makes
show you in
total
the Libra
sense.
Code how the birth certificate is also your indemnification certificate. And didn't the court just ask for indemnification in the form of a security and or additional security?
Yep.
Well, what's an indemnification certificate?
Additional security.
It's an additional fucking security. Damn right it is. And it's backed by what? The full faith and credit of the United States. Who's the full faith and credit of the United States?
Yep.
73rd Congress, First Session, Volume 77, Part 1 says, you are the full faith and credit of the United States.
SF 24, affidavit of surety.
Mm-hmm.
You
You
said
said 9091, but they removed the 91. They still have the 90, but that doesn't mean you can't put it on paper. Go pull up an old 91, which they
And
just
make your own.
use the fucking language right off of it.
you said the certificate, the birth certificate, or that what was that certificate you were just named?
Now do you understand
Identification?
why I'm surrendering my beneficial interest I may have in the certificate to the court, and I'm lodging and ledgering it with the court? It says right here.
He's lodging and ledgering it. The court can now use that on the balance sheet to settle the claims.
I can now use it to prove that I gave, and I can put whatever value I want on, and I can inform the IRS that I ledgered and lodged it with the clerk of the court.
Yep.
And if she refuses it, guess what happens? Trading with the Enemy Act. She's derelict in her duty.
She's committed conduct unbecoming an officer.
Granted complete immunity under any rule, regulation, order, or proclamation issued by order of the president. And if she refuses, I'm 100% indemnified, and she carries the primary active degree of fault. Because why? The national debt can never be questioned.
Yep.
What are they in possession of?
Evidence of debt.
No, an advance from the Treasury, which is the national debt that belongs back to me. It's part of the national debt that belongs back to me. That's what they're in constructive possession of. They're trying to whisk away my entitlement.
Yep.
How does this work for people who haven't?
Are they questioning the national debt?
They can't.
Well, they sure are by failing to perform, aren't they?
Well, yeah. I mean, they're
the fucking intended beneficiary, and they're not fucking cutting me the check and holding my shit in advance. And I've given them a statement of interest, a notice of interest, and I've provided the additional security that also is power of attorney and proves that I'm the intended beneficiary and the rightful entitlement holder. And if I have the right, who has the duty?
They do, and that's an insult. It's an insult of your intelligence, because if you know this stuff this broad and this vast, they're going to be in a world of hurt. Period.
Now,
and it'll come down the road.
Watch this, Thomas. they created a constructive trust. How can we exercise discernment and affirm that?
By performance.
By the lack of their performance.
Oh yeah, by lack of their performance, and also the reporting, ledgering, and lodging.
So I don't have to prove shit. Their actions are already proving it, because absent a victim, there is no crime. So the only thing this can be is a constructive trust predicated on information. And if it be that, and it's in rem, wherein they're doing things under maritime admiralty and attempting to affix a lien to the Social Security juristic person, for which they're going to hold the property in abeyance and bar me from being able to engage in trade and commerce. See, when they put a lien on that Social Security juristic person, that's a violation of Title 15, subsection 1, subpart 1, interference with trade and commerce. That's $100 million fine for the entity that partakes.
Yep.
And $1 million for the one who executed it.
And up to
See
10
why
years
the
in
judges
jail.
jump off their bench and fucking freak the fuck out? Start barking at the fucking district attorney saying, I'll bring sanctions on you, you son of a bitch. You will cut that guy a check.
Well, you know, when he reacts that way, you've really hit a nerve.
Sure, because he can also go to prison because he's bound by Title 26 and he has agreed, operating under the legislative branch, administering the bankruptcy, he has agreed to be compliant with Title 26. And Title 26 is your best friend. That's why Smoking Baby loves Title 26.
I see why he does.
Title 26 secures your fucking interest and guarantees your recoupment.
I have a question.
Yep.
If say I'm actually like suing somebody for attempting to steal money or committing fraud, and I had done an appeal, and the appeals court sent me a bill for money that's owed for that appeal.
Converted into a bill of exchange. They already have gotten an advance from the Treasury for it.
Okay.
They already got the advance.
Yeah, but wait a second. I want to clarify something here. This is a civil matter, correct?
Mm-hmm.
Okay. This is when she's clarifying it's a civil matter.
It doesn't matter. All matters are civil. Title 27 CFR, Code of Federal Regulations, with the Federal Table of Authorities being controlling, not persuasive, clearly tells you that under 27 CFR 7211, all crimes are commercial. That means everything is commercial: rape, sodomy, murder, grand theft auto, and business, because there's assumption under maritime admiralty of a civil compact. That's why all property is vested in state by virtue of government.
So in theory, the state of Oregon has an interest in this, as well as the fact that the appeals
they're entitled
court
to a transaction fee.
Yeah.
My securities intermediaries and glorified pawnbrokers. That's it.
Yep. Okay.
And they're cutting my throat, trying to convince me I'm a debtor and a peasant. And these fucking assholes that call themselves attorneys are running around declaring themselves to be first-class citizens, and we are just merely second-class peasants.
Mm-hmm.
They're parasites.
How's this work
to
for
you
people?
lawyers? For you laymen with burdens grievous to be borne, yet ye yourself not touch them with a fucking finger. And he who seeks to enter, you hinder, yet ye yourself not enter into. It's been that way from the beginning of time. Usury, usufruct, turning your brother into merchandise. It's all a violation of the law. Where do you think they got the idea of human trafficking? I said, well, fuck, we can't traffic humans. What can we do? You know what we could do? We could create persons, and then we could get these feeble-minded fucking individuals through public indoctrination to believe that they are the thing we created, and they will stand as surety and never be the wiser. And if 1 in 1 million should ever figure it out, we have in our arsenal of plausibility.
Plausible deniability.
I have no idea what you're talking about. You sound crazy. In fact, you sound like you need a mental health evaluation and a 3-day vacation for contempt of court. Because you
5150.
batshit crazy.
5150.
And so what I say is, as long as quid pro quo is in order, and we're all going to the funny farm. And the difference between me and you, Judgy Poo, is I don't mind popping a few pills and hanging out with crazy motherfucking people, because crazy is my style. But on you, on the other hand, I don't think are going to enjoy it. And whatever they're about to stick in my veins or throw down my throat, they throw down your veins and your throat first. And then I get to decide whether or not I want to participate. You get all googly eyed and drooling all over, I might not be joining you. All of a sudden they go, well, I think I'm of sane sound mind, and I know I'm of sane sound mind. So who the fuck sounds crazy now? Because you think you're of sane sound mind? You don't know for a fact affirmatively that you're not fucking crazy? That sounds awfully crazy. I don't know if you're competent enough to sit on that bench making statements like that.
What was the question she asked? I heard the question, but I walk away.
My apologies.
What about those who have an apostille on their birth certificates that they've had that?
An apostille is for in-state, and authentication is for
authentication, I guess.
Out. So there is a beneficial use for doing it in-state. But look, it's already backed by the full faith and credit of the United States. That's why you have it.
Well, I was just wondering if for people that are going to do this, it's like, how does that work? Because I haven't. Okay. Anyway.
What do you mean? The alleged courts are nothing more than banks.
Mm-hmm.
They're not even banks anymore.
Yeah.
They're real estate investment firms. Because you know what banks hold? Gold and silver, things of monetary value, precious metals. So there are no more banks. That's why there are no more banks in the United States, because they did away with gold and silver. And so the only thing an actual alleged bank really is a real estate investor and securities intermediary and broker. That's it. You can literally deposit anything in a bank. They're a depository institution.
We are the goal.
I got somebody that I know that takes every last one of her billing statements, and Smoking Baby was the one that pointed this out. So she changed the language she was using, and she's like, oh yeah, I've got a bearer bond here. And they're like, what? Bearer bond? Can we see it? Yep. She didn't separate it from the bearer bond up top and the voucher down below, and endorsed it. And they said, well, what would you like to do with it? Just deposit it. Okay, no problem. I'll need a deposit receipt with that as well, so I can keep it for my records. No problem. And they deposited it in her account.
A special account?
Nope.
Or just any account?
Nope. I've encouraged her to do a W-8 BEN and go get a non-interest bearing account. But they deposited it into her bank account.
Damn.
Because it's a negotiable instrument. And when you read the securities law, a draft or instrument that is drawn and not endorsed, whoever is holding it can treat it as a draft, a bill of exchange, and convert it any way they like. So just think about this. When you don't give a notice of interest and a statement of interest within 21 days, and you do a blank endorsement, and you don't give instructions on how they are to negotiate the instrument that you just gave them that actually has actual cash value at par, okay, then they're able to turn around and convert it into anything they fucking want and negotiate however the fuck they want, because they consider it a gift. You know, somebody comes up and hands you $100 and walks off, and they don't tell you what to do with it or anything like that, and you wait 6 months, 8 months, 9 months, you go ahead and invest it, and they never come back. And
So that 21 days, is that from like the initial citation, or so you can't go in and claim that at any
well,
time
see,
after 21?
you gotta figure it. Look, the citation in and of itself is one aspect of it, but then the district attorney is going to support that citation with what? A complaint security.
Yep.
A complaint.
Something of equal value. So you got to balance the books. Got to have something of equal value. So they underwrite the security because you didn't underwrite the citation on the side of the road. You gave a blank endorsement. Anybody know anything about underwriting here? 101 people? Got any underwriters? I'll tell you, the only reason you guys even exist is because the American people were never taught that they are, in fact, the underwriter of their own issue. You are the original source value issue of all issue. And if you don't do a proper endorsement, the bank can't underwrite it. They have to outsource to a disinterested third party who can underwrite it. And then they go ahead and underwrite it for the benefit of whoever handed it to them, which is the bank. And you become the surety. You become the surety of it because you failed to qualify your endorsement. You abandoned something of value. You created new money in the economy, and they're not going to report the capital gains. And so you become an belligerent combatant of the United States who just raised the national debt.
So you're saying as soon as you get the summons or you get a warrant, you have to be on it right then?
Absolutely. You should be calling them saying, get my check ready. I'll be down there in a few minutes.
Okay,
so
hold on.
So you've waived that right, and you can't come back and get that at any time.
Why? Who says
That's
you
what
can't?
I'm asking you.
Look,
that's what I've been asking. I haven't get
I'll
an
show
answer
you
to
something
yet.
here in a second. Do you know that there's a thing that's called, and every state has them, it's called a lost or abandoned or stolen warrant? And you can fill out the documentation because it's your name and your information. It's your intellectual property on all that shit. And you can get a hold of the Treasury and tell them to reissue the motherfucking check.
Oh.
What are they going to do? Throw you in jail for it? They weren't qualified and authorized. They don't have a delegation of authority. You got a fucking power of attorney. The birth certificate proving you're the attorney, in fact, on behalf of the principal, and you're just handling the fucking affairs of the estate. You are well within your powers to do that.
State powers, trust powers.
Because you are the accredited investor in the United States. It all belongs to you.
You said a lost.
Hold on 1 second, everybody. I'm going to stop this. I want to stop this recording. It's 12:36 a.m. on 11/2/2025. I'm going to start it again, and we are recording. It's 12:36, 11/2 of 2025. Thank you.
Look what they say. In such sum, when you sign something, some certain, what does that mean? Some certain makes it negotiable. Damn right it does. So what are they asking? They're asking for an additional security to back up the complaint security that dipshit created without authorization. Okay. And they're going to want a fee, a transactional fee that they're entitled to, which we don't mind because they're going to be our banker and they're going to negotiate the shit. They fucked up. We're going to issue the additional security, but we need to know something before we issue the additional security, don't we? We need to know what it's going to take to cover the taxes, right? In such sum as the court shall direct. The judge is a banker. He sits on a bench, which is a bank. All right. So we need a full accounting, don't we, under UCC 9-210? What is each one of those penal bonds and penal sums attached to that complaint security valued at? I can't possibly issue a blank security, an additional security with a blank endorsement. That would be highly irresponsible. I don't know if you guys are into trafficking children, trafficking kids, running guns like Eric Holder down to fucking Mexico to the cartels. We have no idea what you fucking people are doing. So I need a full accounting.
So I know security need to be mailed, registered mail. I know that. So
Yeah, you got to
so
do
I
it.
get
You got
I
to
guess
talk to
one.
the clerk of the court, because the clerk of the court, I'm going to show you here in just a second. The clerk of the court is who you negotiate with, and it's right here. It tells you that. To pay all costs. So look, the additional security shall be for a sum certain, making it negotiable, to pay all cost as the court shall direct. So we need to know how much all the cost is so we can satisfy it, right? The cost is the excise tax that needs to be paid for the advance from the complaint security that they got from the complaint security they lodged and ledgered with the clerk of the court, and then they got the advance from the state treasury. And so they need to cover the costs and expenses for the transaction, because we all got to eat, right? That shall be awarded against the party by any interlocutory order or by the final judgment. Everybody's got to bond their claim. Everybody, if you're going to make a claim to that complaint security, you have to put up or shut up.
Yep.
A lot of times, the reason that court cases are dismissed for a claim for which relief cannot be granted is nobody has gone in there and put the proper bond in place. You have the power to create the SF-24, 25, 25A, or use the SF-28 and the SF-29 to bond the case. If you're bringing a claim for $30 million, you better put $30 million in the account, because I got news for you guys. Those corporations that's not where they're getting the credits. That's not where they're getting the fungible funds. They're not getting it from that business. They're getting it directly from your estate. And so when you file a claim and they say you file a claim for which relief cannot be granted because you didn't bond your claim, they can't access the treasury and get your fucking funds.
You're going to show us how to do that?
I'm talking about it.
It's right here in front of us.
Okay. All right.
Yeah.
Think about it. When you create a perfected private administrative process, you've got your certificate of service, your notice of non-response, your certificate of dishonor, notice of default, and you create your order. You have what is known as a foreign judgment, aka a binding contract and agreement, right?
Yep.
They didn't respond. They acquiesced by tacit agreement. This is a maritime admiralty claim for damages, right? Monetary. Let's not call it damages. Let's just call it monetary, because that's what NREM, maritime admiralty, deals with. Assurance and insurance. It deals with contract law, right? Now, you take your private administrative process after being perfected, which is a private foreign judgment. Are you going to go into the public with it? You're going to go to the clerk of the court and try and schedule a court date and have a summons issued? Or do you want the clerk of the court to go back in camera in chambers because those dickheads don't get a second bite at the fucking apple, and to review your private administrative process and to sign off on it and issue the order with enforcement, because that's what they're supposed to do. They're supposed to be there as an enforcement, right? An extension for enforcement, because they don't want us running around like the wild, wild west putting guns to people's head, right? So what's the judge do? He reviews your private administrative process. He sees you got a notice of fault, notice of default, opportunity to cure. He sees you have your certificate of service, certificate of non-response, certificate of service, certificate of non-response, certificate of dishonor, and final order. He goes through to see who is the lien creditor and who is the lien debtor. And that creates what? A perfected security. What is a perfected security? Perfected security interest is?
An obligation.
Money.
Money, an obligation and money.
Now it can be filed in the UCC1 commercial chamber, right? Because the UCC commercial chamber is to do what?
Large financial interest by fiduciaries and beneficiaries.
Be able to grant assignments, right? To be able to transfer, negotiate, and
Mm-hmm.
it gives the
Ledger.
financial institution an ability to be able to create a credit score and not extend federal block grant funds to certain organizations, so on and so forth. You report it also to the Duns and Bradstreet number, or the Duns and Bradstreet, and attach it to their number, because you now have security by way of lien, which is debt, and debt is the new money in the public system. So you have an interest. What can you do with that? Well, you can have a written supplemental hearing and do a writ of garnishment, writ of levy, writ of bodily attachment, all that good jazz if you want. Or after the judge signs off on it and issues a uh, order from the court for the lien debtor to comply with the order within 30 days to make you whole, or a show of cause issue, or a warrant will be issued for a show of cause as to why you have not performed, because that's their job. Their job is to keep the currency moving, because currency in the economy that isn't moving, that is stagnant, the system dies. It's always got to be moving. That's why the banks can't keep shit on hand, and they've always got to be transferring it from U.S. Bank to Bank of America to Wells Fargo to Citizens Bank, back over to Bangkok and fucking Bank of International Settlement. Everything's always just flying around and moving, because if it's not moving, there's a tax liability for wherever it's landed, number one. And number two, if it's not moving, think of it like the ocean. If the ocean's not moving, every fish in it's dead tomorrow. The ocean is always moving. It has a heartbeat. Same thing with currency. The currency is just like electrical current. It's got to be moving. It's got to always be carrying energy. The second that it stops, they'll never get it restarted again. So anyway, the judge issues the order because you have a perfected private foreign judgment, and he issues the order of enforcement for you. You draft the order. Don't let somebody else draft your order, but he may critique your order and say, oh, he didn't put any enforcement in here. Okay, well, the court will see to it that there's enforcement. We're going to give notice to the lien debtor that he has 30 days to satisfy this perfected foreign judgment, or we're going to issue a subpoena or launch a warrant to it, have the marshal come pick him up and bring him to the court for a show of cause hearing as to why he shouldn't be held in contempt of court for disregarding this court's order. You guys have the power. And that's how you enforce your private judgment. See, if you go to the clerk of the court and say, oh, I need to get an action going and all this stuff, well, you're going to go in the public with it? You already got a private foreign judgment. There's no need to go in the public with it. It's already perfected if you follow the federal rules of civil procedure. Give them 21 days and 10 days and 3 days, certificates of service, certificates of non-response. You do everything through a disinterested third party who's above the age of majority, competent to handle their own affairs, and understands how to do the process and complete it. Typically, I would hire a notary to do that. But you could also use a private process server. You want a disinterested third party that can testify to the veracity of the facts. When it was sent out, when they were supposed to respond, they should be your point of contact for the other party to respond to. So it's not he said, she said, you versus them. It's the disinterested third party intermediary that says, hey, on the 21st of November, they were supposed to respond. We waited an additional 3 days grace for mail matter, and we didn't receive an envelope. Therefore, I issued a certificate of non-response. And then you should be prompt and ready for your notice of fault and notice of default. Start out with a friendly correspondence. Here's what's due and owing. This is the trespass. This is my notice of interest, statement of interest, blah, 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 blah. Notice of fault. This is my notice with my intent. To press my claim, nihil deceit, which means their silence is confession and judgment. It's confession and judgment. I'm not going to take you in to court in public and quibble in the theatrical theater of public court. Fuck no. We're having court on the four corners of paper. It is my intent to press my claim, nihil deceit, and your silence is confession and judgment. I don't have to go into the public and let a judge decide who's right, who's wrong. He agreed to the following facts. That's what the caveat's for. You got to have the caveat in there. Your failure to respond is confession and judgment of the following facts as stated herein. And you, us, we agree to these following terms and conditions. You know that if you do this to government officials, they'll never respond to you. If you make a claim to proceeds or anything at the Treasury, they'll never respond to you, and you can default them. The same thing. Who did that? There was a gentleman that did that. He was a banker, and he defaulted. Who did he default? He defaulted a bank. Anyway, he got a huge lump sum out of the deal, and that's exactly the process he did. They never responded, and it wasn't. He did something with Eric Holder. That's what it was. He did something with Eric Holder. So wasn't Eric Holder the Attorney General at one point? I want to say he was the Attorney General at one point. Well, if you know anything about the Solicitor General and the Attorney General and the fact that they hold multiple positions, he also is a physical agent of the Treasury. And so this guy defaulted Eric Holder. Eric Holder never responded back, and he got an obscene amount of credits out of this deal. They ended up arresting him, but his conviction is faulty. They arrested him because Eric Holder got embarrassed because he dropped the fucking ball and was derelict in his duty. So then they tried to equate it to fraud, when the truth of the matter is he gave him notice and opportunity. Their silence was acquiescence. He was a banker, so he knew what he was doing, and he defaulted the United States. And then he turned around and sold the perfected security interest and lien through way of assignment to a foreign entity, which is the same fucking thing they do to you guys anyway. So I don't know how he was guilty of anything that was nefarious when that is the very fucking same thing they do, because they all operate through the Bank of International Settlement, because there is no national bank in the United States. Make sense? I think I lost him. All right.
No,
I'm right
we're
here.
here.
I'm right here. We're here. We're here.
Okay, so anyway, they never did get the funds back, but they put him in prison. And then I had some of his constituents and associates get a hold of me asking me how to, because he left everything in trust for him. So the government couldn't go back and get the proceeds because it was in trust and they couldn't touch it. However, he set it up, and these guys were asking me how they could access it because the trusts were set up for them. And absent of having the trust indenture, there's really nothing you can do. And if he's got trust protector set up, and he's a former banker, so I'm sure he has very intelligent people surrounding him and stuff. Absent of knowing how to get a hold of the trustee, I don't know how you would be able to compel the trustee to perform. And even if you did find the trustee, if the guy was sharp, he would have had a trust protector that would come in and fire the fucking trustee. So about the time you find the trustee, the trust protector would fire him, and you'd have to start all over again trying to find the trustee. Trustee can be a business. It can be when you start studying the 8K and the 10K from the SEC, you'll find out that Bank of America can be the trustee for Wells Fargo. And so your point of contact for agent of process of service and stuff can vary and change, and makes it difficult to a degree to get answers, because if Bank of America is the indentured trustee, Bank of America is an inanimate thing that has no digits, no functioning brain capacity. So how's it going to communicate with you again? Oh, through its agents and agency, right? 3, process. In admiralty and maritime proceedings, process in rem or of maritime attachment and garnishment may be served only within the district. B, issuance and delivery. Don't we want to be delivered from evil? Issuance and delivery of process in rem or of maritime attachment and garnishment shall be held in abeyance if the plaintiff so requests. Of course, the district attorney is going to ask that the trustee hold it in abeyance because he's going to pretend he doesn't know who it belongs to. Oh, we just got these funds here, this property, this general tangible, general intangible property, and the rents, profits, proceeds, features, and annuities from the investment through the CRIS system, and we don't know who it belongs to. Nobody's coming forward to claim their interest in this constructive trust. And under the Uniform Trust Act, under 401 and 402, the only way that a constructive trust can be destroyed is if somebody comes in and expresses the trust. So if it's a constructive trust, I can come in as the grantor, settler, beneficiary, and I can, as a grantor, delegate what the trustee has to do with the funds. You're misappropriating these funds, and as the grantor, I'm telling you, just go ahead and give them back to me. Go ahead and give me the full accounting and give me all the funds back. Can the trustee tell me, no, he's not going to give me the check, the advance that he got from the treasury? He's not going to release it to me? See, I know for a fact that they get a check because the clerk of the court slipped up and told me that one time. And then I drilled her. That's a video that's out there on Facebook of me drilling the clerk of the court, the magistrate. She slipped up and said, there's a check here. The smoking baby said, you dumbass, instead of fucking arguing and quibbling like a twat, why didn't you ask her whose name's on the fucking check? And I was like, yep, they just can't get right. Fucking up. All I wanted to do was argue, and get to the bottom of something like a fucking pet detective. And he's like, all you had to do was ask her whose name's on it, and she would have said it's yours. It's your name. Great. Well, then give me my fucking property and would have been done. But no. You wanted to know the ins and outs and be a proctologist and try and figure out who handed what to who and when it was transferred and how it was transferred. That's none of your fucking business. Those are trade secrets. Those are trade secrets. They're protected under patent and trademark. Even if you subpoena them and get them on the bench to testify how they negotiate instruments, the judge ain't even going to allow them to tell. In fact, he'll allow them to lie and perjure themselves sitting in the witness stand because they're trade secrets and they're patented and trademarked and they're protected information and they don't have to talk about it. Make sense?
That's where the IRS comes in with a 1099-B.
There you go.
So Derrick,
the execution of process, marshals return. See, the marshal actually holds the warrant. The thing that they're holding at the sheriff's office is a copy. And this is why you get to demand the original. If you don't hold the original and they're not handing you the original, you're being shafted. The law states that they have to give you the warrant because the warrant is your indemnification. But unless you're in constructive possession of it, so you can put it into escrow and take control over it, guess what? You're without a pot to piss in. There's a liability out there. It's got your name on it. And you didn't demand it. You abandoned it. And the marshal's going to hold it in escrow. And if you don't claim it, you're going to be held as surety because they made a draw on your behalf and then you abandon it. And now there's a tax liability due and owing. And then you're engaged in not reporting the taxes due and owing. So you're aiding and abetting and assisting tax evaders. You're just as guilty as they are.
But you're demanding this through notice first. And
it's going to tell you right here in just a second.
Okay.
Execution of process. Here's the execution of process. Marshals return. Custody of property. So you got to give a notice of interest, a statement of interest. You got to let them know that you have a right and they have a duty. Custody of property. Procedures for release. That's what we want. We got to get some satisfaction. In order to get a satisfaction, we need a release. We need some delivery. In general, upon issuance and delivery of the process, or in case of summons, remember that when a warrant's issued, they must also issue a summons because both of these instruments serve a purpose in the banking realm. Kind of like when you make a deposit, you also need a deposit slip, right? You need a receipt with process of attachment and garnishment. when it appears that the defendant cannot be found within the district, the marshal or other persons or organizations having a warrant shall forthwith execute the process in accordance with this subdivision, making due and prompt return. B. Tangible property. If tangible property is to be attached or arrested, the marshal or other person or organization having the warrant shall take it into the marshal's possession for safe custody. If the character or situation of, character or the situation of the property is such that the taking of actual possession is impracticable, the marshal or other person executing the process shall affix a copy thereof to the property in a conspicuous place and leave a copy of the complaint and process with the person having possession or the person's agent. Didn't we just discuss a minute ago how the birth certificate makes you the attorney in fact on behalf of the principal? Didn't we just discuss earlier how the Social Security juristic person is the beneficiary? In furtherance, so they're coming to look for you, and they're supposed to be executing the process and leaving that process with the person having possession or the person's agent. Don't they always call you the authorized agent? In furtherance of the marshal's custody of any vessel. So the arrest warrant is for the arrest and seizure of the vessel. The marshal is authorized to make a written request to the collector of customs not to grant clearance to such vessel until notified by the marshal or deputy marshals or by the clerk that the vessel has been released in accordance with the rules. Now, I want you to understand this. Their fictional overlay on the land is the land is flooded. In fact, Smoking Baby, what was it that McDowell said? That the United States has been projected somewhere over the Pacific Ocean? Something like that? Do you remember that?
Remember. I don't. Yeah, no, I don't remember.
That funny, goofy guy that had a great laugh that was always chuckling and fucking up the government by doing all kinds of weird processes. And he says, yeah, their projection is that the United States is actually way out there in the Pacific Ocean. It's just floating out there in the abyss. He's such an energetic guy in his 70s, and he's funnier than shit to listen to. But he really had some shit figured out. Anyway, the Coast Guard, by the way, has a form that is better than the UCC1, and it deals specifically with United States vessels. So when they're talking about making sure that the vessel cannot leave and putting customs on notice, that's what they're talking about. The juristic United States person, estate, and vessel and domestic trust. They can't stop you from leaving. They can stop the entity for which they created, which would bar you from being able to engage in commerce, make it really hard for you to do anything in that realm, right? C, intangible property. So you got general tangible, which means you can physically touch it, cell phone, Pepsi, whatever it is. And then you've got intangible. Intangible is going to be your rights, titles, interest, dividends, derivatives, debentures, hediments, general tangibles, general intangibles, chattels, security, trust residuals, rents, profits, proceeds, futures, and annuities. Okay? That's what your general intangibles are. And you have to lay claim to them. Notice of interest, statement of interest. C, intangible property. If intangible property is to be attached or arrested, the marshal or other persons or organizations having the warrant shall execute the process by leaving with the garnishee or other obligor a copy of the complaint and process requiring the garnishee or other obligor to answer as provided in Rule B3, A, and C6 of the or the marshal may accept for payment into the registry. Remember, when you perfect your security interest, it has to be recorded at the federal registry, right? Payment into the registry. Why does it have to be recorded at the federal registry? Because under the federal preemption, they deal with everything pertaining to the bankruptcy, and they deal with everything pertaining to maritime admiralty, because in Article 1, Section 8, from Clause 1 to, what is it, Clause 17, they deal with everything that deals with the import, export out of the United States. They deal with everything administering bankruptcies. And under Article 6, all the treaties and debts and all that stuff that were in existence before the adoption of the Constitution are as valid as after the adoption of the Constitution. So that's why it all goes into the Federal Registry. Into the registry of the court, the amount owed to the extent of the amount claimed by the plaintiff with interest and cost. In the event the garnishee or other obligor shall not be required to answer unless alias process, did I say that right? ALIAS, alias process shall be served. D, directions with respect to property in custody. The marshal or other persons or organizations having the warrant may at any time apply to the court for directions with respect to the property that has been attached or arrested, and shall give notice of such application to any or all of the parties as the court may direct. Expenses of seizing and keeping property. Deposit. Wait a minute. The court, you're making a deposit? Expenses of seizing and keeping property. Deposit. These rules do not alter the provisions of Title 28, United States Code 1921, as amended, relative to the expenses of seizing and keeping property attached or arrested, and to the requirement of deposits to cover such expenses. Procedures for release from arrest or attachment. Whenever property is arrested or attached, any person claiming an interest in it shall be entitled to a prompt hearing at which the plaintiff shall be required to show why the arrest or attachment should not be vacated or other relief granted consistent with these rules. This subdivision shall have no application to suits for seamen's wages when process is issued upon a certification of sufficient cause filed pursuant to Title 46, United States Code 603 and 604, or to actions by the United States for forfeitures for violations of any state, for any statutes of the United States. 5, release of property. Special bond. There's your birth certificate right there. Special bond. Whenever process of maritime attachment and garnishment or process in rem is issued, the execution of such process shall be stayed, or the property released on the giving of security to be approved by the court or clerk, or by stipulation of the parties. See, Smoking Baby's the one that taught me this. Derrick, you don't need them to fucking agree with you. You'd prefer them to be quiet and stipulate, because the IRS don't give a fuck if they admit to anything. They only give a shit that the party failed to respond and thereby stipulated to the accounting, or by stipulation of the parties, conditioned to answer the judgment of the court or any appellate court. The parties may stipulate to the amount and nature of such securities. Guess what? If I ask for a full accounting and you motherfuckers aren't going to give me a full accounting, then I'm going to make an assessment of $10 billion. And if you don't respond with the proper accounting, then you acquiesce and agree to my accounting. How does that fucking grab you? How you like them apples? In the event of the inability or refusal of the parties to stipulate, the court shall fix the principal sum of the bond or stipulation at an amount sufficient to cover the amount of the plaintiff's claim fairly stated with accrued interest and cost, but the principal sum shall in no event exceed twice the amount of the plaintiff's claim, or two, the value of the property on due appraisement, whichever is smaller. The bond or the stipulation shall be conditioned for the payment of the principal sum and interest thereon at 6% per annum. They just told you how to settle your cases. They just told you how to do it right here. Feel like playing Pink Floyd, Money. B, general bond. So we got a special bond, and now we're going to go to a general bond. The owner of any vessel may file a general bond or stipulation. Stipulation is what? An agreement, right? With sufficient surety to be approved by the court, conditioned to answer the judgment of such court in all or any actions that may be brought thereafter in such court in which the vessel is attached or arrested. See, that warrant for the arrest, that's for the vessel. They only have control over that which they created in the United States vessels, which they're attaching themselves to. Thereupon the execution of all such processes against such vessel shall be stayed, so long as the amount secured by such bond or stipulation is at least double the aggregate amount claimed by plaintiffs in all actions begun and pending in which such vessels has been attached or arrested. Judgments and remedies may be had on such bonds or stipulations as if a special bond or stipulation had been filed in each of such actions. The district court may make necessary orders to carry this rule into effect, particularly as to the giving of proper notice of any action against or attachment of a vessel for which a stipulation had been filed in each of such actions. The district court may make necessary orders to carry out. Motherfucker, skip the line there. I was playing tricks on me. General bonds. Let's see. Just skip the line. No. Vessel for which a general bond has been filed. Such bond or stipulation shall be endorsed with an I, by the clerk, okay, with a minute of the action wherein process is so stayed. Further security may be required by the court at any time. If a special bond or stipulation is given in particular cases, the liability is what? An obligation on general bond or stipulation shall cease as to that case. C, release by consent or stipulation. Order of court or clerk cost. Any vessel, cargo, or other property in the custody of the marshal or other person or organization having the warrant may be released forthwith upon the marshal's acceptance and approval of a stipulation, bond, or other security signed by the party on whose behalf the property is detained, or the party's attorney, and expressly authorizing such release, if all costs and charges of the court and its officers shall have first been paid. See, I told you they need their transaction fee. They're entitled to a transaction fee. They went to the treasury for you. They charged up the estate. They have the funds. They want their transaction fee. You have to pay the court first before they're going to release the advance to you. And the proof is in the pudding, because they acquired a debt. You're going to pay their debt for them because you're the creditor. And because you pay their debt for them, now you're going to come in and step in the role of creditor, and you're going to assume all the rights, titles, and interests that the creditor would have had. Otherwise, no property in the custody of the marshal, other person, or organizations having the warrant or other officer of the court shall be released without an order of the court, but such order may be entered as of course by the clerk upon the giving of approved security. Once you give the approved security, the clerk of the court has the power, doesn't need to talk to the judge, doesn't need to talk to the district attorney. The clerk of the court has the power as provided by law, and these rules were upon the dismissal or discontinuance of the action, but the marshal or other person or organization having the warrant shall not deliver any property so released until the cost and charges of the officers of the court shall first have been paid. They're wanting paid their transaction fee. They're your securities intermediary. The trustee's entitled to be paid. They got to eat too. They want paid. D, possessory petitory and partition actions. The foregoing provisions of this subdivision 5 do not apply to petitory, possessory, and partition actions. In such cases, the property arrested shall be released only by order of the court on such term and condition and on the giving of such security as the court may require. Reduction or impairment of security. Whenever security is taken, the court may, on motion and hearing for good cause shown, reduce the amount of security given. And if the security shall be or become insufficient, new or additional securities may be required on motion and hearing. Security on counterclaim. Right there. When a person who has given security for damages in the original action asserts a counterclaim that arises from the transaction or occurrence that is the subject of the original action, a plaintiff for whose benefit the security has been given must, not might, not shall, this is a fact, must give security. Did you catch that? When a person who has given security for damages in the original action asserts a counterclaim that arises from the transaction or occurrence that is the subject of the original action, a plaintiff for whose benefit the security has been given must give security for damages demanded in the counterclaim unless the court, for cause shown, directs otherwise. Proceedings on the original claim must, that's mandatory, be stayed until this security is given, unless the court directs otherwise. The plaintiff is required to give security under Rule E7A when the United States or its corporate instrumentalities, counterclaims, and would have been required to give security to respond in damages if a private party but is relieved by law from giving security. Restricted appearance, an appearance to defend against an admiralty and maritime claim with respect to which there has issued process in rem or process of attachment and garnishment may be expressly restricted to the defense of such claim, and in the event in that event is not an appearance for the purpose of any other claim with respect to which such process is not available or has not been served. Disposition of property, sale, interlocutory sale, delivery. Okay, so if they're going to assign and sell the securities through the CRIS system, right? Interlocutory sales delivery on application of a party, the marshal or other person having custody of the property, the court may order all or part of the property sold. This tells you right here that the whole damn thing is a financial endeavor. No victim, no crime. This is a financial endeavor. They negotiated unregistered securities, created value out of nothing and pledged you as surety for it. They're looking for you to sign off on it. With the sales proceeds, or as much of them as will satisfy the judgment, paid into court to await further orders of the court. If A, the attached or arrested property is perishable or liable to deterioration, decay, or injury by being detained in custody pending the action. B, the expense of keeping the property is excessive or disproportionate. Or C, there is an unreasonable delay in securing release of the property. 2, in the circumstances described in Rule E9AI, the court, on motion by the defendant or a person filing a statement of interest or right under Rule C6, may order that the property, rather than being sold, be delivered to the movant upon giving security under these rules. B, sales proceeds. All sales of property shall be made by the marshal or a deputy marshal or by other persons or organizations having the warrant or by any other persons assigned by the court where the marshal or other persons or organizations having the warrant is a party in interest. And the proceeds for sale shall be forthwith paid into the registry of the court to be disposed of according to the law. Preservation of property. When the owner or another person remains in possession of the property attached or arrested under the provisions of Rule E4B, the permit execution of process without taking actual possession, the court, on the party's motion or on its own, may enter any order necessary to preserve the property and to prevent its removal. Notes of the advisory committee. Anyway, I would encourage everybody to go read this section right here. If you didn't understand what was being laid down there, this is Rule E under the special rules of Maritime Admiralty, and it's actually special supplemental rules of Maritime Admiralty of 1966. And this absolutely applies to everything that they're doing. Because as I pointed out to you earlier, they are not operating in the judiciary. They are operating in Article 1, Section 8, Clause 9, special maritime admiralty venues that are outside the judiciary. Says in here, how to negotiate with the clerk of the court. Where's that at? Six extension principle 50. The government when sued under the similar public rights. 44. Make available the type of post a seizure hearing. And so when they're taking your guys' cars, automobiles, persons, houses, papers, and effects, you should always demand a post-seizure hearing and then show a cause why there was no pre-seizure hearing and why you've been deprived of your right to life, liberty, pursuit of happiness, enjoyment of property under the Fourth Amendment and the Declaration of Independence. Counter security to protect the defendant from the improper seizure. The foregoing requirements for the prior court review or the proof of the extingent circumstances does not apply in the actions of the United States. Anyway, so we walk through the Trading with the Enemy Act. We walk through Title 28, Special Supplemental Rules, Section E, Special Supplemental Rules for Maritime Admiralty Claims and Asset Forfeiture Actions, which is what that whole rigmarole is doing. They're lodging a complaint security. And so now let's get back to this here. I believe we left off on second here. See if it'll go back. Oh, what did I do? I fucked that up, didn't I? Sure did. Second. You guys all down for the count, are you?
I'm awake.
Still riding shotgun.
I remembered Richard McDonald. Is that the guy that was talking about the
I
Marine?
believe the little guy standing at the podium.
Yeah, he's really
Talking
funny.
about how the United States is somewhere in the Pacific Ocean.
I
So
posted it in the room.
Oh,
Posted the video in the room in the chat.
oh, cool.
McDowell,
Funny as all.
McDowell.
Yeah.
All right. Now we're back to 41. So the Army, all that stuff. All this coincides with obviously the District of Columbia, 10 square mile area, and what they have jurisdiction over. So next slide. Article 1, Section 8, Clause 16. They are in charge of organizing the militia, right? The Congress for the United States is in charge of the organized militia. The organized militia is, in fact, your police department, sheriff's department, state troopers, National Guard, all that good shit. Okay. To provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States. Again, in order for their rules and regulations to apply to you, you have to be employed or fill office or volunteer to be subject to the United States, ladies and gentlemen. Okay, we're going back to driving without a license. You don't need a license because you're not within their territory and you're not within their jurisdiction. Reserving to the states, respectively, the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress. Clause 17, Enclaves Clause, to exercise exclusive legislation in all cases whatsoever over such districts. See, they have legislative control over districts not exceeding 10 miles square, as may by sessions of particular states and the acceptance of Congress become the seat of government of the United States. And so and to exercise like authority over all places purchased by the consent of the legislator of the state in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. And clause 18, necessary and proper clause, to make all law which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or office thereof. The reason it says any department or officer thereof is because they're only in the legislative and executive branch. We're supposed to be a limited government for a short duration of time that they have converted into a permanent fixture, and they're operating under the executive branch, and so it's department and officers thereof, which means they are all administrative. They're all administrative. You have to contract with these people for them to have a hinkling of jurisdiction. And so when you comprehend this, you will quickly be able to exercise discernment and realize that if they didn't provide full disclosure and give you all the facts, and they hit a bunch of blind adhesion contracts in there that are loaded with a litany of legal consequences, guess what? If you're the only one engaged in the contract, you're the only real party in interest, you can do a revocation of election. All right, so you're going to do a revocation of election. You're going to terminate your contractual nexus with them. All right. You don't have to if you don't want to. I'm going to tell you right now that if you're doing these things, you should be extraordinarily learned and confident in yourself. You may or may not be tested, but if you put the right agencies on notice, they'll leave you the fuck alone because you're going to hit them with a notice of liability. You're going to tell them that they're maintaining a record in there that's causing you harm, damage, loss, and hardship, and that if they don't correct that record that they're maintaining in error and they continue to disseminate your private intellectual property without your express written consent, they bury the primary active degree of fault amongst joint tortfeasors for the harm, damage, and loss that you are being caused. And that now that you've given them notice, their failure to correct that record is a wanton disregard for the law. And now they are knowingly, willingly, and intentionally causing you harm, damage, loss, and hardship. All right. That's where the notice and the caveat and the notice of liability come in. When you put that together in a nice package, now if they persist on, you have a grounds for a claim for which relief can be granted. You gave them notice, opportunity. They failed to correct the record. They maintained the record. It continued to cause you harm, damage, and loss after you fully availed them that the record had been ascertained by false and misleading, deceptive trade practices, by either concealment of material facts, false conveyance of material facts, or misrepresentation of material facts. And now that you have fully availed yourself of all the blind adhesion contracts and the impending doom and danger and harm that it's caused you, the contract is void in amnesia. Okay, they don't have a ground to stand on and say, oh, no, 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 you're stuck with us. Remember, they told you that the law required you to have a driver's license. But if the law required you to have a driver's license, then they would have had to give it to you. But there is not a legitimate government. They are in business. And that's why they are offering you a service or a product. Same thing with the bank. The bank offers you a mortgage. There's no law that requires you to obtain a mortgage, ladies and gentlemen. That's a product and a service they offer you. And if you accept it, then yeah. Anyway, instead of demanding your clear marketable title, if you accept their product known as a mortgage, which is a service and product they offer you for a fee, where you waive all your interest and payments and future gratuity and everything. That's the cost of doing business with them. First Amendment: Congress shall make no law respecting an establishment of religion. The reason we're going to go through the amendments is because you guys need to understand these are what you're going to stand upon. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for the redress of grievance. This right here, the petition the government for redress of grievance. Now, the alleged judiciary, which you now know not taking the Article 6 oath, meaning that they are a private ad hoc for-profit organization masquerading around as government, is going to tell you that you can't go to the court to petition the government for a redress of grievance. And this is why they're charging you an arm and a leg in administrative procedures, because they're taking it under maritime admiralty under the presumption of contract. But in reality, you're going to change the jurisdiction, and you're going to come in there because you have a right to the courts. Corporations do not have rights to the courts. It's a privilege, and because they have that privilege and immunity under the 14th Amendment to utilize the court, it comes at a fee, because for corporations, utilizing the court isn't a right, it's a privilege, and they have to pay for that privilege. Okay. Just like you have to pay for the privilege to drive, they have to pay for the privilege to air their grievances in we the people's courts. Okay. So when they're trying to charge you for something along those lines, pull out the Constitution. It says justice shall be had freely, without delay, without denial. And then, of course, I like to quote the maximum: justice denied is justice delayed, or justice delayed is justice denied. By telling me that I have to give them some benign fee or whatever to press my claim is absolute asinine bullshit. But with what we just read, it's a difference on what you're going for. If you're going for injunctive relief and estoppel, maybe a compelled performance, and you're not going after damages, if you're going after damages, this is going to be a maritime admiralty claim, right? Typically in equity, you're not going to be looking at any financial wherewithal. In maritime admiralty, however, if you're going for financial wherewithal for just compensation, you may want to assess that a little bit, knowing what you know now, and issue the SF-28, the SF-29, SF-30 to go ahead and properly bond the case, right? So the other thing is we make all our claims underneath the freedom of religion, is what this gentleman from Washington, D.C., who's a very good attorney, and he said, and I quote, that anytime you're dealing with the courts, always, 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 always state your affirmative defense as freedom of religion. Okay. And even if you lose through the myriad of courts, by the time you get to the Supreme Court, they will always reverse it in your favor and in your decision, so long as there's not an aggrieved injured party. If you're making your claim that the reason you were doing what you were doing, that they found to be benign, obscene, or some statute violation, when all else fails, if you make it a right of your freedom of religion, okay, so long as there's not an injured party, the Supreme Court will overrule it if they ruled against you. Second Amendment.
Oh, that's all. Hold on one second, please. Hold on one second. It's 11:34 a.m. on 11/2/2025. I'm stopping the video, or stopping the recording. And I'm starting the recording at 11:35 a.m. on 11/2/2025. Thank you very much.
The interesting thing is why the First Amendment carries so much weight is because, in fact, what they have done is religion. They religioned themselves. They went from a government of the people, for the people, by the people, into creating a corporation that masquerades around and looks like a government, but is not a government, but in fact a business. And so that's their religion as well. They religioned themselves. So that's why they never go against religion.
They went from the Roman Legion to the Roman religion, right? Roman Catholic religion, right? Religion.
It took me a while to figure out what that attorney was talking about, but after studying for a while, I was like, oh my gosh, that's why they won't. As long as you stick to it's a religious thing, they will never. They might go against you in the lower court, but when you get to the Supreme Court, they'll always overrule it, so long as there's not an aggrieved injured party. And the reason for that is because that's what they're doing. They religion things. And so it's a quid pro quo. It was just a nice little tip this guy told me, who was an attorney, that gave me 10 minutes of his time that rightfully didn't have to. And I thought it was pretty cool. And that was the one thing he said: I've lost one case in my career. And I go, oh, yeah. And he goes, from that moment on, when the tribunal of judges sat there and they said, if they would have made the argument predicated on religion, we would be more inclined to agree with you. But the defendant did not make that argument. In fact, the defendant made the arguments under like the 14th and the 14th Amendment, and therefore, we agree with the trial court. And so when they made that statement that if the defendant would have predicated his defense on freedom of religion, they would have overturned it. He figured it out right there. Well, I'm only going to take on cases where they're talking about religion, and I'll prevail when it gets up to the Supreme Court. So pretty interesting. So long as there's not an aggrieved injured party, you'll prevail. And in most instances, when your estate's being charged up, there's no injured party. So Second Amendment, a well-regulated militia. Well, there it is again. Being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Third Amendment, no soldier shall in time of peace be quartered in any house, not resident, not real estate, house, without the consent of the owner. See, when we came over here, or they came over here, um, the whole thing was to get away from being under the subject, being subject to the king in a feudalism, in a feudal system where you owned nothing and you only got to stay on the property that you were on by the grace of the king and how he felt. Well, they wanted to own property in allodium. And so when they came over here, they understood that in order to do that, they couldn't be um, borrowing from bankers because then the bankers would buy them out of their properties and eventually there would be interest and all this other stuff. So usury was heavily frowned upon when they were coming over here because they wanted allodial, meaning they owned it outright. They were the kings without subject. In order to be a king, in order to be elector, you have to have land. All right. Without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Well, the law is pretty simple. And the four organic laws, it tells you that you have the right to be securing your houses, papers, persons, and effects. It also tells you that you have the right to life, liberty, pursuit of happiness, and enjoyment of property. And those are my claims. I've been caused harm, damage, loss, and a trespass and an injury in fact by John Michael Doe, who at times acts as the city mayor, who caused harm, damage, loss, and a hardship by way of trespass on my right to life, liberty, pursuit of happiness, and enjoyment of property. All right. And then I'm going to articulate as to how they did that. You know, they took something that belonged to me without just compensation. That's my claim. That's your claim in a nutshell. It's like a fucking paragraph long. It's super fucking simple. They took my precious value time commodity on the side of the road by declaring an emergency when there was none and stifling my unalienable right to egress, regress, and ingress as I see fit. So that's why I'm suing for $50,000. See how simple your claim can be? Make your claims fucking simple, people. Don't talk about how he pulled his gun, threatened to pepper spray me and taser me, and I was nervous as a whore in church, and oh, my heart was shaking. None of that shit matters. If you want to try and enforce a claim perpetuated on the fact of mental anguish, then you have to go to the doctor. You got to go see a head shrink and a psychologist and all this other crazy cracker shit. Make your claim simple and get paid. They violated the law. You can prove they had intent to violate the law because they have an oath of office that says they will not encroach upon your life, liberty, pursuit of happiness, enjoyment of property, or deprive you of your right to your papers, houses, and effects without just compensation. And they do it all the time. There was no post-seizure hearing. There was no pre-seizure hearing. There's really nothing more to say, nothing more to do, and enforce your claim. Make sense? Third Amendment. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Again, this is very, very valid point here. Your private household consumer goods also requires a warrant. You want to know why they ask you permission to search your car? Because your car, your private household consumer goods, your automobile is considered an extension of your home and thereby requires a warrant unless you grant your consent. Okay? So that would be considered quartering soldiers. At no time are they allowed in your house. When you open the door because they're knocking on the door and they put their foot in the door, ladies and gentlemen, they will tell you legally that they're allowed to do that. Ladies and gentlemen, that is an invasion of privacy. That is disturbing your right to life, liberty, pursuit of happiness, and the enjoyment of property. You've got somebody you don't know with a Batman utility belt working on behalf of an organization that you're not familiar with that is a private mercenary thug for hire for the United States, and they're professional paranoids. You need to give them notice of liability to leave you alone. Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Shall not be violated, period. And no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Some of these alleged warrants that I've seen lately, they are so vague and so broad, it's not even funny. A warrant must be specific because the law is specific. And again, if they issue a warrant to attach themselves to the person, right? The driver's license suffices as a person. The birth certificate is the person. It's not you, the man or woman. It is the thing in rem, because remember, they're not operating judicially. They're operating administratively, which means that they're denying you due process of law. This is exactly why when you go to a court, you demand under the Sixth Amendment to know the nature and cause, and you demand the verified criminal complaint sworn to, independently bonded, and you also demand right away under the Seventh Amendment a trial by way of jury. Right then and there. If nothing else you're gathering from this, if you make those demands on appeal, you will win. They will reverse the piss poor decision at the lower court. It's a simple win. Not some of the time, not part of the time, every time, because at the appellate division, it will be overturned. Denial of due process. Once they deny you due process, they lost jurisdiction. They cannot recover it. Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime, unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia. See, when they're accosting you against your will, they're presuming and assuming that you're part of the militia. They're presuming and assuming you're a United States citizen. They're presuming and assuming that they have authority, that they have in personam subject matter and territorial jurisdiction. And they're going to drag you into an Article 1, Section 8, Clause 9 venue, and they are presuming and assuming that you are subject to that jurisdiction in that venue under the DOD administering a bankruptcy. When in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. They violate that all the time. That's what I'm telling you. If they took your property, if they took interest in your stuff, if they took you to jail, remember, part of your property is your general tangibles and general intangibles. Okay, you got the things you can touch, but there's also the intangible rights. Okay, and so there are a multitude of cases out there that state that to suffer a harm, damage, and loss does not require a physical injury, does not require lacerations, bruises, so on and so forth. That you can physically engage in a false arrest and false imprisonment, and you do not have to physically put somebody in four walls and close a door or behind bars for them to be physically detained and incarcerated against their will, absent due process of law. You guys realize that when they take you and arrest you on traffic infractions, which is not a violation of the law, they actually breach your peace. They're engaged in human trafficking, trafficking of persons. They engage in identity theft. They violate the FCC when they run your private intellectual property, known as your name, date of birth, social security number, all that stuff, through the airwaves, through the frequencies, okay, without your express written consent, okay? They declare an emergency where there is none. That is a felony. It's not a felony, excuse me. That is it is a felony. It's a felony. It's also an arrestable offense. They disturbed your peace and declared an emergency when there was none. They carry liability for that. An average officer creates about 25 felonies in the process of pulling you over. All right. And most people don't realize that. And the only reason they're doing it is because you're coloring them with authority and they've been improperly trained. So when understanding this, if they have reasonable articulable suspicion supported by a reasonable articulable fact, instead of pulling you over for some benign city ordinance rule or regulation, what they should be doing is filling out a sworn affidavit as to what they witnessed, what they saw, and they should be taking it to the district attorney and the judge and scheduling a probable cause hearing so he can articulate a reasonable articulable fact supported by his reasonable articulable suspicion for the judge to then issue a warrant or a summons to appear for the alleged violation. Earlier, there was a gentleman on with us that said that you are entitled to an administrative hearing before they try to do anything in the court system. Well, as you know now, none of them took the Article 6 oath, so there is no judiciary. Therefore, everything is an administrative hearing. So that means these alleged judges masquerading around as judges are all in a position to be disqualified under Title 28, 455. Okay? They got a verified conflict of interest financially. They're all getting kickbacks and paid from these corporations who they're being hired by, and their retirement is bolstered and supported by. Okay. They're not government, they're just a business, and they go into cooperative agreement with all these other businesses for enforcement. Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. If you want to make another grandioso denial of due process of law, nowhere in there does it say you have a right to a bar member. It says,
Did it say a professional counsel?
yeah, it says counsel, somebody learned in law that you trust.
Just the simple word counsel, right?
Yeah.
So that means you can make a choice for a counsel, whatever counsel you choose to make.
Yeah,
It doesn't have to be. It doesn't have to be professional.
It was always fun when the judge would say, I'm going to appoint you. I'm going to appoint you an attorney. And you go, oh, so you're going to bear the primary active degree of fault if he causes me harm, damage, and loss?
Yeah.
He said, what'd you say? I said, well, if you're going to appoint me counsel, he's going to be good, right? He's like, well, I don't know. I go, well, then why would I allow you to appoint me counsel if you don't know if he's going to be good or not? And if you can't guarantee me the win, why would I be dumb enough to allow you, who I don't know, who's supposed to be non-biased, disinterested third party, set the rule on the matter and a fact finder, why would I let you pick my counsel? And then if I lose, why wouldn't I hold you accountable for it? Okay, well, you have 30 days to find counsel. I was like, okay, I'll go find counsel. Well, he didn't like my counsel because my counsel wasn't licensed by his ilk, wasn't part of his society. See, my counsel, I licensed, and he really didn't like it because James Bethel is a sharp, fast, smart-ass motherfucker, and they absolutely cannot stand him. Not that he's wrong, he's just an asshole who likes to argue. He doesn't want to win. Hell, he'll even argue their point just to piss him off. It's quite entertaining.
Real quick here. The Judiciary Act of 1789, Section 35.
Yeah, you're talking about the blending of the
Parties may plead and manage their own causes as they deem necessary, or with the assistance of counsel or an attorney. So that's
which,
never.
which constitutional provision or natural law grant them that authority?
That's a great question, but it's under the Judiciary Act of 1789, Section 35.
Can you
Which-
Yeah,
post
so that's a legislative principle. So if you
Yeah.
check while he's reading, you're gonna see the Amendment 9. In Amendment 9, a lot of people, their rights that's not delegated. That's not a delegated power in the Constitution. So therefore, they didn't have no right, interest, or title to do any such thing.
Yep. Yep.
Could you post that, Thomas?
Give me just a moment. I'll be right back with you. I gotta.
Yeah.
So what
I'll
I'm getting at
probably.
is, go ahead, go ahead. If Thomas, if you was gonna say something, continue. Go ahead.
No, go ahead. Go ahead. Go ahead.
So what I'm getting is, they would like to tell you that they're going to make you appointed. They're going to appoint you a council, or the state have to appoint a council. Now, in the principle of choice and the principle of law and agency, in order for you to be able to appoint me attorney, I would have to delegate that power to you, or I would have to make a choice. I have the right to make a choice, and that's an inalienable right. Being that it's an inalienable right, you can't abrogate it or shorten it or limit it in any way or form. Now, to force an incompetent person to be an attorney unto me, you then make a reservation of right immediately and use the UCC 3-415 that any such attorney sign any form of documentation, he will be liable for. He's the endorser of that documentation. You're not going to take responsibility. And
By
if he's going to
accommodation.
give you
Yep.
somebody, he have to indemnify you. So he'd have to use that indemnity bond or some form of bond to indemnify you if he commit any harm, injury, or loss to you.
Exactly. And also, Corpus Juris Secundum Volume 7, Section 4 clearly states that when you do hire an attorney, you're basically committing or confessing to the court you're non compos mentis. You're an infant, and the first obligation of the attorney is to the court. The second to his pocketbook and how many billable hours, and the third is to the ward of the court. So you were a ward of the state by the abandonment. Now you become a ward of the court, and you're expecting to get remedy. So, yeah, good luck
Absolutely
with that.
correct. Absolutely correct. And I always go in as assistance of counsel, and I'm protected under the Sixth Amendment, and I've done it over 100 times.
Yeah.
Son of a bitch, the whole Two Live crew's still alive. They're still with me. Look at you guys go. All right, Seventh Amendment. The reason that you're going to demand the Seventh Amendment, and I learned this from about an 80-year-old guy, and this is what he does. He demands a trial by way of jury, knowing damn good and well they're never going to give him a trial by way of jury. Then what he does is he goes to the House Committee Review Board, to the clerk for the legislator, and he files for impeachment of the officers in the state and federally. And the reason that he does that is because he got tired of winning sometimes and losing others. He could do the same process over and over and over, and he'd win, 5 of 7 cases, and it just didn't make any sense. So it's all predicated on how people feel and whether or not that they think you're going to be able to hold them accountable, because the system has gotten pretty corrupt at this point. So what he suggests is you demand to know the nature and cause. You demand a Seventh Amendment trial by way of jury. They're going to give you a jury trial. And the second that they move to do that, he just simply sends them notice in the mail that he's not coming back and that he's now going to move for impeachment. And I believe that is under Article 7. If my recollection serves me correctly, it goes before the House of Representatives. It has to be served upon the clerk. I'll have to look it all back up again. Anyway, that's how he prevails. And he simply gives them notice that he's not coming back, and that if they press the issue or seek to cause him harm, damage, loss, absent a victim, absent a crime, without verified pleadings, that he will go ahead and move forward with a petition for impeachment. And he says that always seems to stave them off. And then he gives notice to the FBI and the Judicial Conduct Review Board and Ethics Board for their blatant violations of the law. And he says that typically does it. What ends up happening is the representatives call down to the court and say, back off. Because at the end of the day, with what I've just expressed to you, if you guys are still with me, is you now understand that Congress carries the primary active degree of fault for causing you harm, damage, loss, and hardship. They have created this whole fucking mess, and they're all liable. And you can't sue the state without its consent, but there's absolutely nothing that says that you can't sue Congress. All right. So they've created this perpetual conflict, this fucking problem, and really to get the solution, according to Justice Scalia, you have to sue. I have a right because those motherfuckers have a duty. And when they took the substance out of the economy, and then they put these military tribunals under Article 4, utilizing Article 1, Section 8, Clause 9, lower inferior courts as administrative venues to manage the bankruptcy and improperly operate outside their jurisdiction. They've caused us all harm, damage, loss, and a hardship, and they're all liable for it. They're also responsible for offsetting and discharging everything under Title 18, subsection 8, that's 40 statute large 411, section 7E, by proclamation of the president. And of course, Congress was the one that created the Trading with the Enemy Act. They're the ones, that's not an executive order, ladies and gentlemen. That's Congress and the House of Representatives assembled, making a statute at large, which is legal evidence of the law. So, with that being said, the Congress is liable here. Seventh Amendment in suits at common law where the value in controversy shall exceed $20. This is important. When these lower inferior courts are telling you that the fine is $20, $700, $500, you understand that they're not defining what a dollar is. The dollar was defined in the Coinage Act of, I believe it's 1781 or 1791. Don't take my word for that. Look it up. It is in the 1700s, but in the 1700s, I believe it was 1791 or 1781, the Coinage Act established that a dollar is a finite amount of gold and silver. So a gal was asking me earlier, she goes, well, when you talk about specie, what are you talking about? This is exactly what I'm talking about. Public law and public policy prevent them, and 31 CFR, Title 31 USC, as well as public law, what is it, 857 or something like that, and public law 7310, it prevents them from demanding a specific specie of currency, okay? There is no legal tender anymore. The Supreme Court has already ruled on that. Only God can create something from nothing. So the substance of the economy has been eaten out. It's gone. It doesn't exist. So when they're telling you that you owe $790, the question is dollars of what? You can't be expected to perform an impossibility. And because they're not going to give you the nature and cause of the action, where you could get some resolve, because then you would be fully availed and you would understand that it's banking and demand a full accounting so you can offset, render, settle, and close and discharge the account and balance the books. Because they're not going to do that, they've created an impossibility, and there is no expectation of you performing an impossibility. The other thing is, under Article 1, Section 10, no state can compel you to perform to satisfy a debt with anything other than gold or silver coin. The other thing is, they can't create ex post facto laws, guys. The whole ideology that, or belief that the legislator can create laws that affect you as the free inhabitants is absolutely insidious. Now, I'm not saying that you're lawless people. There are laws. It's natural law. Nature's God. Keep your hands and feet to yourself. Don't punch, fight, kick, and honor your word. Uphold your contracts. If you fuck something up, fix it. Provide remedy. Pretty simple shit. We learned all this in kindergarten. You can't legislate people into morality just like you can't tax people into prosperity. So I think it's really funny that people think that government was instituted amongst men because we're 50, 60, 70-year-old grown ass children that don't know how to get along and don't play well with others. That's not why government was instituted amongst men. So anything aside from protecting my life, liberty, pursuit of happiness, and enjoyment of property is arbitrary and capricious. It's contemptuous.
Yeah, under the Coinage Act of 1798, I believe it was 371.23 grains of silver equal to $1.
Mm-hmm.
But I mean, you say they can't make post ex facto law, right?
That's correct.
So what that mean in contrast?
That means that the only law that they can create only apply to them and their ilk, their kind. For example, if they want to get together and decide that on Wednesday everybody's allowed to wear shorts at the office, that's their fucking prerogative. But that don't mean I got to wear fucking shorts because I'm not part of their ilk. I'm not in their state of. And the state of Nebraska is actually the building they own. That's what's really funny about it. People think the state of Nebraska is this big swath of land with meets and bounds. But the truth of the matter is, the state of Nebraska is only in the legislature assembled. Does that make sense?
Yep.
It's a congregation of people that is bound together with a piece of paper who have all agreed to certain terms, conditions, and thought process. But we're told from the very beginning that even if 500 men decide to get together and form a society, those 500 men don't get to encroach upon my life, liberty, pursuit of happiness, because I don't have to join their society. I can be independent of their society.
Pruden versus Neal, 1796.
And it just goes back down to sound doctrines and principles and reasoning. You know, just because 200 people want to go jump off a cliff like a bunch of nuts doesn't mean that I have to do it. A million people do the wrong thing every day. I choose to about face and go the other direction. Is it right, wrong, or in between? I don't know. But, you know, for a lot of people,
Another way to put it
I
is
think go ahead.
another way to put it is the post ex facto law, ex post facto law is the Constitution is established. It's there. You now then have laws, you have rights to make legislation, which is considered to be intelligible principles. Now you're making this legislation, you decided that you're going to write a legislation to take away the constitutional rights, interests, and title in which you are guaranteed. That's a violation. That law cannot be enacted and it have no force. So the right that they're making, I talk about where there is probable cause, that's not even legislation. That is a court decision, which does not grant no rights, interests, and title to the court, nor the state, nor the federal government, which make it a post ex facto decision, which is in violation. It cannot have any standing in the court of law. It have no legal standing. Do you ever go in a court and they said, "Oh, you're a sovereign citizen," and whatever it is that you're doing, they have no legal standing? Well, to try to enforce something after it's already passed in the Constitution and try to make a law contrary to that pass, it becomes a post ex facto ex facto. Post ex facto is also when you have a contract. And a contract, say you have a contract with a corporation for a mortgage. Here you are with a mortgage. They then go ahead and make a claim after they sell the note already. I come into the court and try to make a claim. They have no standing to give get any right. When the court trying to exercise that right for giving them, you can declare the court is making an post ex facto decision. They already sell the note. They cannot get double pay. That will be in violation. You must do a quiet title because the title is now clouded. If you don't understand procedures, you got to learn it quickly and swiftly, especially when you're going through a mortgage, because that's exactly what they're doing in a mortgage. They're granting various people that already sold note. When they're talking about MERS, it's the same thing. MERS cannot actually buy the note. What it can do is can process the note separately from the county. what they are doing is trying to make you agree to that, because when you're not checking the MERS, they are using the same MERS principle to sell the note behind your back because they don't put it on the county, and they are using that same pool principle to have about 4 or 5 different people inside of that server without disclosing anything to you by sending the documentation to you. That doesn't abrogate your rights, interests, and title according to the federal government, where every time they sell the note or transfer the note or assign somebody to the note, they must send you those notice. You can give them a statutory violation after they review all the accounts.
Do a revocation of deed of trust, fire the trustee. You appointed him, so you can damn sure disappoint him. The thing is, the trustee will proclaim that he works on behalf of the bank, but in truth, he actually works for you. You're the one that appointed the trustee. The bank had power of attorney and they appointed him on your behalf. That doesn't change the fact that you're the grantor. And if the trustee
Yep.
doesn't do what the hell you tell him to do, you can fire his ass or
Yep.
disappoint him.
I did that.
They would love to tell you that they don't have to follow you, but that's a freaking lie. In the principle of law and agency, you are the principal party, therefore they are your agent. The principal have the right to acquire every single information from his agent. If the agent decided not to follow the procedure, the principal can fire that agent. It's the same principle in husband and wife. The husband is the principal and the wife is the agent. If the wife decided to buy a property without the husband consent, the husband can destroy the contract. He does have to know rules, structure, foundational laws, and you understand every single thing that they're doing. I continue there. Sorry about that.
No. I'm appreciating the interaction here. I've been droning on for a few hours here. But like I told everybody, we're going to lay down the basics because what I'm about to show them is going to be extraordinarily liberating. But if they don't have the foundation and the principles and they don't understand that this is all administrative and it's not judicial, so they exactly what you just said a moment ago, it's all agent and agency. And if it's agent and agency, I'm the fucking boss. And so people laugh when I told them that I fired a judge. I just looked at him and go, "You're fired. You can't fire me." Well, if I can't fire you, then you're obviously not fucking government and I don't belong here. So kiss my ass because I'm not gainfully employed by you people. And he just kind of sat there staring at me like, what the fuck do I do with this one? And I thought it was hilarious because it was really quite the conundrum. If I can't fire you, then you're not government because I have the right to abolish and amend and reform my form of government anytime I see fit because I have the right to declare my nationality, all right, and my allegiance. And so if you're telling me that I can't fire you, that's a violation of the treaty again. I must be a subject, serf, and slave, subject to your edicts, which violates the Treaty of Ghent. It violates natural law, natural principles, sound doctrines, equitable maxims. So where did you get your authority again? We're in a position here where if I can't fire you, then I only got one thing left to do. I don't really want to do that. But that's the position you're putting me in because, and it's kind of like, Boris. I like how eloquent he is. I'm a bull in a china shop and he's real eloquent because I just got one question before this court. Does the state own me? What do you think the answer to that one was?
The bet you bottom dollar no.
No, sir, the state doesn't own you. There's no agreed party here? Nope. Then have a good day. And he turned around and walked right the fuck out the courtroom. Have a good day. Does the state own me? No. If the state doesn't own me, you can't compel me to perform and be somewhere I wish to be for a duration of time unknown. That is barratry, maintenance, circuitry, and it's false arrest and false imprisonment. Have a nice fucking day. That violates the judicial canons. They're not supposed to be doing that shit. That's called harassing, badgering, and intimidating under threat, duress, and coercion under the color of office, color of law, color of appointment. What is there? There's like 4 of them.
This is why the judges can never appoint
Color of
nobody
authority
for you without your consent.
Mm-hmm.
They have to get your consent to try to make it in the legislation saying that they have to appoint somebody for you. Who the fuck gave them that authority? Where's declared in the Constitution? When did you and them have a sit down and a discussion of it? When did you delegate that power onto them?
Did you guys know that attorneys do have licenses?
Repeat.
You guys know that attorneys do have licenses, right? It doesn't.
There's something bar.
They have a bar guild card membership.
Oh, bullshit. I'm about to fucking shock and awe you motherfuckers. Okay? If you have unlimited right of contract and they're running a business and the 14th Amendment grants them the same rights and privileges and immunities that you have under the equal protection of the law, I'm telling you right now, attorneys are licensed. The question is whether or not you can take yourself out of the fucking box that the patriot mythology is painted upon you and see where I'm coming from. Now think about this for a second. Who licensed an attorney?
The British.
Whoever hires them.
Whoever fucking hires them, right?
The Supreme Court of the
state. If you hire an attorney, you license them. You indemnify them. You hold them harmless, and you license them. And that's why when I used to go into court with my mentor, they fucking hated us because they'd say, "Are you licensed?" And he'd turn around, look back at me and go, "You ever licensed anybody before?" And I go, "No." He goes, "Judge, I'm 001. He's like, no, that's not happening. Not today, not in my court. I don't think so. Do you have a bar license? And he goes, "Do you have a bar license? I've never seen a bar license. Does that guy have a bar license?" He goes, "In as much as the plaintiff is being represented by that man over there, I am the representation for Derrick S. Gonzalez." No, I'm not going to allow that. He said, "Well, who qualified you?" He said, "Well, the state." He said, "Well, if you were qualified by the qualifier, surely you can qualify me." And he says, "I'm not going to do that." He said, "Well, if you don't have the ability to qualify me and you were qualified by the qualifier, then I don't see fit that you're qualified to sit on that bench if you can't qualify me." And about that time, the bailiff came over and we were kindly escorted out of the courtroom. But I thought it was funnier than shit. That's the kind of shit James Bethel likes to do. He just likes to fuck with them. We call it fucking with public officials. Entertainment for poor people. That's our profession. But anyway, it makes a lot of sense when you start to think about it. When he looked back at me and said, "I'm 001, right? Or you ever licensed anybody before?" I go, "Nope." He goes, "Your Honor, I'm 001. It's just fucking comical. Needless to say, you guys have to understand, it's not the judiciary, it's administrative. In the Constitution, there is executive, legislative, and judicial. Where did this thing,
I didn't understand it takes
the administrative, come from? Where's it at?
I didn't understand it takes so long.
It's in the executive branch, okay? So that in and of itself proves the disqualification under Title 28, 455, because it is a conflict of interest. Anytime the state's got an interest in your estate, always bind it over to the federal court. Now, if they try to remand it back down to the state court, because what they're saying is how I was raised and how I was informed before I started studying on my own is that the state court is supreme and superior to the federal court. But after you learned what you learned today about the fact that they do not take the Article 6 oath, ladies and gentlemen, you want to take everything to the federal court under federal preemption because there's a perpetual conflict of interest they can't avoid. The agency and agencies are all working on behalf of entities masquerading around as government that went into cooperative agreement with the state to get federal block grant funding to float their retirement, bolster their paychecks, and their wife, their son, their daughters all benefit from it. Same thing with foreclosures and mortgages, by the way. There is not a judge in any of the states that can sit on the bench in all honesty and rule on a foreclosure. Does anybody know why? Why can't they sit on the bench and rule on a foreclosure? Because their retirement is predicated on hedge funds in the S&P fucking 500. So that means if they foreclose on you, they have a financial interest to rule in favor of the bank so they can issue more securities, which would increase their retirement. There's a financial interest there. They're not non-biased. And it is a prerequisite underneath the judicial canons that they maintain this prestigious influence amongst the general populace and keep clean hands and never grant rise to anybody having an inclination that their orders and rulings could benefit them financially in any way, shape, or form. It's the same thing with the child support order. Ladies and gentlemen, there isn't anybody that can sit on the bench on a child support order. You want to know why? Because child support was not implemented as an inherent right of the child. It's a mere incidental benefit. The reason that they implemented child support was to benefit the state treasury, which benefits each and every person in the judge's household. And not to mention through the ADA, Americans with Disabilities, because they consider the child disabled, right? Wardship, can't take care of themselves. So they're getting Title II and Title III kickbacks from the ADA, which is an emoluments violation. Remember what Title V, United States Code 3332 stated, that they weren't promised any financial gain or took any bribes or anything like that. Well, that's exactly what they do under Title 4A, Title 4D, and Title 4E. They're financially incentivized. It says it right there in their own literature. Not to mention that in child support, any CPS hearing, you can't even hire an attorney because that's conflict of interest, because the Bar Association for the United States out of Illinois created all the provisions for DHHS in family court and child support issues. So that's a conflict of interest. You can't hire a bar member to represent you in that. Secondly, family court is just like traffic court. They're special star chambers venues. They're administrative. They're operating outside the judiciary. All right. So there's another issue there. So that is a substantive right violation. It's a denial of due process of law. And if you ever want to get out of the family court, just immediately demand a trial by jury. They're going to say, well, what grants the right to that? Because my precious value time commodity is worth more than $20. Thus, the Seventh Amendment, in any suit at common law where the value in controversy shall exceed $20, the right of a trial by jury shall be preserved. Kind of like the Second Amendment, shall not be infringed, shall be preserved. So no matter what they do, no acts, no executive orders, no legislative edicts amend the Constitution, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Now listen to this. When you go to court and you demand a trial by way of jury, which is under the Seventh Amendment, which you are guaranteed, and then you go through this jury and they find you guilty and they tell you that you have a right to an appeal, were you afforded the Seventh Amendment trial by jury and jury of your peers? No, you were not. They use false and misleading and deceptive trade practices. So when you demand trial by jury and they say, well, we're going to give you a jury trial, and you're going to say, is that a trial by way of jury? And they're going to say, yeah, it's what you're asking for. You want a jury trial? We're going to give you a jury trial. The next thing out of your mouth should be, point of clarification. If the jury rules against me, do I have a right to an appeal? And of course, they're going to say, yes, you do. Well, guess what? That's not a trial by way of jury. That's a jury trial. That's a special administrative proceeding under maritime admiralty, masquerading around looking like a legitimate judiciary. But if you can appeal the jurors, then that tells you that you're being denied the Seventh Amendment. Because listen to this: in suits at the common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. This is the important part. And no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. In other words, not even the Supreme Court can overrule a trial by jury. When the jury members have decided the facts and the law, not even the Supreme Court can overrule it. There is no fucking appeal. The decision is final. And so when I discovered that, I was utilizing that with other people in courts, telling them, hey, just do yourself a favor, demand a trial by jury, and they're going to bullshit you and say, oh, jury trial, no problem. And then you ask them the immediate question right after that. If the jury finds me guilty, do I have the right to appeal? And they're going to say yes. Well, this is the improper venue, because trial by way of jury doesn't grant me or afford me the ability to appeal. See, because trial by jury is going to recognize there's no verified criminal complaint here. There's no aggrieved party, and therefore this is a simulated legal process with sham legal pleadings. Now, earlier I was showing you guys the special supplemental rules from 1966 of maritime admiralty. That's a little more advanced for dealing with securities and making a claim and a statement of interest and notice of interest. For the complaint security, I wouldn't, before you guys jump off the deep end and try something like that, you really want to study that a little bit more. Eighth Amendment, excessive bail and bond. Bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. When they arrest you for traveling without a license, for not giving them, coloring them with authority by giving them what they're asking for, I want you to understand this. When they pull you over, they're asking for you to voluntarily give information and color them with authority. They will tell you the Supreme Court requires that a driver produce license, registration, and proof of insurance. They are correct in that assessment. However, where they have fucked up is they're presuming and assuming that you're subject to the Department of Transportation Motor Vehicle Code. They have no physical evidence that you are or have engaged or have acquired a driver's license. They're presuming and assuming that. And if you don't give them what they want, whether you have it or don't, they will exhibit violence on you. So that's extortion, identity theft, declare an emergency when there was none. They run your name on the radio. That's a violation of the FCC, invasion of your privacy. They also run your information through their digital database without full disclosure. So denial of due process of law with the DMV and the BMV, these are all very valid and relevant points. Pick and choose your battles, but if you understand what I'm talking about, it'll make it that much easier for enforcing them, for forcing them to correct the record. This simple stuff. So the Eighth Amendment, when they arrest you on the side of the road and they put you in torture, in handcuffs, that's by way of policy. They're putting you in handcuffs because of policy, not law, policy. Policy dictates that they put you in handcuffs, okay? And they're going to say it's for your safety. But the Supreme Court has already ruled that an officer has no obligation to protect you. So when they're telling you it's under the guise for your safety, that's bullshit. Number two, unless they've actively seen you commit a crime, a felonious act in front of them, or you're disturbing the peace, those are the only two grounds they have for physically accosting you against your will and arresting you and taking you to the nearest magistrate. Otherwise, they have to go get a warrant. They have to have a reasonable, articulable fact supported by a reasonable, articulable suspicion that you're about to engage in a heinous activity or crime. Okay. Even when officers speak to witnesses on the side of the road, that is just hearsay. If they didn't witness it with their own eyes, all they can do is take a report, swear out take the sworn affidavits, and go to the clerk of the court and the judge and have a probable cause hearing to see if there's sufficient evidence to issue a summons or warrant. All right. But the way that they're trained is to accost you against your will, take you in, and the first thing they want to do is process you. Why do they want to process you? Well, they get a kickback. See, you got the bid bond, the payment bond, the performance bond, and then you have a warehouse bond. The sheriff gets paid for warehousing your body. Okay. So they want to take you in and they want to book you. They want to get fingerprints, photographs, butt prints, mushroom prints, you name it. I'm surprised they don't take toe prints. I think that's funny, but they don't. The reason they want to do that is that's how they get paid. All those instruments can be negotiated and, in fact, are sold. They're sold to Interpol, they're sold to other agencies. All that data is valuable and they sell it. They're selling property they got from you without just compensation and without full disclosure. They're telling you that it's the law, but the truth of the matter is it's not law, it's policy. It's policy, not law. In fact, it's against the law to take fingerprints, photographs, accost you against your will, and detain you absent a victim, absent a crime, absent disturbing the peace or committing a felonious act in their presence. It's absolutely not only illegal, but unlawful for them to do that. So you need to state your claim because you have been accosted against your will, denied your life, liberty, pursuit of happiness, and enjoyment of property, all under policy, which grants rise to a Monell action. For city police to do these things, they have been hired by the city council to enforce city municipal code. City municipal code only applies, just like Congress, just like the United States, it only applies to the buildings they own, the land they own, the property they own. So like the housing management of the city, if they've got a bunch of little HUD houses and they micromanage the HUD houses, the city wastewater sewage treatment plant, the utilities building, maybe the golf course, the cemetery, that's where their jurisdiction is. Everything else that they're trying to do with you is arbitrary and capricious, ladies and gentlemen. And you got to put them on notice to cease and desist. They carry liability for depriving you of life, liberty, pursuit of happiness, absent due process, notice and opportunity. So it's just a matter of ceasing to do what you're told and start questioning and analyzing things so you can enforce your rights. The Eighth Amendment, excessive bail shall not be required. Absent a victim, when they're charging $50, $60, $100,000, $200,000, $250,000 in bail, it's a 10% cash bond, 100,000. You know, so bring us 10 G's. Okay, that's excessive bail and bond. That is cruel and unusual punishment. To put somebody in a cage, to extort their family, their friends, their loved ones in order to get them out of a cage where they're presumed guilty until proven innocent because they're in a cage and they haven't done anything that is heinous. There's no reasonable articulable fact or reasonable articulable suspicion or reasonable articulable probable cause to believe that you're have harmed somebody, about to harm somebody, or could harm somebody. They're just sticking you in there because they know most people will make a phone call. If I was to do that, I'd be charged with kidnapping, false arrest, false imprisonment. When they do that, they consider that business. That's just how we do things. And everybody seems to go along and get along. You need to start making private claims against these people that are doing this because they're doing it under policy, and policy is not the law. I've taken many trips to jail with officers and just flat out looked at them and said, I'm not putting cuffs on. And they're like, excuse me, I'm not putting the cuffs on. I'll get in the back seat. I'll roll with you voluntarily, but I'm not fucking putting cuffs on. I'm not doing it. And they're just like, all right, get in the car. Would that work in Houston, Texas? Probably not. In other places, it does work. But the fact of the matter is, you can tell them no. You don't have to consent. All right? I'm going with you. I don't have to. You don't have the warrant. And in order to arrest me, you actually physically have to be in possession of the warrant. They'll tell you no, they don't. They absolutely do have to be in physical possession of the warrant, or it's a false arrest and false imprisonment. So, cruel and unusual punishment. I think we covered that. On to the next part here. Ninth Amendment. The enumerations in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Notice how this is a lowercase p, not we the people in the preamble, but a lowercase p. Disparage others retained by the people. The 10th Amendment. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. The 10th Amendment is one of the best because most people in agency stop at to the states respectively, and they forget the 4 words that precede to the state respectively or to the people. Ladies and gentlemen, you are the alpha and the omega. You have all the control. You have the right to abolish and amend and reform your form of government anytime you see fit. And it doesn't matter what their opinion is, what their slanderous, defaming tone or snide remarks are. You have the ability to tell them to pound sand, to kick rocks, to fuck off. Or you'll issue them a notice of liability. You want to be left alone. So, understanding that martial law is afoot, that they didn't take the Article 6, there's no judiciary, we're in martial law. Abraham Lincoln never did a proclamation to end the war. He did do a declaration to start the war, but as we went through the 40 Statute at Large 411 Section 7E, where it said that the war could be ended by way of a treaty, right? The Law of Nations, or the Principles of Natural Law from 1758, Book 1, Chapter 16, of the protection sought by a nation and its voluntary submission to a foreign power. This is Law of Nations 192, protection. When a nation is not capable of preserving herself from insult and oppression, she may procure the protection of a more powerful state. If she obtains this by only engaging to perform certain articles as to pay a tribute in return for the safety obtained, to furnish her protector with troops, and to embark in all his wars as a joint concern, but still reserving to herself the right of administering her own government at pleasure, it is a simple treaty of protection that does not all derogate from her sovereignty and differs not from the ordinary treaties or of alliance otherwise than as it creates a difference in the dignity of the contracting parties. So, in other words, you can surrender to a more powerful state and invoke their military forces for your protection while maintaining your derogation of sovereignty and the right of administering your own government at your pleasure. All right. So, being that we're in time of war and we are under the War Powers Act, and we have been subjected to martial law. When in Rome, be Gandhi. Go to peace, surrender while maintaining your derogation of sovereignty under the law of nations, which is clearly mentioned in the Constitution. They recognize it, the law of nations, and administering your own government at your pleasure and leisure. Right? Let them know you're not an enemy, belligerent combatant of the United States. Right? You recognize their sovereignty. You expect them to recognize yours. There's a clear line drawn in the sand. We can both go along to get along. I don't want to be at war. You guys got enough problems on your hands. Handle and settle your own affairs, and we can coexist. The Treaty of Ghent under 1814, Abraham Lincoln didn't free the slaves. He did so because of the Treaty of Ghent. The Treaty of Peace and Amity between the United States and Great Britain. Article 10, whereas the traffic in slaves is irreconcilable with the principles of humanity and justice, and whereas both His Majesty and the United States are desirous of continuing their efforts to promote its entire abolition, it is hereby agreed that both the contracting parties shall use their best endeavors to accomplish so desirable an object. Now, this is a treaty between the United States and Great Britain. You can invoke this treaty and hold them accountable. So, involuntary servitude, slavery, peonage, bondage, maintenance, circuitry, all of that equates to slavery. Compelling somebody to be at a location where they don't wish to be for a duration of time unknown against their will under threat, duress, and coercion is slavery, bondage, peonage, maintenance, circuitry. Maintenance and circuitry you're going to have to look up to understand them. These are ethics violations as well as unalienable rights violations and due process of law violations. So let's nip it in the bud and prevent that from occurring, predicated on some benign contract that they're presuming and assuming grants some extraterritorial jurisdiction and makes you subject to policies, rules, and regulations. This is why the Chevron deference case being overturned is such a magnanimous event. Let's see here. Oh, what happened? There it is. Screen sharing has stopped. The shared window is closed. All right, here we go.
Okay, we're gonna stop it here for just a second here, folks. And
to grab.
Okay, it's 1:40 in the morning on 11/2.
Where did it go?
And it started the recording again. There you go.
Let me see. I gotta find. Oh. Let me see. So now, instruction for the government. There it is. So do this. We're going to change from the PowerPoint here. And let me grab that here. Close that down. Close. What's this one? Corporation. slow and go here for a second. Let me make sure I'm on the right screen. Before you guys are troopers. Any questions? Questions. We'll continue on. All right. So we're almost getting to the nitty gritty with the right to travel, and I'll bust out some cases and run through the codes for you guys in short order here.
I do have a question if you don't mind.
Yeah, go ahead. We're the only ones awake and still chugging along, so ask away, and
Okay.
it'll help me be more
You're
thorough. I'm about to tell you.
you're talking about filing the birth certificate in a case to settle it. Could you file your birth certificate into your nephew's case, or would it have to be his birth certificate?
It'd be his.
Okay.
It'd be his, yeah.
And it has to be just certified from the county register, or it has to go through the Secretary of State?
It doesn't even have to be certified or authenticated. It's already backed by the full faith and credit of the United States. But to authenticate it on the state and federal level is to adopt it, and it is to be treated as the original. So that's the whole hocus pocus behind the authentication processes. I spent a little bit of time with a state registrar, and she alluded to when you do the apostille, it's for in the state. And when you do the authentication, it's because you're going to take it out of the country. Now, you got to think about that. I know somebody who actually authenticated a birth certificate for the United States of America. Knowing what we now know and what I just went through with the Constitution and everything, it is very, very clear that the United States and the United States of America are foreign to each other. They are separate and distinctive things. So when he told me that he got his birth certificate authenticated for the United States of America, I found that very peculiar because when you go down to the Secretary of State's office, if you say something like that, they're going to look at you real sideways because most people's belief is that the United States and the United States of America are the same thing. They're not. And the union of states, for example, Arizona versus the state of Arizona, Arizona is its own sovereign nation and foreign. It's a reservation, if you will. And every state of the republic is its own nation and reservation. So they're distinct from the state ofs because the state of is a political construct versus the state of is a subsidiary corporation to perpetuate and further the agenda of the principal corporation to do business, right? And then you have the state, which is the actual republic, wherein all the people's rights are vested and tied to the land. So distinguishing fiction from reality is quintessential, and in doing so, it's imperative that people understand territorial jurisdiction and how powerful it is. So with the birth certificates, all that stuff's in the fiction. You can go to the state registrar and get 50 of them. Who cares, right? So turn around and on the back of it, remember the front of the instrument is public, the back of the instrument is private. Turn around and endorse the back of it and release your beneficial interest to render, settle, and close and satisfy any debt due and owing pertaining to, and then write the court case ID number, the docket number, get the bar numbers for the attorneys, put all that stuff on there. Put all that detailed information on there and turn it over to the court to settle, close, to render, settle, and close the matter. And then use the special supplemental rules from 1966 and point them out to them. Right here it says special bond. Well, that's an awfully special bond, isn't it? It's printed on pretty banknote paper. It's special in the aspect that it has all the special details that pertain to your estate. Make sense?
Mm-hmm.
So you have to use those that you've got back from the state. I mean, not from just the state or from the.
You just get it directly from the state registrar. It's already verified. That's what's funny. It's got the upraised seal. What other document?
You can use a copy. You can use a copy. You don't have to use the ones
No,
that
you got to use the original, but you got to use the copy that you get from the state registrar. But let me ask you this: how many documents have you ever gotten from the alleged government that has an upraised embossed seal?
Well, I don't have too many.
When you study
the birth certificate,
I'm talking about the birth certificate. Yeah,
I know what you're talking about. When you get the long form birth certificate, it comes with an upraised state seal on it.
Yes, okay.
Embossed upraised state seal. Okay. How many other documents do you get from anywhere else? Courts, doctors' offices, Secretary of State's office that come with an embossed upraised seal? I can only think of like one other document, and that was out of the Secretary of State of Minnesota, and I had to pay extra for it that they gave me the upraised embossed seal.
I've got more in my trust than I have, I guess.
So the upraised embossed seal, when you learn about marks, sigils, signets, and seals, the upraised embossed seal is verification. That is certified.
Okay.
So having to go and get a apostille on it and or an authentication, not necessary.
Okay. Well, I guess that's what I'm confused about.
And if you use one that's got the full faith and credit on it, there's just additional bond numbers on it. And in the bottom lower left-hand corner, you should study those
Well,
codes.
I've got a copyright on that particular one too. So, you know how they're numbered. So
copyright on it.
I think I've got a copyright on the birth certificate.
You can always get more of them. I don't understand what people's infatuation is.
Well, I don't know either. I mean, I started this process 3 years ago, and so I went with more of the foreign trust thing, and thinking that it met all of the I guess protections to keep you away from all of the BS. But
why
so
it doesn't constitute a form of identity, and it's clearly a certificate of
irrevocable
security. It's a warehouse receipt, bill of lading, it's cargo shipping manifest. Like, what's the point of hanging on to it, just to collect dust?
No, I guess so.
I don't know. I've never figured out what people's infatuation with them is. I know a guy that's got like, it's actually a girl who's got like 20 of them, and she's so proud of them. And every time she goes anywhere, the group's getting together and congregating to talk about law, she brings them and shows everybody. See all these?
I don't give a shit. They're in my file.
This is how I ended up talking to that gal at the state registrar in Arizona, because I ordered like, what was it? I ordered 24 or 25 of them. It was a couple $100, and she looked at me and she goes, "Can I ask you a question?" I go, "Yeah." She goes, "What are you doing with these?"
Gonna be raping some bankers.
I said, "Hell, I don't know. I'm here, and I'm here, I'm there, I'm gone like the wind. So I pick them up while I'm here because it's better than getting them at the vital statistics. And plus, I figured I'd come in here and bullshit with the likes of you." And she started laughing. She said, No. Now, seriously, what are you doing with all these? I said, well, I think the more important question is, why would you be concerned about what I'm doing with them? And she just kind of looked at me. I said, I'm thinking about authenticating a few and apostilling a few and maybe making a few, depositing a few into a bank. I said, what's your concern about me ordering so many in one time? And she says, well, if you were to meet your untimely demise, we would want to make sure that we could cancel these. Oh, cancel them.
Oh,
Cancel them for what? Well, in case you met your end, and I'm not wishing that upon you or trying to bring that upon you or anything, but we would want to make sure to cancel it. I said, well, you act like they got a lot of value or something. I said, you must know something the rest of us don't. She just kind of smiled, and I said, now I'm gonna ask you some questions, and it ain't legal advice. We're just having a friendly conversation here, but I know a little bit of something about these things. What do you know? And so I started pointing to the numbers. I said, on each one of these, there's a number in the bottom left-hand corner with a circle around it. And I said, I presume and assume that to be a bond number because it don't have a letter integrated into it. So I don't think it's a QSIP number. And she said, oh, that's for internal use. I said, well, what does it need that number on it for when it prints the number at the top? Well, I can't really go into that. It's kind of a trade secret. Really? So you're saying that the identifying number that changes by one digit every time you print one of them cocksuckers is a trade secret. And you're telling me that it's not a bond number or a QSIP number or some type of identifier that is tied to anything financial. And she goes, well, I can't really get into that. She says, but I will tell you this, that if something was to happen to you, we would want to keep track of all these because they have value. And somebody could go out there if they got a hold of them and use them. But then she wouldn't tell me for what they would be used for, which I found interesting.
Like a death certificate too, and all of that.
Well, a birth certificate is a death certificate.
Yeah, it is. I'm just saying, I look at death certificates. I mean, what do you do with those? I mean, you could do.
They're valuable.
They're valuable. Yeah,
they're evidence of the estate and the accounting. See, when you go to the IRS and you start reading the IRM manual, you will find that there's a business master file and there is a personal master file.
Business and personal.
Using the Social Security and birth certificates your entire life as forms of identification and things of that nature. And for filling out applications, every time you fill out an application, you create a new juristic person and a new account because under Proclamation 2039 and 2040, everything is now a financial institution. That's why you're a private banker. Because when they took the substance out of the economy, they had to provide you a remedy. Therefore, they didn't grant you the power of being a private banker. What they did was recognize your authority of being a private banker. See, there's things you guys got to understand about the banking system. They didn't create shit. The people were already negotiating negotiable instruments amongst themselves. The people were already creating securities. All the system ever does and ever will do is mimic and replicate. That's it.
As I recall you saying, sign not for the benefit of commerce, industry, and agriculture.
Yes, the 73rd Congress, when you get into it,
yeah, it's cool.
It's lengthy, but right after they solve the whole banking crisis and everybody applauds, the next thing that transpires is they immediately start talking about licensing.
Yep.
First thing they start talking about is licensing of automobiles and the licensing of this and the licensing of that and so on and so forth, but specifically automobiles. And the reason for that was to generate these new securities and negotiable instruments so they could peddle them on the market.
So being that I, took my husband's name and all of that, and he's passed, I changed my name because I listened to somebody that worked at the IRS, and I changed my name. I wonder if I have another, or at least another Social Security card out there that they're banking on.
I don't know if the baby's still on here or not, but I went through him, and I know for a fact because I went and spoke to the hospital administrator. There's a book of life, and that book of life has a secondary series of numbers, whether it be a second social security number or not. I can't
We don't know.
affirm one way or the other. But what I can tell you is that there is a difference between a long form birth certificate, short form birth certificate, and the certified photocopy of your birth certificate. You want a certified, is it a photocopy? What's the other? It's an image of the birth certificate.
Okay.
Verified, certified image of the birth certificate. So it's not just a scanned in copy. It's a photo.
Verified and certified.
I don't know if it's verified or certified. I'd have to
Okay.
pick his brain about that again. There's a specific word.
But not a scan. Okay.
I want to say it was an image,
Image. Okay.
but that's not the word being used. It's not like what they typically print. It is an image. And on that image, there is nothing that is left out. For example, when that gal was from the state registrar's office was printing out all those birth certificates for me, she was stating that some of those numbers were for internal in-house uses.
Mm-hmm.
Well, just the same, you're entitled to that complete record, and that record may be associated with different accounts in different locations. Well, how are you supposed to do decedent estate life planning to set up your estate to take care of your loved ones and offspring if you're not being fully availed of all the material facts and the things associated with it?
Right.
That becomes the issue. And so after speaking to Smoking Baby, I found somebody who was willing, because I was really intrigued with this whole thing. And I'm kind of the black sheep of the family, and everybody thought I was fucking nuts. So he agreed to go up to the hospital with me. He was born in '63, and we went up there, and lo and behold, the only book that was missing from their archives at the hospital was the year of '63.
Really?
And he was born in a hospital that I think he was one of the last few babies that was born at that hospital before they tore it down. Anyway, there's only like 15, 20 kids born that year or something like that out in the sticks and the boonies in a little tiny ass hospital. Anyhow, they come back, and the state hospital administrator, they always operate in pairs of two, liability, and they're just covering each other's asses. But the hospital administrators know way more than most people do, because everything is done through agriculture, and of course you got the Township Ward Maternity Act, and they are financially incentivized. They're private, but they're financially incentivized and go into cooperative agreement with the state registrar and the state and the county and all that good stuff. And so they understand that human life is a commodity that is capitalized on. The hospital administrators know that stuff.
Mm-hmm.
They get paid handsomely for umbilical cords, placentas, eyeballs,
Yes.
lungs, fucking footprints, butt prints. They get financially incentivized to jab a baby and overdose them with 72 fucking gallons of horse piss and bullshit that they pump into the body. It's pretty disgusting. But anyway, needless to say, they understand that this is nothing more than a huge, it's just a huge feedlot. It's what it is.
Yes.
Some people call it a slave plantation. I call it what it is. It's a feedlot. Feed them and breed them.
Derrick, I have a question for you.
Yeah, go ahead.
What do you do when they tell you that your record is sealed until you're the age of 75? Because when I went to my jurisdiction in May, I asked to see my birth announcement, and they kind of beat around the bush. Then the lady finally told me that I couldn't see it until I was 75. How do you get how do you get around that?
Probate. Go into probate. Subpoena the record.
Yeah, order to show cause.
You're doing decedent estate life planning, and you need those records to um, complete your decedent estate life planning.
Okay, thank you.
Remember, everything is administrative. There is no judiciary. Everything's administrative. So you're going to go in under the law of agency and handle the affairs. And now you have been availed under 40 statute large 411 section 7E, which is evidence, legal evidence of the law, that birth certificate grants you power of attorney. You are the attorney in fact, and all records pertaining to that estate you do have unfeathered access to.
What code was that again, Derrick?
40 statute at large 411 section 7E.
Okay, thank you.
Yeah.
Thank you.
She was asking for a birth announcement.
I wanted to see my birth announcement and my birth record, and they told me I had to be 75 to see it, which told me you have a trust on me
in
till I'm
that
75.
fucked up state of Montana where they won't fucking give you the long form, or Pennsylvania where they give you a bunch of horse shit, are you? Is that where you're at?
I'm in Montana. I was born in Oregon, but I'll tell you what, this is one of the most.
Montana's a pain in the ass. I believe Kaya was saying that they won't let her see it for 75 years. And it seems like I was helping somebody, and we did achieve getting their record. And they were in Pennsylvania. I want to say they said that it was locked up for 75 years. Kaya, are you in Pennsylvania or New Hampshire?
I'm in Pennsylvania, and they told me 100.
I'm in Illinois. I'm in Illinois.
Kaya, I'll get a hold of my buddy because we worked on that together. We ended up getting his record for him, and he was in Pennsylvania, and it was a pain in the fucking ass. And I don't know why they bar you from having access for 75 years there. It doesn't make any sense except for the fact that they're barring you from gaining access because they don't want to release it to you. They're hoping that you'll be deceased and gone, and they can declare you alive and start a new insurance policy.
That's my
when you make an application for the Department of Vital Statistics, when they ask you for the reason for it, I was advised to put down, quote, for private estate matters, close quote.
Right.
Okay. Now I've pulled birth certificates from Pennsylvania, Michigan, Ohio, New York, Minnesota, Wisconsin, Arizona, Texas, Oregon, Washington, Nevada, California. I mean, I've done them all over the country. And every time we put down the reason for it was private estate matters, they always complied with it. The only thing they won't give you is the notification of birth, because the notification of birth was the biometrics that were placed on the long form that they don't put on the certificate of live birth or the standard certificate of birth or certificate of birth. So there's Oklahoma has a standard certificate of birth. They have a standard certificate of live birth, certification of birth. Illinois has like 7 different classifications. And so I did a lot of ordering of those, and I probably done close to 100 authentications back when they were being done with the Secretary of State's office out of Sterling, Virginia, but they've bottled that all up now. It's almost next to impossible to get an authenticated one.
Really?
What's so interesting about it is the fact that you are the only real party in interest that pertains to that information, and that information has everything to do with you. And it is, I think how we ended up getting it for him out of Pennsylvania is we stated that it was the intent of the grantor for him to receive those vital records of a vital nature, and it was never the intent of the grantor who granted that information to them to disparage or to deny him access after reaching the age of majority, and they turned over certified copies of the record to him in Pennsylvania.
Well, it's sort of funny was when I was working with Adam Beck up in Canada, he had what's called the first will and testament. Now it's interesting when somebody dies, they always want to scramble to find the last will and testament. They never talk about the first will and testament. Well, based upon the fact that the mother was the grantor and the child, either the baby boy or the baby girl or the whatever you want to call them, the infant, they were the beneficiary.
Right.
So when you have a first will and testament, it's the wish, the demand, and the
will, wish, and pleasure.
Yeah, will, wish, and pleasure, and demand that, when the party reaches the age of 18, they are allowed to administer their affairs of their own estate.
Yeah. They've gotten so accustomed for generation after generation after generation of people not claiming their interest. And they've gotten so accustomed to utilizing it and misappropriation of it that they don't want to give it up now.
Sure.
That's where I see the real issue is because I'm pretty well versed. When I walk into a courtroom, if they're cordial with me, I'll be extraordinarily decent. But the second they try to piss down my back and convince me it's raining, fuck you. You want to play fuck around and find out? I promise you, I'll leave your dick in the dirt intellectually. And I'll talk about things, and I know for a fact that a lot of these people that sit on a bench, they don't have a half a fucking clue. And I can rattle stuff off the top of my head that the attorneys are just like, I have no idea I can't keep up with him. And every retort and everything that comes out of their mouth, I have an affirmative, expedient rebuttal for. Because once you realize that it's all banking, and then they want to talk about benign statutes, code, city ordinance. And how does that apply to me again? Oh, that's right. It doesn't. You don't have any evidence of a contractual nexus between me and the state of that would bind me in any way, shape, or form. You have a presumption and assumption. I just defeated that. Next, you got anything else? So as I was saying, I want my rights, titles, interest, dividends, derivatives, ventures, sediments, general tangibles, general intangibles, child securities, trusts, residuals, rents, profits, proceeds, features, or annuities. I'm gonna report you motherfuckers for tax evasion, money laundering, extortion, human trafficking, trafficking of persons. I'm going to try and freeze your accounts under Executive 13818 and 13903. And I'm going to do my best to report you to every agency that I can. Because in all reality, what they're attempting to do is they're attempting to collect the debt, which is they're forbidden from masquerading around or pretending that the debt is vouched for by the United States. So they're not allowed under 1692E to wear any facsimile badge or give the impression that the debt is vouched for by the United States. Well, when the sheriff comes up and delivers papers to you for a third-party debt collector, guess what? He's no longer the sheriff. He just became a third-party debt collector, and he's liable. They're not supposed to be using the sheriff. Well, this all starts to make sense when you understand there's no judiciary, that they're doing it under administrative procedures under War Powers Act, and that they're all private mercenaries working on behalf of the United States, which has conveniently created this martial law by way of executive fiat, and all of them are militia members. And then it starts to make sense. So in order to put them back in the box, what do we have to do? We have to understand territorial jurisdiction. Territorial jurisdiction is quintessential. And I think maybe we should do a class on that, because this really ends up, when I go through all these codes, and I'm going to break them down for you guys, and I'm going to go through all the heavy hitters, realistically, you only need a couple of these. You need 49 USC 13505A.
What was that? 49 USC
14504A. 10. You need that.
14,504. Okay.
Yep. We'll start through that here in a minute. I'm just taking a small little break. I want to go through the Lieber Code real quick so you guys can understand that you are under martial law. And when you bring up the Lieber Code, because you now know that all these courts are underneath the Article 1, Section 8, Clause 9, and Article 4, which means they're all underneath the DOD. And that's why they have the flags in there with the gold fringe. I don't even like bringing it up. I know how to articulate it. I know what people are talking about. And they're like, oh, I'm not subject to a court martial and I'm, blah, 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 blah. And it's like, look, those arguments, although they have some weight, force, and effect, if you don't understand how to articulate territorial jurisdiction, you're just pissing up the wind.
You said Article 1, yes, Section 8.
Section 8.
Clause 9. And then the other one was 4?
Article 4, yeah.
Okay. Yeah, I know those.
Yep. And the proof is in the pudding that everything has fallen apart because when you look at it, you got United Nations in New York and you got a United Nations headquarters that is now in Utah. Well, back in the 40s and 50s, that would have never fucking flown. But it does now. I saw a gal who went into the United Nations building in Utah, and she's recording on the sidewalk and walking back and forth and recording the building. Well, somebody comes out from Haiti and starts yelling at her, "Hey, you can't record here." And she's like, "Freedom of the press, Constitution." And the gal was quick to remind her that she is not on United States soil any longer, and she can be arrested and detained until they choose to release her. And I found that very, very, very interesting. And that was right there in Utah. Well, upon further investigation and study, because I can't just hear something like that and not look into it, the United Nations building is treated just like an international airport, and the Constitution doesn't apply in international territory. So the United Nations building in Utah is considered international. And so
it's an enterprise zone.
It's like the national
Recording in
progress.
progress.
Paid off in 70 years, it doubles, and therefore they have to leave the one charter that they've created and roll it over to a new charter, and that's all the reorganizations. In 2008, we went through a reorganization, and again, and it follows those dates.
Yeah, 1781 to 1861, 1865 to 1945 at the end of World War II.
Right.
From 1945 to 2025 is the Third Republic, and we're going to be starting the Fourth Republic.
Which is exactly why they're getting ready to start another war.
Yep.
Exactly.
Got to get rid of it.
Tuesday night, I bet Tuesday night will be the invasion of Venezuela because Tuesday night will be a full moon.
Yeah,
So
it sounds like Venezuela needs some fucking democracy and freedom down there now that they've found a bunch of minerals. Fucking people, insidious. And here's the thing. the real estate. And therefore, when you get the electricity, they're presuming and assuming that you're reselling the electricity, and therefore you have to pay for it. If you remove your house from the tax roll and you gave them notice that it's not real estate and there's no commercial value and that it is your humble abode, it
Yep.
is your private household consumer goods, they cannot charge you for electricity because clean air, clean food, clean water, and electricity are essentials that you're entitled to.
Okay, remove your house, your home.
Reclassify it. Everything that you're going to learn from me over the next
Reclassify.
couple hours has to do with the classification, how these companies and corporations are in cahoots with the system and classifying all your property
Mhm.
by their terms and definitions.
Okay, so
If
pay.
agencies
Okay,
in place that do unlawful conversions without talking to you about it, we trust in them. They say, oh, we know how to do this. We've been trained by the government. We're certified by the state. We know exactly how all this works. We'll just take care of it for you. And then what they do, because the way they're trained, is they do an unlawful conversion and they take your property and they convert it into something that it was otherwise intended to be, which is called destroy. They destroy it. They destroy it from its original intent and purpose and convert it into a purpose that benefits and suits them. And they call it privilege that you receive that you now have to pay for. For example, the reason or one of the reasons I should say, is one of the benefits that they allege is a benefit to you is the address. The address belongs to the municipality. Okay. By having that address makes you subject to 911 emergency dispatch. Now, I'll tell you right now, 911 emergency dispatch. How often do you call them? Probably fucking next to never, right?
Right.
But that's the privilege that you incur, and as such, you have to pay a tax. So remove me from the emergency 911 call. I'm going to go ahead and remove your easement and your address from my property because you didn't fully disclose that that was perceived to be a benefit for which I had to be paying taxes to you for the service and product you provided, known as an address. I don't need a fucking address. In fact, it's best that you don't have an address because you have a right to privacy. In the 21st century, people have lost the value of privacy.
Smoking baby talked
booty
about that.
shaking, booty shaking, the tatas are hanging out, and people are taking pictures of their morning turd and the porcelain god. It's like, holy Pete, people, you know, do
Yeah,
not.
Smoking Baby talks about the municipality,
Mhm.
how they own the address. I remember that, and then
Right.
how to go back and go to the post office and then fix
It's
your.
not the post office. It's the general post. It's two different places within one.
All
There you
right. Well, I'm not that smart yet.
Yep, you grant
I
it back
appreciate it.
there, and what you do is you tie it to an assumed business name and then ship that son of a bitch back over there and go, there's your foreclosure. Go foreclose on that PO box. Have fun.
Yep. Exactly.
Because they're not
And you have terms.
foreclosing on the house, which is funny. They're foreclosing on the address. So what you do is you tell them, hey, I still own the land. Because see, they're marketable title. They'll tell you that at the sheriff's sale. So what you do is you get a hold of them and tell them, get your fucking building off my land. You have 30 days. I'm going to charge you $100,000 a month. If you don't get your building off my land in the next 30 days, I'm going to send you an invoice for 100,000. And what ends up happening, because the bank's the one foreclosing, right? It's not necessarily the county. So you put the bank on notice. And so once you start racking up a bill, because it's all about notice and opportunity. And then of course they stipulate by their silence being acquiescence because they foreclosed on an address. They didn't foreclose on the land. All right. And so you still have title to it. and they know you have title to it. That's the funny thing, because if you didn't have title to it, then the sheriff would tell you at the sheriff's sale that you can get title insurance on it, but you can't. They're they're actually stealing your property. And what they do is they come by way of force and they say that you voluntarily left. And then 30 to 60 days into it, they drive by the property and they deem it to be abandoned. Well, they're in the business of making sure that asses are in seat, because asses that are in seats generate tax revenue. So they want to help the bank resell it again because that generates more tax revenue. That's what it's all about. So as soon as you remove your property from the tax roll, they leave you the fuck alone. And in order to remove from the tax roll, you have to tell them that they're maintaining a record in there. There is, and so you have to, like, for example, the Department of Revenue for Nebraska, I acquire a property. They want me to fill out a specific form for tax purposes to declare the commercial value of the property that will no doubt increase in equity. You will have equity in there, sir, because those buildings appreciate value. I've been in construction all my damn life. You know, you've got the appreciation value from when you first install siding, but at every year after that, there's a deduction because of the deterioration. So things like houses don't appreciate in value. In fact, they're a liability. You want to know what appreciates in value? You want to know what the real asset is in a transaction when dealing with a home? Is the paper. They don't want the house. The house requires somebody to live in it, take care of it, maintain it, upkeep. That's not an asset. That's a liability. It's the paper that's an asset. That's
Someone's
why
living in your
wealthy people
house.
put Picassos and Rembrandts and Stradivarian, violins on the wall and shit, because they require minimal maintenance and they accrue in value and they become more precious over time. That's an asset. A house is a liability. You got to keep it heated. You got to fix the plumbing. You got to fix the roof. You got to maintain the yard. You think a bank wants to do that shit? Fuck no, they don't. You know what they want to do? They want to kick your ass out so they can get somebody else to sign another note so they can sell themselves another product known as a mortgage and provide another service. The paper is the value. The asset is the security that requires minimal maintenance and minimal attention, that pays dividends and derivatives month after month after month, year after year after year for the next 35 to 45 years. And that's how.
The interesting thing about my foreclosure was that throughout the entire court process, they were foreclosing on the real estate property. But when it came to the order for the sheriff to remove me, it was to remove me from the meets and bound of the land.
Oh, the meets and bounds. Oh, there you go.
Yeah. Well, here's the thing. They can't remove you from the meets and bounds because the meets and bounds weren't part of the real estate. They'll say it's the
APN.
immovable fixtures is what they'll say, but here's the whole thing. You turn around and tell them to get the house off your land or pay me.
Oh, shit.
And they think you're crazy when you do that because they ain't never heard of nothing like that. But that's the reality of it. Get your fucking property off my land. You foreclosed on the address that's attached to the house that meets the fixtures and fixture filings. Fine, so be it. Get your shit off my land. You have a
Banks
call.
can't own land; they can only own the home. So that's why
That's
you could
right.
tell them to get the home off your land.
Yep. And if you won't, and they can't, first of all, and they won't. But what you do is by giving them notice that you're going to start billing them $10,000 a day or $100,000 a month, and you're going to start invoicing them. And guess what? When you issue the invoice and they dishonor it, UCC 3-505, notice of dishonor. They
What was
dishonor.
that?
UCC 3-505. They're in dishonor. You send them an invoice, they have to perform. They have to perform.
I have a question. What if you have a property that was never mortgaged? Like I have family, like it's been in the family for years. My granddaddy built it from the ground up. I've been trying to figure out how to get it off the tax assessor's roll because I know we shouldn't be paying no taxes on it. It never was mortgaged or anything like that. He built it.
I don't know if our brother Joshua is still on here, but years and years ago, uh, he embarked on calling forward the letters patent. He did it a little differently than um, what I
Ron
learned.
Gibson.
Well, he did it a lot different than Ron Gibson. I don't think he followed exactly Ron Gibson because what he did was, if my recollection serves me proper, he went to the Bureau of Land Management and all he did was get a certified copy and then of the meets and bounds. And then he went down to the Register of Deeds and she took it back in the back and um, she circled and marked out the area because a letters patent can encompass multiple houses in a town or even multiple acres, and you don't want to trespass on somebody else's claim because then it could invalidate your claim, and then you could be paying damages and stuff. So you want to be careful about that. Anyway, they marked it out for him, and then I can't remember. She said that you need to take it to the county recorder, which is also the comptroller of the currency, which is funny in the county, at least in that state, and um, and then after that, um, the girls were gossiping like hens or whatever. He's like, "Wow, we're really doing something here." And then she handed it the comptroller of the currency, the county recorder, turned around and handed it back to him and told him that he needed to go see the treasurer. So that was very interesting. I don't know the rest of the story, what he did. I know that he follows through with things. He was on here earlier and he was talking to me yesterday morning about 6 a.m. and he's done some other things where they sent him his free set of plates for his automobile and stuff and don't charge him and he says it's nice when the cops pull up behind you and they get right up on your ass and then they hit the brakes uh, like they're running into a head-on train and just do everything in their power to get away from you. I was like, yep, that's the power of being outside their jurisdiction and they realize that there's a lot of liability being too close to you. They could get real hemmed up for causing you harm, damage, and loss. So,
Well,
I
do
don't.
you know anything
May I
about? Do you know
may I real
anything about
quick?
established? Go ahead.
Okay, so what we've been working on uh with about 5 parties. Three of them are in California, one's in Montana, and one's in Idaho. On the different phases of the obtaining the land patent and bringing the land patent forward. What makes the land patent so powerful is there's no exclusive reservation or implied reservation to any county or city or jurisdiction. And when they try to impose and bring out, uh, operators of drones flying over the property and then, trying to bring in code enforcement and all this other stuff, these counties are finding out they don't have jurisdiction to do that anymore. And so one of the things is that researching Ron Gibson's stuff, there's a lot of things that were wrong with Ron Gibson's process. The premise is, look, if you want to do a petition for declaratory relief to get the court to recognize in federal court that, hey, is this land patent, letters patent that was signed by Woodrow Wilson in 1914, is this still valid? And all they're going to do is basically confirm that the letters patent is valid. And so when you realize that they 1948 they started developing the Torrens land records, where they did away with the land offices and started creating the county recorders. All these county recorders have buried all the information, and the title companies don't even want to touch it. The fact that, in rural areas in the West, especially the West, all these properties are under land patents. When you get into like Los Angeles and San Bernardino and stuff, it gets a little bit rougher to do it because they're tract homes. They've been built by builders and everything. But when you're in a rural area like Yucca Valley or the North San Juan up in Northern California or Marysville or Nevada City or Grass Valley in that area, it's easy to get that identified. And one of the most aggressive counties in California is Nevada County. They've been going hog wild on everybody, especially with the fact that California passed this cannabis laws. And of course, everybody and their brother grows weed up in Nevada City and Grass Valley. In October, November, you walk around that city, it smells like skunk everywhere. So these people have proven, and one of the guys is a 85-year-old architect. And this guy built a 5,000 square foot house back in the mid 70s. And when he started working there, when he started building this home, he'd already built like 300 homes, you know, 50, 100 strip centers, all development, architect, builder. So they came back after him in 2022 for a permit that was pulled in 1976 for a septic tank. At the time that this permit was pulled in 76, there were only two people working at the code enforcement area. One guy was the inspector, and the other guy was the office guy. They didn't know what their ass from a hole in the ground. So this guy was threatened of $1,350 per day from the time that this happened, and since 2022. So he met with the people at the county and said, "Hey, you want to continue to move forward with this? I'm going to file suit in federal district court." And they thought he was bluffing and everything, and he did it. And then when they got served the next day, I mean, I saw all the pleadings, the writings. Guy did a great job. The next day after they were served, they were pleading with him to come back in and sit down and settle. So they settled, and two more people that have been involved with this code enforcement are in different stages right now of settlement. But yeah, this land patent stuff is very important to understand. And one of the guys that I work with, Kevin Michaels, I think Derrick knows who he is. He's one of the best pleading writers and researchers that I've had the privilege to work with in the last 45 years. I've been doing this since about 1980, so I've seen a lot of people's work product and notice their method and try and convey it. He comes on our jurisdictionary courses occasionally, not all the time, but he was on Friday, and it was a really, really good one for a case that was just absolutely complex. I mean, it was just unbelievable to figure out. But anyway, so yeah, understanding these land patents, and I believe Ron Gibson had like 3 or 4 different flaws in his process. So yeah, if you want to maybe learn more about it, I would
Well,
suggest.
I've looked at Ron's stuff. It's kind of complicated, but I was thinking about something a little bit more simpler, like transferring the house over to the family church or declaring the family house as the family church.
Do a counter lease then.
Yeah, because I heard that basically if you transfer the property over to a church,
You
Counter
can
they
be your
tax
own
you.
church.
Yeah, my own church, basically. Yeah, because
Yeah,
I'm a
you
minister.
be your
I
own
was trying to.
church and then you put it in
Mhm.
a ecclesiastical trust, but you want the land patent and a allodial title. They can't come on your land. They can't do anything because you own everything above and below.
So even if I do the church thing, I would still have to get the patent,
You
basically.
have to
Well,
have the land patent.
you
You
have to
own
understand
everything
something.
above and below.
You have to understand something. If you have a meter on your property, if you have an electrical meter on your property, that's an easement.
Oh.
You're granting access to the electrical provider to have access, and that carries
To
over to
stop
the.
that, all you have to do is order your own meter, and that
Mm-hmm.
kibosh on that.
Yeah, exactly. But
Where do you order a meter from?
Wherever they do.
Online, get rid of those damn digital ones. They're nasty little
Terrible.
fire hazards and dangerous as fuck. Everything
We
that
don't
they
have a digital one yet. I stay in a small country town,
that
so they
you
haven't switched
mostly
over.
analog. Yeah,
Yeah, we still
they haven't
Analog.
gone over to analog. Yeah.
Yep.
yeah.
Hey, Thomas, you were talking about the different reservations. You said implied reservation and what else about land patents? You said, is that what you said? Implied reservation?
A reservation for the county or the city to have any right to tax the property, implied reservation or
Mm-hmm.
explicit reservation.
Explicit. Okay.
And all the patents we've seen, there's nothing on them. I mean,
Okay.
I probably looked at 25 different land patents in the last 12, 15 years, and not one of them has any exclusive reservation or implied reservation to any city, county, townships, or state for any type of taxation whatsoever.
Really?
So for
Yeah.
clarity, I need to go to the BLM to check on the land patent and the allodial title.
What state are you on?
I'm in Georgia.
No, you're not in Georgia. You're on Georgia. See,
On
that's
Georgia.
the mental block. You didn't go through a wall to get into Georgia.
All right,
You're
I had
on
that same
Georgia.
problem too.
Well, I'm
Now,
actually on my land, but I mean, technically, it's located in Georgia.
Georgia, there's an issue with Georgia and Alabama
Uh-huh.
and Mississippi. Florida, there's a lot of land patents in Florida. But yeah, contact the BLM. I think the office you need to contact is in Richmond, Virginia. BLM office.
Okay, thank you.
You're welcome.
Is Montana that bad too, or is it?
No, Montana, we're having great luck up there. We've got a couple of surveyors up there that know what they're doing.
Oh, okay. That probably
How
makes sense.
about Texas?
Texas is a pretty good state. I mean, Texas is huge, man. It's huge.
Texas is real easy to get land patented because all of Texas land is already patented.
Yeah, it's already Texas has a land office. I mean, you contact the Texas land office, they're some of the most helpful people. You know,
Okay, thank you for that.
Oh, awesome. Thank you.
yeah, because Texas has found a new oil, right? The new oil is three-blade wind turbines, which are, killing 360,000 raptors in Texas alone in 5 years. That's why these utility companies pull what's called taking permits. They're allowed to so many kills every year.
Yeah.
How about getting the land patent in Long Island, New York, or on Long Island, New York?
That's probably next to impossible because there was never any land patents issued up there. I believe. I don't know. I've never done any work. I would say in Albany, Rochester, Buffalo, there'd be more of a chance. Syracuse,
Yeah, you have to understand the reason that the letters patents were issued was because they were trying to get people to migrate westward so they could colonize.
Yeah.
And they were incentivizing people to go west by saying, that they would be kings without subject. They would own land, not be part of the feudal system. And it was all a plot fomented, as you could see, with the conversion of the Constitution to get people to float their form of, their corporation, essentially. So you're invested in their corporation. And if you listen recently, I heard something the other day that the Trump administration is pushing to the United States to be an investor in businesses and shit. That is the beginning of
total fascism.
Yeah, fascism, socialism mixed with Marxism, all simultaneously combined into one.
Why don't people see it? I guess I don't know. I don't know.
Because they don't read history, and history tends to repeat itself because of that.
Yeah.
Yeah.
I mean,
when you look at the amount of energy that's displaced. I was watching Simon Michoud. He's a phenomenal guy, but anyway, to get a grasp on how much armament and tanks has been lost in Ukraine. 25,760 something tanks and armored trucks have been destroyed in the 3.5 year war in Ukraine.
And they
Now,
don't.
these were all claims of these weapons being game changers, right? The amount of energy that would take to build that many tanks is equivalent to the production of all the energy on this planet for 2.5 years. I mean, it's like unfathomable. You can't believe it. It's just unbelievable. And they still want to sink money into this piss ass campaign. They think they're going to break Russia up into 9 different countries, steal the 112 million or 112 trillion dollars in assets, and put Putin off the. It's nuts. The insanity of these people, Ursula von der Leyen, and all these psychopathic maniacs, man. It's just unbelievable.
That's because good men won't do what psychopaths will do. Psychopaths will destroy the world and smile and never have a second thought of it. And a conscious man has.
Understanding
Yeah.
that a hectare is 2.4 acres, right? A hectare. So imagine this 61,000 hectares of cemeteries that are developed now in Ukraine.
Mm-hmm.
61,000 hectares. That's over 120,000 acres of cemeteries.
Kind of like all the private prisons in America.
Yeah.
We have 5%
more dead than alive, right?
Largest prison population out of everybody.
Disgusting.
And then of course people don't band together to do anything about it. Most people are passive aggressive. Hey, I'm all for you, hurrah, hurrah, but it doesn't directly affect me, and I'm passive aggressive. I'm just going to go along, get along, and then 6 months later they call me. My nephew is a really good young man, and they are just trumping up allegations against him. I said, yep, it's better to be proactive than reactive. I'll tell you right now. Well, can you help him? No, because he will. The amount of knowledge that I would have to download and dump into his brain, unless he's willing to really commit, just tell him to make a deal and sign the deal and do the probation or whatever else.
Yep. Okay, hold on 1 second. I'm going to stop this. It's 2:45 a.m. Pacific Standard Time, 11/2 of 2025. I'm stopping. And we are now recording. It's 2:45 a.m. on 11/2/2025, and we're back at it.
So I'm going to go and show you guys how the Lieber Code ties into all of this. All right. You have to understand that Abraham Lincoln declared a war. They euthanized him before he executed the proclamation to end the war. Therefore, since Abraham Lincoln, we have been in a perpetual state of war, which is martial law. And I'm going to prove it to you right now in the Lieber Code. Now, when you bring this up in court, they get all antsy about it. Now, that doesn't apply, blah, blah, blah. Yes, it does. We can prove that it does because you're operating outside your territorial jurisdiction. And the only way that you could possibly be doing that is by implementation of martial law. So we're going to go look at 45. All captures and booty belong, according to the modern law of war, primarily to the government of the captor. Prize money, whether on sea or land, can now only be claimed under local law. All right. We go to 55. The states, if a hostage is accepted, he is treated like a prisoner of war according to rank and condition as circumstances may admit. So the states are operating under this right here. Okay. Everybody's being treated as a prisoner of war. A hostage is a person accepted as a pledge. What did they do at birth in the township ward maternity hospitals of 1921 to the present day? They pledge your precious valued time commodity into the futures market so they can borrow against your future labor because you are a asset or collateral that they're going to use your future tax labor, right? So a hostage is a person accepted as a pledge for the fulfillment of an agreement concluded between belligerent enemy combatant of the United States during the war or in consequence of war. Hostages are rare in this present age. Well, that couldn't be further from the truth because in order to get the birth certificate, that was had by an ancient system of pledging. Colonel House, Edmund House, was the one that said that. Now, whether or not he said it, I have no firsthand perfected knowledge. But if you go read his speech that he purportedly stated to Woodrow Wilson, and Woodrow Wilson, imparting office, said that he single-handedly destroyed the nation he loved and handed it over to a handful of greedy bankers. If you read Colonel Mandela House's speech, he says very soon the American people will pledge their biological material in an ancient system of pledging and will become wealthier than ever and should we incur a loss, the insurance will cover it, and it should one in a million ever figure it out, we'll have in our arsenal plausible deniability. So anyway, as you guys know, bankers fund both sides of the war. The winner of the war pays for the spoils and losses that the losing party incurred by losing the war. So, in other words, the bank funds both sides, and whoever loses doesn't matter. The bank still wins because the winner has to pay the debt of the loser. So we have a hostage is a person accepted as a pledge. Well, in order to get that birth certificate, there was a pledge made, okay, by an informant for the fulfillment of an agreement. So that pledge was an agreement included between belligerents during the war. You're considered a belligerent enemy combatant, and the proof that this is a battlefield is in, I think it was in 2013, Lindsey Graham said, very soon, the homeland is a battlefield. And then right after that, Justice Scalia stated before his untimely demise, very soon, United States citizens will be gathered up and put into FEMA camps, which is a political correct way for saying concentration camps. And so when Lindsey Graham said he declared the homeland a battlefield, this would explain to you why every post office flies the prisoner of war flags. You guys ever find that to be odd? Every post office flies a prisoner of war flag. That's because the homeland is a battlefield.
And it's black. And the other funny thing is a black flag.
Yeah. So when understanding this and understanding what the birth certificate is and how it's acquired through the application, which is a pledge through the ancient system of pledging, and this is the state participates in this, okay? And the state also participates in this, all right? Which fulfills 45, which is going to be the federal government. Well, the United States. All captures and booty belong according to the modern law of war primarily to the government of the captor. Prize money, whether on sea or land, can now only be claimed under local law. So when I pointed out earlier there's no judiciary, they didn't take the Article 6 oath. that they expanded their footprint, and now you have martial law. Everybody that wears a patch of the United States flag with gold fringe is a participating member of the armed forces and militia. That is the organized militia. Now let's think about who all wear those flags and those patches on their uniforms. Sheriffs, local PD, state troopers, SWAT team, National Guard, Army, Navy, Air Force, every last one of them. They're all part of the regulated militia. Okay. To further conclusively show you this, in order for Article 32 to be fulfilled, Article 38 must happen. So, 32, a victorious army by the martial power inherent in the same may suspend, change, or abolish as far as material power extends the relations which arise from the services due according to the existing laws of the invaded country from one citizen, subject, or native of the same to another. The commander of the army must leave it to the ultimate treaty of peace to settle permanency of this change. In other words, in order to end the declaration of war, the commander in chief must either enter into a peace treaty agreement or a special proclamation. Okay. Well, when they did the Civil War, the war between the North and the South, because the South didn't want to buy the shit the North was selling, it was junk. And then Abraham Lincoln ended up getting excommunicado and euthanized. He never had the opportunity to end it with a proclamation. I think that was part of the reason the Jesuits whacked his ass, was because they could create this perpetual state of war and keep martial law implemented. Now, if we look at 38, this is where your indemnification certificate shows up. Article 38, private property, unless forfeited by crimes or by offenses of the owner, can be seized only by way of military necessity for the support or other benefit of the Army or of the United States if the owner has not fled. The commanding officer will cause receipts to be given, which has which may serve the spoliated owner to obtain indemnity. So your birth certificate is an indemnity certificate. All right. The property, unless forfeited by crimes or by offenses of the owner, can be seized only by way of military necessity. When they're taking your automobile on the side of the road for not flying the state's flag or whatever, they're doing that under martial law. And that's why they're not giving you just compensation. All right. For the support or the benefit of the Army or of the United States. Who does it benefit when they take your property without providing you just compensation? Them. The tow truck company gets paid, who's in cooperative agreement with the city and the county. The police officer is going to get paid because he's issuing a citation, possibly arresting you. Then the court is going to file a complaint security, so they're going to get an advance from the Treasury. Happens within 72 hours of lodging the complaint security, launched with the citation. All right. And you're the only one that isn't getting paid. So, with that being said, you were denied due process of law. They didn't grant you a pre-seizure hearing. They didn't grant you a post-seizure hearing, which you're in charge of scheduling the post-seizure hearing. If you schedule a post-seizure hearing after they take your shit, they will return your shit because you're going to nail them right away on the fact that they didn't have a pre-seizure hearing, which is denial of due process of law, violation of the Fourth Amendment. And it says right here in the Libra Code under Article 38, private property unless forfeited by crimes or by offenses of the owner. That comma is a full stop. So unless they have evidence that you were engaged in a crime or an offense of the owner, they have to release your property back to you. But right here it says, which may serve the spoliated owner to obtain indemnity. That receipt that they're talking about right here. The commanding officer, which is the commander in chief under the executive branch, will cause receipts to be given which may serve the spoliated owner to obtain indemnity. Now, let me know if you can see what I'm about to put back up over here. Now, you should be able to, and let me do this real quick because it's going to take a second.
Supplemental.
Yep, 1 second.
Yep, I know exactly where this is going.
Yeah. The sharpest tool in the shed by hanging around some really intelligent motherfuckers. So now that you understand the Libra code to a degree, oh, we forgot one fucking thing. Hold on. Can you guys still see the Libra code up there now?
No, we see
Why does it do
411
it?
stat.
How do I share
65th Congress.
How do I share that screen? So it's just that screen. Oh, bear with me. We will let's do it this way. All right, I forgot to show you the most important part. Now you should see the Libra code up there. So we got Article 38. That's your indemnity. Yep. Article 32. In order for Article 38 to come into fruition, where you're getting your certificate of indemnity, Article 32 had to have occurred. A victorious army, by the martial power inherent in the same, may suspend, change, or abolish, as far as the martial power extends, the relations which arise from the services due according to the existing laws of the invaded country from one citizen, subject, or native of the same to another. Okay? So, in order for Article 32 or Article 38 to come to fruition, Article 32 must have occurred. And in order for Article 38 and 32 to have occurred, that means that
Article 11.
Article 2.
Oh, Article 2.
The law does not cease during a hostile occupation except by special proclamation ordered by the commander in chief. They're telling you right here, the commander in chief in the executive branch. No president since Abraham Lincoln has issued a special proclamation to end the Civil War, and there has been no order under executive fiat by the commander in chief to enter into treaty and end hostilities, or by special mention of a treaty of peace concluding the war when the occupation of a place or territory continues beyond the conclusion of peace as one of the conditions of the same. So when you guys look at this and understand, I believe it is 45. All captures and booty belong according to the modern law of war primarily to the government of the captor. Prize money, whether on sea or land, can now only be claimed under local law. This is very, very important because this is going to be your federal government. This is why they're subjecting everybody under the laws of the United States. And they pretty much abolished the republic and they talk about democracy, 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 democracy. This is why. Okay. They pretty much smothered out the republic. So you said 11? Let's see what 11 says here. Been a while since I went down this road, studying this stuff, probably 6, 7 years ago. The law of war does not only disclaim all cruelty and bad faith concerning engagements concluded with the enemy during the war, but also the breaking of stipulations solemnly contracted by the belligerents in time of peace and avowedly intended to remain in force in case of war between the contracting powers. Yep. I like 38. 38, 34. Yeah.
Yeah, there's the churches.
And here's why, because I'll show you why in just a second. And if you notice, the the one with the churches that talks about the churches and everything that is in
34.
34, that's correct. That almost mirrors and mimics Article 1, Section 8. What is it, Clause 7, that talks about churches and the USPTO essentially talks about all that. So you guys can see how this all is intertwined and laced together. It takes years and years to kind of see it. I haven't studied the Libra Code forever, so I'm not going to pretend to have it all memorized anymore because I don't. All right, so then we go back to 40 Statute at Large 411, Section 7E. And the reason that I want to point this out is because we just learned in the Libra Code number 38 that when the hostile military force has persevered, that when they take all the property from the people, that they have to issue a certificate, and that certificate is a certificate of indemnity. Now, it says no person shall be held liable in any court for or in respect to anything done or omitted in pursuance of any order, rule, or regulation made by the president under the authority of this act. Okay, this is the Trading with the Enemy Act. When they're talking about the president here, they're talking about the commander in chief under the executive fiat and executive order. Any payment, conveyance, transfer, assignment, or delivery of money or property made to the alien property custodian hereunder shall be a full acquittance and discharge for all purposes of the obligation or of the person making the same to the extent of the same, the alien property custodian, and such other persons as the president may appoint shall have the power to execute, acknowledge, and deliver any such instruments or instruments as may be necessary or proper to any such to evidence upon the record or otherwise such acquittance and discharge. And this is very, very important. When we get down here to the bottom, it says the president shall issue to every person so appointed a certificate of the appointment and authority of such person, and such certificate shall be received in evidence in all courts within the United States whenever any such certificate of authority shall be offered to any registrar, clerk, or other recording officer, federal or otherwise. That's a big blanket statement when it says federal or otherwise within the United States. Such officer, such officer shall record the same in like manner as power of attorney, making you the attorney in fact, and such record or a duly in like manner,
A duly certified copy.
Duly certified copy thereof shall be received in evidence in all courts of the United States or other courts within the United States. Now, when you listen to that and you understand what that is the birth certificate. And one of the reasons that it was issued to you is because we're in time of martial law. And so what they did was they had to issue the peaceful inhabitants that can't flee and don't have anywhere to go under 38 when they took the private property Private property, unless forfeited by crimes or by offenses of the owner, can be seized only by way of military necessity. Now, the law of necessity is important to understand. The law of necessity is a maximum under military force. Under military force, what I mean by that is might is right. So there's a maximum that says necessity trumps the law. Okay. And necessity makes the law obsolete. In other words, you have the right to forage for food, even if the way that you go about foraging for food would be considered unethical or immoral. Necessity trumps the law. So, in other words, I don't need a license to go hunt a deer, an elk, um, you know, birds or whatever the case may be. If I'm hungry under the law of necessity, I have the right to forage for food. I can go fish, I can do that, and none of it requires a license. All right. So the law of necessity trumps the law. Necessity trumps the law.
Law of necessity.
Yeah. So can be seized only by way of military necessity or the support or other benefit of the Army of the United States. If
Or
the
of the United States.
Yeah, yeah. Uh-huh. If the owner has not fled, well, we don't have anywhere to go, do we? The commanding officer, that would be that would be the commander in chief under the executive branch. The commanding officer will cause receipts to be given, which may serve as spoliated owner to obtain indemnity. That is why when you turn over the birth certificate into the court, they're supposed to zero balance the case. So you take 40 statute at large 411 section 7E, which is a statute at large. It is legal evidence of the law.
Self-authenticating evidence.
What's that?
Self-authenticating evidence.
Yep. It only need be mentioned. You don't even have to subpoena it into the court, which is beautiful. You combine that with Article 38, Article, is it 32 or 34?
32.
32. So in order for 32 to come to fruition, or excuse me, Article 38 to come to fruition, Article 32 has had to have already incurred. Well, it wasn't 32. It's 31. A victorious army appropriates all public money, seizes all public movable property until further directions by its government, and sequesters for its own benefit or of that of its government all the revenues of real property belonging to the hostile government or nation. The title to such real property remains in abeyance during military occupation and until the conquest is made complete.
Yeah,
So
that'll be on the 32nd day of the month of never.
yeah, it's Article 38, Article 31, which is why they issue the birth certificate, because that's your indemnity certificate, because during a military hostile takeover, they're in constructive possession of everything. And that proves that Article 2 never happened. Martial law does not cease during the hostile occupation except by special proclamation ordered by the commander in chief or by special mention in the Treaty of Peace conducting the war, concluding
the war
when the occupation of a place or territory continues beyond the conclusion of peace as one of the conditions of the same. So, because of Article 31 and Article 38, 38 and Article 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 38 and Ar Yeah, Article 31, Article 38 could never come into fruition if, in fact, Article 2 was not still true. And that's how that explains it.
Yep.
And that's why we have our indemnification certificates under the Lieber Code, is because they had to issue the inhabitants indemnification, free passage certificates. So some people say that the birth certificates are safe passage between ports, certificates, things of that nature, but there are indemnification. I just proved that to you in 40 Statute at Large 411, Section 7E, which is the Trading with the Enemy Act. And then you turn around, go to Lieber Code, and it explains why and puts it together. So there's that. And then, of course, I showed you that they're doing everything under supplemental rules for maritime admiralty claims and asset forfeiture actions. So they're taking people into
Right.
into voluntary forfeiture, and people are forfeiting their rights, titles, and interests. It's happening. And it's all being done under the DOD. Let's see what this one is. Yeah, got it. Let's see here.
Oh, is that better?
That civil forfeiture they be talking about. They'll do the civil
God.
forfeiture.
Well, the forfeiture of all the property, and then of course, because you're the creditor, and you have the indemnification certificate, and they're debtors, and they owe a very, very large debt. They're using your exemption, or trying to generate funds. That's how they're floating this whole thing. This is how they're sending all this billions and billions and trillions of dollars everywhere and blowing shit up and leaving $800 billion worth of weaponry to the Taliban and funding all these black projects and shit like that, as they're hypothecating we, the creditors, credit into existence and shipping over to allies and doing their own thing with it. And what they're not doing is taking care of the people. This is one of the reasons they got rid of Gaddafi. You know, over there, if you got married, they bought you your first house, and you had time to bond with your wife or whatever. Then when you had your first child, I think the maternity leave was for both mother and father. And I think they gave you like 8 or 9 months to bond with your offspring. And then not only that, but also free education, so on and so forth. Well, they were leading by example, and Gaddafi was getting ready to, unionize the African continent, and that's the United States' greatest fear. And then they were going to change the currency to be gold-backed currency. Well, Africa is one of the wealthiest land masses throughout the world, and everybody knows it, but also highly uneducated for the system that the Europeans have created, and they like it that way because then they can utilize psychological warfare and usufruct to keep them impoverished and keep them doing the things they want so they can extort them for their minerals and shit. It's such a fucked up place. It's fucking I think you gotta earn your way to heaven. I think we're already in hell, and you gotta earn your way out of this shithole. I really do.
Gaddafi was going to start the gold back to NAR, which is going to basically evict the French monopoly on the currency down there. And of course, he also built the largest aqueduct system in the world, and was I mean, what he did, if you couldn't be healed in one of his hospitals, he would send you to a hospital in Switzerland or Germany, your whole family, everything paid, airfare, send you to school, get you a car. Yeah, but now Abraham Traore and the other people, the Solari, or the Sahar group are kicking ass. I mean, the Burkina Faso, I think, has produced uh, nearly 11,000 tons of gold in the last 2 years, and the primary buyer is China. They're paying, the price that Russia established.
That's what happens
5,000
when the United States comes in to implement democracy in your neck of the woods.
5,000 rubles per gram, which has gone up to about 11,800 rubles per gram of gold now.
Wow.
And of course, Venezuela is sitting on the equivalent of about 160 trillion barrels of oil. Now, known reserves, there's probably another 15 trillion barrels of oil that they haven't yet discovered down there.
Hey Derek, when they came and took money from me with the silver forfeiture, they had it where the money was suing me, like the money versus me, you know. That didn't make sense to me how they had it where the money was suing me.
Well, when Cool Fox and I do this financial class, all of this stuff will make a lot more sense. Um, Especially the indemnification certificates, the special supplemental rules for maritime admiralty, 40 statute at large 411, 73rd Congress first session volume 77. When I start putting all that together, all those puzzle pieces together for you guys in a magnanimous fucking PowerPoint, because that one will have to be very, very detailed and specific. It will prove to you that you're the creditors and that your notes, drafts, bills of exchange, bank acceptance, trade acceptances are the new money. And we'll go into 31 CFR 357 and rip through 31 CFR 31 USC. We'll rip through the federal table of authorities, and it'll show that the banks are required when you scratch on a napkin $10 million and you hand it to them, they are required to deposit it in your account, but they deny you. And it's in part because all these little banksters are so compartmentalized, they don't know their ass from the hole in the ground. And so you have to sue them, which is really shitty. The whole system is predicated on creating controversy and perpetual war. One, to discourage people from trying, and two, to keep the people who are attempting to ascend to the mind from doing so and making it very tiresome. One of the things that you're going to do with finances is you have to let all these agents and agency know who you are. They don't know who you are. And that's one of the struggles. The certificates of beneficial ownership at the DTC and the DTCC. Then you've got the certificate of identification for the Treasury Department, the SF. Is it the 221 and 223 forms need to be filled out. Then, of course, the Office of Foreign Affairs needs to be put on notice as well, because that's where the alien property custodians authorities now are seated. That's the other thing about these courts, because they're all EDGAC corporations. We should be reporting them to the Office of Foreign Affairs in the Treasury Department, because they deal with money laundering, racketeering,
fictitious obligation, debt bondage.
Yep. And then the DOJ should be put on notice under
The big
Executive
thing,
Order 13818 and 13909 to freeze the asset of every alleged judge, every alleged ministerial administrator, for human trafficking persons, and kidnapping and bear train, all that shit.
Well, that Executive Order 13844.
I'm not familiar with that one. Let me have it. Let me hear it. What do you got?
Executive Order 13844.
Oh, I thought you said, yeah, you did say 13844. I was talking about 13818. 13818 deals with the trafficking of persons, automatically grants rise to the freezing of all accounts.
Oh yeah, that too. But 13844 talks about the uh, financial frauds committed against the American people.
Yeah.
It says it right in there. It says the American people, and that
Right.
the assistant U.S. attorney for the civil division, which is Harmy Dillett, she's a lawyer out of California. And then of course with that wonderful lady, I Am the Queen, with her AO 91 course, which incorporates the Executive Order 13844, going to a JAG official at, either Luke Air Force Base in Arizona or Dill Air Force Base or whatever. So I don't know if
Well, it's
anyone's
Luke
seen
Air
anything.
Force Base. I was actually born on Luke Air Force Base. Maybe I need to crank out one of those AO91s. That's what makes
AO91 is a one-page document, man. It's a criminal complaint.
Being born on Luke Air Force Base.
Yep, it's quite a place.
The nice thing is, I thought I was born on a federal territory, only to find out while I was out there in 2013 that a little old lady leases Luke Air Force Base to the government. Therefore, I wasn't born on a federal territory, which is nice.
Yeah, a little old rich lady.
Yeah, they fired up the jets at 3:30 in the morning and pissed her off, and it was on the news the next morning at 6 a.m. 70-year-old so-so calls up a full-blown colonel and told him, if we're not at war, I suggest you shut those jets down unless you want to lose your lease. And they grounded all the planes. I thought it was funny or shit. They were doing some type of 3 a.m. exercise. She's like, not today, Scooter. Unless we're at war, I suggest you shut down those planes if you like your lease. And they said, yes, ma'am, right away, ma'am.
She's had that lease since 1951.
That's fucking cool.
She's a Mormon too. That's funny. The Mormons own so much land out in Arizona. It's pathetic.
It's wild. Yeah. That is one interesting organization. I have a friend that's a Mormon, and I'm fascinated by architecture, and they have some amazing buildings, and I wanted to check them out. And he's like, well, you can purview the outside, but you can't come in. I'm like, are you fucking kidding me? He's like, I'm dead serious. And I was like, you do realize that I'm a stonemason, right? And I'm fascinated by the architecture and shit. And he's like, it doesn't matter, dude. You cannot come in this building. I'm like, I'll be damned. It's kind of weird. Very interesting.
Yeah, the Catholic Church is the #1 property owner, and Mormons second.
Yeah. Let's see here.
Hey, Derek, will you also have a class where you'll be showing us about how, I remember I talked with you one time before, you were saying that the warrants were like checks and how anytime they issue a warrant out on you, it'll be a check.
Yeah, we just went through that just a second ago. The PIP call. Yeah, it's a put call. It's a capias. A true warrant for the body is called a warrant of committal. So when they say they're issuing a warrant, it's a capias. It's an in rem action. They're looking for a thing, which is the juristic person or the United States vessel, the birth certificate, the driver's license, the social security card. That's what they're after. That's what they're after.
Well, I had a warrant where it's like I was it was a traffic ticket and I didn't sign it or anything like that, and they let me drive off. But the police officer went to a magistrate and got a warrant, and they just like tagged the car. And when I went through a certain area, a tag reader caught that a person of interest was in a car, and they dragged me out of the car. And then they or actually opened the door, told the door open, and pulled me out and hauled me off. And I even got a copy of
You want
that
to know what
warrant.
makes you subject to that bullshit? Is because prior to you getting a driver's license or a state ID, all they would have had was a name. But then we go and we fucking put our stupid ass fucking engraven image, which is a violation of the freedom of religion, and it violates our religious principles. And we put an engraven image on a piece of plastic that they put in a database. And then every time they run that name, it's associated with our image. That's how they get people at 13, 14, 15 years old getting a driver's permit, learner's permit, and you take your image and put it on there, and now it's forever in their database. Should have never, none of us should have ever done that.
Yeah, he actually was saying that he was waiting on a picture to come back to identify who the person was. You're right.
Oh, I know. I studied the David system, the AAMVA, the DMV, the BMV, the contractual nexus between the states, and that's what I'm getting ready to bust down for you guys. And then when I do child support, it'll blow your mind because I'll show you all the little contracts they enter into and how none of them have plausible deniability. Child support is actually supposed to be paid for by Congress. They're supposed to cut the check for it. He who creates he who creates the problem must provide the remedy. Well, they created the problem, so where's the fucking remedy? Where's the funds? You know, for example, if I contract you to build me a house and I tell you to be there on Monday morning with 8 guys, you show up on Monday morning with 8 guys, but I didn't supply the lumber. Who has to bear the burden for your guys being on the job site for the 8 hours? Because somebody's got to pay them or you'll lose your whole crew, right? So is it me or you that has to pay your crew? It's me, because we had an agreement. You were going to show up on Monday and you were going to build me a house, but because I dropped the ball and didn't get the materials there, I can't expect you to perform an impossibility. But because we had an agreement, I had to provide uh, the ends and the means, which means I had to supply the materials. And because I didn't supply the materials, your guys didn't work. But you can't be expected to pay your guys when you didn't make any money because of my negligence. So he who provides the ends provides the means. When they created this thing called child support, they also had to provide the remedy. Same thing when they took the gold. They didn't provide the remedy by making it us private, by recognizing us as private bankers and recognizing the fact that we have the ability to create notes, drafts, bills of exchange, bank trade acceptances that are the new money. Then they would have been strung up for treason, which at this point I think they probably should have been because they only stuck to, after 1933, they only stuck to that format for probably about 15 years. And then what happened? 1945, all the people who had any intelligence that knew what the fuck was going on were all put on the front line to go over there and get whacked. Create another war, stick another generation in the public fool system, and they'll never be the wiser. And they'll be trading these frivolous, worthless fiat currencies back and forth that depreciate in value, never being the wiser. I just read the statistic the other day. Was it like 1970? Like 65% or 70% of the 30-year-old people had houses of their own. There are 15.8 million houses that are vacant right now. And I want to say they said only uh, like 15 or 13% of 30-year-olds out there actually own their own home. When in reality, they don't own their home because it's all under mortgages, all that other shit. But nevertheless, they've really run this fucking shithole into the ground. They spent 10% of the energy that they spend on wars and everything else doing something constructive here, this place would be kick ass. Just 10% of the energy that they run around the world, policing the world and destroying shit. This place would be something phenomenal. But as Thomas so eloquently said, a bunch of psychopathic, narcissistic, scumbag piles of shit that scratch their way to the top because they're willing to do anything to get there. And we were warned. This is Lucifer's world.
Can I ask a question? I was going through the comments when I woke up. Somebody said that they denounce insurance and reinsurance. What's the thing about insurance? Did you mention something about insurance?
Oh, yeah. Just talking about how the whole system works underneath the martial law and underneath the banking system. There are only four things in the economy. There's insurance, excise taxes, bonds, and securities. And so there's the assurance and insurance. We are the assurance and insurance that floats because we're the collateral that floats the United States corporate entity. And we are the creditor, but they treat us like we're the debtor. For example, they draw us into their special Star Chambers venues. They draft charges that are tied to penal sums and penal bonds and get an advance from the Treasury. See, we are barred from going directly to the Treasury, which is our bank, and we are barred from going to it, and we are forced to use securities intermediaries. But yet these bar association members will get a hold of our estates, charge them up, and then instead of cutting us the check for the advance they got, and I'm talking like traffic tickets and stuff, a couple traffic tickets could be as much as $800,000 draw from the Treasury. And these rat bastards will turn around and tell you, well, you got to pay a $600 fine for that. $600? Seriously? You just got $800,000 out of the estate. You didn't provide a full accounting. You weren't authorized to make a draw or create a draft to draw upon the Treasury. You wrote a check your ass can't cash. You're not reporting the taxes, so you're engaged in tax evasion, money laundering, and counterfeit United States securities. And you have the audacity to threat, intimidate, and coerce me into going along, getting along because you require my signature to release the credits? And you want me to be surety for the advance that you got? Yeah. It's pretty sad when you really study the finances and see what they're doing. And it's simple what they're doing, but it's complex in the aspect that they keep everybody so compartmentalized that most of the people that are in the banking realm, they can't wrap their head around the things that we're talking about here. They're like, that's not how that works. It's exactly how it fucking works.
Okay, let me ask you a question. So I'm an insurance agent and well, life insurance. I don't deal in the other aspects.
Yep.
So I actually studied like infinite banking with Nelson Nash concept.
Nice.
So is that a bad thing? Because according to like Jordan Maxwell, is that his name? I can't really remember. I'm a little tired. However, he said all the other insurance is fraud. However, life insurance is the only one that they don't push. But now they're pushing it because they're pushing the IUL, which everybody is screaming as if it's holy grail, and it's actually not. It implodes on itself. But no one even pays attention to that. But anyway, so is the whole life aspect of the insurance a bad thing? Because isn't that how like
Whole
Tulsa
is good. Term life fucks people. IUL is absolute garbage and junk, and the people that get into that are like getting into timeshares. They will regret it eventually, I promise. When your newborn is born, the first thing you want to do is go get a whole life insurance policy. You can pay something as 50, 60 cents, 80 cents a day, or whatever it is. And then what you do is you make the trust the beneficiary of it.
Oh
Now,
no, I totally understand. However, being that everything else is like coming out, I'm like, is it because it's muddy in the water for the whole life insurance? Everybody thinks it's the same because they labeled it as permanent insurance. So they put it in the same box. They put ULs, BULs, IULs, and whole life in the same box as permanent. And I keep telling people it's not the same. But
no.
since the internet is everybody is IUL, 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 I'm like, that's the same thing as the derivative market of the stock market.
You have to remember who's pushing that and who's paying for all those advertisements on TikTok, Facebook, BoobTube, you name it. And you nailed it. It's the stock market. They have a financial interest in getting people to do stupid shit because it bolsters profits.
I was a former insurance executive, and the best book you can read or have the people read that you care about is Be Your Own Banker.
No,
And
I literally studied that, and everybody that tries to tell me about the IUL, I have Be Your Own Banker because I'm with the Nelson National Institute. So, that's what we want people to build off of, because like I was saying, this is how Tulsa and all of these other things that they tell you was destroyed, but they don't tell you that your government destroyed it. But anyway,
So
this is
that's
how
why
they built themselves up, because they were mutual company. I mean, they were mutual and they built it up on insurance. But people don't understand that because they're not going to ever tell you that aspect, because that'll destroy the whole illusion that they're giving you about the stock market making you rich.
yeah, you want to
Right.
want to always use a mutually owned insurance company and go for paid up dividends, and that's the whole life insurance scheme that you want. That's the only one to do. And I
And
yield.
that's the reason why you create systems for yourself. Or create, like us right now, we are here right now. We can create our own system in which we generate our own currency underneath that same principle and make it be able to beneficiary to each one of us whenever we have needs that we can pull from from that instrument. It's just all derive on how you guys want to set yourself. If you're looking for a future for yourself, you right now, we have our what, 90 something people in the life. We can do a thing called networking, in where we go ahead and we have meetings and time for it, where we set aside every 3 months meeting where we look at our asset and our generating our working for our benefit. And that same policy, we can use it for any time what we need and issue the currency for whenever we need it. But we have to be faithful to our own self. It's the same thing you can do for your own family.
Well, like a group like this, to get a whole life insurance policy and is to create a trust. And what happens is you make the trust the beneficiary of all that. And then we have meetings. What you would do is colonize a town essentially, and get rid of all the riffraff and run all the fucking gangster thugs, wannabe type fucking asshole political people who think they're Democrats and Republicans, just poof, gone. First of all, to be a Democrat or Republican, they don't even understand that that's a fucking occupation. So you sound absolutely ignorant when you run around saying, I'm a Democrat, I'm a Republican. Really? It's an occupation. So how often are you getting a check from the government again? Oh, that's
Yeah.
right. You're a wannabe. And that's what they want you to be. They want you to think that you are something you are not, because then it's to manipulate you and make you subject to their statutes, codes.
Induce you to make an error against the interest.
So
Pride of life. Pride of life.
well, it's
Right.
something. It's just my mind. But anyway, you colonize an area and you can literally change the demographic, and we can lead by example. The problem is, finding an area where everybody would be happy. But in hindsight, looking at some other structures like the Rothschilds, and also when you study the Rolex family, the family that created the Rolex started out as a for-profit corporation, rolled it over into a nonprofit organization. You don't ever hear about the Rolex family. You really have to do some digging to find anything out about them because they're private. Everything is encompassed into what I like to call like an onion layered trust with LLCs and S corps, C corps encompassed by trusts, so on and so forth. And so they have no direct attachments. It's really hard to find them. They're almost invisible. And it's really interesting to study their platform. And the same thing with the Rothschilds. You know, they create generational wealth, and how they do it is all through insurance policies. And that really is a great way, or you may not see the benefits of it at this stage and this point in your life, but future generations will. It's kind of like planting trees. You plant trees now for the kids 30 years from now to enjoy the shade. It's kind of a selfless act. You will never probably enjoy the shade or the fruit from those trees, but 30 years from now, somebody will. And that's a fantastic way to look at it, I guess. And it's really nice if you've got a family that you can do it with. But most times when you talk about things like this, that's the last thing anybody in your family wants to talk about is create generational wealth for people that they'll never meet, that are part of their lineage. And this is exactly why the Rothschilds are doing so well for themselves, is because every time somebody gets whacked, taken out, loses their life, a huge chunk goes into a trust that is a non-taxable event. And yeah, through K1 disbursements, so on and so forth. So,
but they also practice incest. So yeah, that money just keeps getting recycled to the same
yeah, I'm
family.
not really for that. Yeah, we can, yeah. So I was going to be Johnny Appleseed when I was younger. I was going to have one of every fucking color. Mom was like, "What?" I was like, "I'm gonna go to Hawaii. I'm gonna knock up a Hawaiian. I'm gonna go to Japan." Like, you are fucking nuts. What do you think? You're the Mexican Johnny Appleseed? I said, "We breathe like rabbits. You know it. You know it." Thank God I stopped with one. One was enough. The first one was a girl, and I was like, "Oh no. Why do all dominant men have girls?" Now I've got to worry about every fucking pecker out there. What a son of a bitch. Ah. So, yep, that was the end of running around thinking it was going to be Johnny Appleseed. I always thought it'd be cool to have a tribe.
Hey, Derrick.
Yep.
Mind if I ask a question about something I'm experiencing?
Sure.
Okay. So we were on live like probably last year, December. And one of the things that you shared was sending the letter to the DMV and putting them on notice about the information in the David system. Right. So in January, I went ahead and did
Because
that.
you're
And
you're in Florida, right?
yeah, I mean,
That's where the David system is. Yeah. Okay.
yeah.
Just make sure you're in the right area.
Okay, yes. So I have private plates. So
Awesome.
I did that in January. Probably about a month ago, I was pulled over by the sheriff department. And so to make a long story short, it turned from one to five sheriffs. Um, and I was not combative or anything, but there was a ticket, I guess, in the court system, and the license was suspended. So they were saying, "Oh, you're driving, you know, that whole spiel." I have some other foundational documents within the county, within the court, and two of those things are my name decree and a lex domicili, which basically the GPO. And then, of course, that document that I had put with the DMV. So I was in the sheriff's car for over 95 minutes because he couldn't do the ticket. While they put me in the sheriff's car, they went through the automobile to find, because I didn't give him any license. So they found an old license by going through the automobile.
From a poisonous tree, that's an illegal search and seizure. So any
Yes.
evidence that they ascertained is you're going to impeach. You're going to move to impeach it.
Okay. So
Are you going through a court case right now over that?
yes. So so I was in the back for 95 minutes because they couldn't put it together because of course that license had no longer had the right information because of my name decree. And so he finally took me down. I had to sit in intake for another hour and a half because the booking lady said the sheriff made so many issues that she couldn't do the intake. So so she had to call him and make changes. You know, I'm just being so nice. I'm like, I'm finna tear y'all butt up. But anyway, I'm just being so nice. So so she gave her little testimony and I got all of that.
I'll tell
Then
you
I
right
finally
now, if you start a court case in federal court against that officer, the DA will drop the charges against you.
Yes, so well I did start one in
Because the DA knows he'll be next.
yeah, I did start one and here's the issue to speed it up. So I did start one in circuit court against the sheriff and all of them and the DMV. And so the DA dropped the felony and recommended it back to county. And so the county court put in one count for suspended license. And then they issued the summons. Here's the thing. They issued the summons in my previous name that was on the license in the previous address that was not on the Lex domicile. And they have all this evidence. So now, do you have any suggestions on?
Well, you can impeach that information too.
Yeah, that's what I was thinking.
Before we can move forward with any litigation, all parties must be properly identified. And being the fact that they haven't properly identified the real parties in interest, therefore they have no case, no standing. So, yeah, let's go through that real quick. First and foremost, you got a recording device so you can catch this information.
Oh yeah, I know the game with you.
So this is what you're gonna do for the attorney on the matter and also for the officer that pulled you over. I actually have a good friend by the name of Lex, and Lex does some really cool shit with territorial jurisdiction. And you are going to cause this district attorney to run up the fucking wall because he is going to shit himself when he sees this. It is, let me see, Florida.
While you're pulling it up, does anybody know why the PDFs won't download or why it says invalid PDF when you try to download it on your phone? Anybody?
It might be just your phone. I haven't had any problem on a computer.
Yeah, me neither. Might be you don't have enough space.
So you have to open it before you download it. I open because I'm on my iPad. I had to open them before I can download them. So you open them and then you close it back and then you should be able to download.
It's not even letting me open them. It says an invalid PDF, and I've had this problem before. I just can't remember how I solved it.
Razor. Facebook for sale. Surrender. Structural trust. What county in Florida are you in?
Hillsborough.
This document right here will put their dick in the dirt. You'll have to go through and correct it and put your information in there.
Mm-hmm.
You'll have to take out Dudley Do Right, which is how he identifies the officers, which is funnier than shit. You can be an asshole when your intelligence supersedes 99.9% of the officers and district attorneys. So let me send this over to you, and then we can kind of go through this because this is part of the curriculum anyway.
Are we able to see that document too?
Yeah, let me pop it up on screen. So we just will bust it out now. Lex is very, very brilliant. And this document here actually went before the
I'm actually in Florida too, so I could use it.
This document actually went before the attorney at the JAG office. So when it hit their desk, it was a woman, and she ended up running into him a while after they had dropped it off. I don't think they dropped it off in person. He just knew somebody who knew the attorney that worked for the JAG, which is for the Navy. It's the Navy dealing with the military affairs in the Navy, right? Court martials and shit like that. And anyway, they just wanted this JAG officer's opinion on what she would do if something like this hit her desk. Can you guys see it on screen? It says Marion County Court heading. So anyway, they wanted her opinion on what she would do if she ever encountered it. And when she came back to talk to him, she goes, first of all, who created this? And if I recollect properly, Lex said, oh, just some janitor. And she's like, bullshit. Who put this together? And he's like, I'm serious, just some janitor, some guy. Well, Lex, to my knowledge, is the one that puts this together. And he goes, so can I ask you a question? What would you do if this hit your desk? And she goes, honestly, I pray to God nothing like this ever even comes near my desk. So with that being said, this establishes and proves exactly what we were going over earlier with the Constitution and the territorial jurisdiction and the fact that there is no judiciary and they're operating under Article 1, Section 8, Clause 9, Article 1, Section 8, Clause 3, and that they only have very, very limited scope of authority. For example, when we're going through Article 1, Section 8, Clause 10, or Article 1, Section 8, nowhere in there does it say that they can create the DOJ, that the Congress for the United States, that they were supposed to be a temporary form of governance until the land could be distributed to inhabitants, through letters patent and so on and so forth. What they ended up doing was the opposite. That's why they created that Constitution in secret and then didn't take the Article 6 oath. They created their own new little fiefdom and then fomented a plan to make everybody subject to it. So what this document does is completely puts their dick in the dirt, because technically all bar association members are supposed to be in Washington, D.C. There's none of them that are supposed to be out here. And no attorneys are authorized to prosecute. They're authorized to be defense attorneys, to be counsel, and to advise people, to help them in, their disputes and stuff amongst others. They're not supposed to be prosecuting us. Okay. So that in and of itself is mixed war against the Constitution, and in the un-American activities through the House Senate Judicial Committee Review Board of 1951, they declared that the Bar Association is part of the Communist Manifesto hell-bent on overthrowing the Constitution for the United States of America. Well, knowing what you know now, they did overthrow the Constitution for the United States of America. They drafted it in such a way that most people never even took cognizance of it. And the information that we were going through was from an attorney who was disbarred because he became so good with this information. So, anyway, state of Florida, alleged plaintiff, Lex, our hero, Marion County Court heading, alleged docket number, obviously, notice and demand. Come now and let us reason together, saith the Lord. Issue 1:18, King James Bible. No personal consent is granted for court jurisdiction by appearance, and this communication is not to be construed as granting such. Any forced appearance or order is under threat, duress, and coercion, which nullifies and voids out any presumption and assumption of contract and consent, which is two of the prerequisites they require and they're counting on, and is repugnant to the unanimous declaration of the 13 United States of America Declaration, which is the Confederation for the United States of America. Of July 4th, 1776, as the first organic law of the United States of America, which is predicated on natural law and God's law. See, the fiction can't deal with natural law and nature's God. Although it's supposed to be in harmony with it, it is very clearly not. As a living, breathing, flesh and blood man, see attached document number 1, Declaration of Identity. He created his own identification card because remember, anything they can do, we can do better. Hereinafter, I, me, my, I make my habitation, because he's eliminating residency. So he's not going to call it real estate or his resident or residency, his habitation on the soil, because they don't deal with the land. They don't deal with I would have used land instead of soil, but in the Constitution, they talk about land and water. So he uses soil of the sovereign, free, and independent state of the United States of America. The way that state of the United States of America, Florida, the way that I would have articulated this here is I would have had the quotation marks and the period and quotation marks, because Article 1, Section 1, that is how you properly identify the United States of America. Florida, the reason that he's doing this in the italics the way it is because he's going to distinguish the difference between the state of Florida and Florida, Florida being the republic, Florida being one of the sovereign states, independent and separate, its own nation, versus the state of Florida, which is a subsidiary corporation. So he's distinguishing that he is not part of their jurisdiction. In fact, he's outside of their territorial jurisdiction, and he knows it, so he's just affirming it with them. The United States of America, Florida, hereinafter, Florida. I state that on January 6th, AD 2021, alleged police officer Trooper Dudley Do-Right, badge number 666, I'm surprised he didn't put badge number, 666 of state of Florida, Highway Patrol hereinafter Do-Right, as I travel on the soil of Florida, located without the exterior boundaries of state of Florida. Now, remember, when I was teaching the class earlier, I told you that it is against the law. It is unlawful and illegal to put a state within a state. Can't do it. Well, that's exactly what these SOBs have done. And that lends to what Cool Fox was talking about genocide and democide. So boundaries of state of Florida and United States. did the following hereinafter injure me. A, stop me. So that's false arrest, false imprisonment. They declared an emergency when there was none. There's no aggrieved or injured party with sworn complaint, independently bonded, and sworn to via affidavit. So that stop is an unconstitutional stop. It violates his rights to life, liberty, pursuit of happiness, enjoyment of property. It violated his right to egress, regress, and egress as he sees fit, and was a clear indication of disturbing his peace and preventing him from egressing, regressing, and ingressing as he saw fit. So that right there is a problem. And you can't commit a felony to enforce a statute. That's the issue here. They're going, oh, never mind what we did. We created a felony by 25 felonies by stopping you, but you violated a motor vehicle code, and that's an infraction. Well, you don't get to go running around punching people because somebody stepped on your toe, right? You don't get to run them over with a car because somebody stepped on your toe. B, extract my signature from me under duress because obviously he's wearing a Batman utility belt. He's violating the Geneva Convention because he's got chemical weapons on his waistband. And cops have been euthanize people that are unarmed, so he's obviously in fear for his life. So he extracts the signature from him under duress. In doing so, when they extract the signature under duress, which they tell you that the signature doesn't mean anything, it's just so you've been veiled to the fact that you will appear. Well, it's a contract. They're lying to you. They're allowed to lie to you under the War Powers Act. They're allowed to lie to you under the Police Powers Act. They're allowed to lie to you, and on the martial law, they're allowed to lie to you by threatening to kidnap me if I didn't affix it on his alleged complaint ticket. So the kidnapping is another crime. They're trying to enforce these statutes, code city ordinances, rules, and regulations, telling you that they're upholding the law while clearly violating the law and actually committing federal crimes. C, take my private automobile against my will to be held for ransom, which is extortion. And when they take the automobile, absent a judgment, there has been no tax paid on the capital gains. That qualifies as grand theft auto. And so when they take your automobile and they don't do an assessment prior to taking the automobile, then we know they haven't paid the capital gains tax on the unjust enrichment for the value of the automobile. Does that make sense, guys? You follow me? These people do things that
Yeah, even the repo companies are on the hook for that shit.
Look, these people do things that if you and I did them, we'd be in prison for a while. But because they wear a shitty little slave badge, it's okay, which is bullshit. That's why me and thugs, we don't get along too well. Take my private automobile against my will to be held for ransom, which is exactly why they took it. There was no reason to take it, but they take it because then they can get these extortion racket. It's RICO because the tow truck company goes into cooperative agreement with either the city or the county, and so the police call the tow truck to come get the automobile. Now, here's what's interesting. They expect you to pay the fee. Well, if I order a pizza and it shows up, would it be okay to expect you to pay for it? If you order it, you got to pay, right? So the cop ordered the tow truck. Why is our man Lex having to pay for something he didn't order? Would any of you guys think that was kosher and okay? Absolutely not. So that's the extortion racket too, that turns it into RICO. And D, allegedly charged alleged defendant with the alleged offense of no registration and speeding. So then, of course, if you're seeing these numbers up here, he's referencing all of the sites, and this is perfect for you because it is specific for Florida. So everything here is going to be just fine. Make sure to proofread it. But everything in this is going to be Nat's ass, and you're going to send this to, with the exception of the fact that you don't have your own personal ID, but you can put your name decree in there. It's in lieu of the declaration of identity, unless you want to create a declaration of identity. It's not that tough.
Yeah, in my name decree, I put a declaration of identity in that case.
Oh, beautiful. Well, then you've got that all set up, so you just want to do that. All written law must identify the territory to which it applies. That right there is a killer. Because we know that the laws that they create only apply to the little fiefdoms they have, the buildings, the land ceded to them, the things that they own, right? It doesn't apply to everything. So, and the reason that they respect this is because if they don't respect our right to property, then they know we're not going to respect their property rights either, and it will come to a head, and they know that. So they have to respect this because it's predicated on the sound doctrines and principles, and their territory is very, very small in Florida. They got the Florida Everglades, they got Pensacola. For federal territory, there's a small strip in the middle of that little peninsula out there. That's federal territory, and the rest of it is pretty much open. Oh, they've got the entire Florida Keys is also federal territory, to which it applies. This territorial jurisdiction is necessary and must be proven upon demand when interacting with any alleged governmental or quasi-governmental entity or employee. See attached to Memorandum of Law. I hereby challenge do rights alleged jurisdiction, territorial and extraterritorial, to injure me on the soil of Florida as I so travel, and therefore the alleged authority of the Assistant District Attorney, ADA, to prosecute this alleged instant matter. United States acknowledges that its territorial jurisdiction is limited by virtue of the organic laws. There are only 4 organic laws. You got the Declaration of Independence, Articles of Confederation, Northwest Ordinance, and the Constitution for the United States of America. These laws clearly define the United States territorial jurisdiction. A United States property includes, is limited to that territory owned by or otherwise subject to the exclusive legislative jurisdiction of the United States of America. United States territory, in this instance, state of Florida, not Florida. This notice and demand is limited to examining whether or not state of Florida, hereinafter the state, can present evidence the state has territorial or extraterritorial jurisdiction over the physical geographical location, in other words, meets and bounds or latitude and longitude. See, you can't blend fiction with reality. Right here, they're fucked. They're absolutely fucked because he's asking for the geographical location where the alleged violation happened has to be within the officer's territorial jurisdiction, and they know damn good and well it isn't. Where do right did injure me, and of course he's pointing out that he suffered from an injury. Hereinafter, this location, my relation to do right is an issue of whether or not this location is on state of Florida, in this state, in the state, and every statute, and every state, in all 50 states, in the statute, they do this little thing. It's predominantly found in their traffic code, and it'll say in this state and in the state. These are 2 different things, and we need them to provide clarity because this is the same thing that happened in the Constitution, in the Constitution and in this Constitution. So they're doing the same shit. This is lawyer attorney fuckery right here, or any other United States territory. And if not, what purported law that do right acts pursuant to confers his extraterritorial extraterritorial jurisdiction to injure me at this location. When jurisdiction is challenged, it must be proved before a court may proceed. For illustration purposes only, at least 3 United States territorial courts concur. And then he's going to give all that great stuff. Oh, this is 9 whopping pages. Boy, Dudley Do-Right did piss him off royally. A police officer's role is ministerial. All right. You know, if you've listened to me for any length of time, I'm always saying ministerial administrators, administrative law judges, administrative law clerks, everything has to be specifically laid out, and there's a purpose for it. And actually, a police officer is a motor vehicle code enforcement officer. And then for the municipality, they're actually identified as a safety patrol officer, and they're charged with the duty of doing benign things like making sure that the bushes and trees and yards are trimmed up. They're not even qualified for making motor vehicle stops because they're not qualified and certified under the Department of Transportation. They're not Department of Transportation officers. So there are only certain officers that are actually allowed to be making traffic stops, but these shit dicks get away with it because they go into cooperative agreement with the state, the AAMVA and the BMV and DMV. And so that's how they're getting away with it. A police officer's role is ministerial and mechanical. No court or officer can acquire jurisdiction by the mere assertion of it or by falsely alleging the existence of facts on which jurisdiction depends. No officer can acquire jurisdiction by deciding that he has it. In all such cases, every officer, whether judicial or ministerial, decides at his peril. In other words, they carry the primary active degree of fault for operating as a private mercenary outside their territorial jurisdiction and subjecting you to his presumption that you are subject to the jurisdiction that he works for. Okay. And so they carry the primary active degree of fault for that assessment. And so when you sue the officer, he can be all butthurt all he wants, but what he really needs to go do is sue the county and the city and his training officers because they failed him. Territorial jurisdiction may never be waived and must be established beyond a reasonable doubt. People versus Thompson. Territorial jurisdiction can be challenged at any time. Before sentencing, during sentencing, after sentencing, you can go 20 years back and you can reverse a decision. That's why I tell you guys, case precedent and res judicata and stare decisis are not law. They're just an opinion that has stood the test of time for a little bit. And at some point, there's either due process violations, procedural violations, or as you guys discovered over this class, you now know that there is no judiciary, which means every fucking ruling they have is ministerial administration under the administrative branch that doesn't even exist pursuant to the Constitution. It's an internal thing for the District of Columbia. Territorial jurisdiction may never be waived and must be established beyond a reasonable doubt. When it clearly appears that the court lacks jurisdiction, the court has no authority to reach the merits. This is huge. This is huge right here. The merits. In such a situation, the action should be dismissed for want of jurisdiction. Mello versus United States. A court lacking jurisdiction cannot render judgment, but must dismiss the cause at the cause at any stage of the proceedings in which it becomes apparent that jurisdiction is lacking. Now, the jurisdiction, it's not for the judge to decide if there's jurisdiction, and it's not for the alleged ministerial administrator for the court to establish jurisdiction on the record. It is, in fact, the duty of the officer and the district attorney to establish standing in territorial jurisdiction on the record, and they absolutely fucking can't do it. Therefore, It would be a trespass against this location for anyone to proceed or attempt to proceed before territorial or extraterritorial jurisdiction is proven. A claimant has the burden of proof. It is a sequential burden from first party encountered to last. Each has the burden of proof, and it cannot simply be kicked up to the next party in line to answer on behalf. In this instance, do right is the first party who assumes the initial burden as the alleged charging officer. The proof is in do right's personal capacity words. This summons served personally to the defendant on January 10, 2018, the issuing charging law enforcement officer states under penalties of perjury and falsification that she has read the above complaint and that it is true, emphasis added. Alleged officer placing statement, you operated upon a public highway, namely CR 44, directions eastbound at near SR 48 in the township of Ocala in Marion County, state of Florida. In order for the state and consequently any territorial court of the United States, of the state or United States to acquire territorial jurisdiction over this location, per the written law, this location must be on United States territory, for example, state of Florida. In the alternative, in order for the state and consequently any territorial court of the state or United States to acquire extraterritorial jurisdiction over this location, a law must confer due right such. I have neither been shown nor presented with evidence, nor am I aware of any material fact, A, demonstrating either of the following.
Recording in progress.
One, mute you there. Sorry. There we go. A little bit of feedback because you're recording. That this location is on the state of Florida or any other United States territory, or that do right acts pursuant to a law conferring his alleged extraterritorial jurisdiction to injure me at this location. Therefore, B, I am convinced no such evidence and likewise no such material facts exist. 15. However, it is not incumbent upon me to try and prove that this location is not on state of Florida or any other United States territory, and B, that do right acts pursuant to no law conferring his alleged extraterritorial jurisdiction to injure me at this location. Therefore, I hereby demand that the state provide me with one of the following: a verified document evidencing this location is actually on state of Florida or any other United States territory, and afford me a reasonable opportunity to rebut such alleged evidence, or the law do right acts pursuant to that confers his alleged extraterritorial jurisdiction to injure me at this location. Otherwise, cease and desist this attack upon me. However, the ADA failure or refusal to present me the herein above demand evidence or either one of the state's alleged jurisdictions, territorial or extraterritorial, respectively, instead demonstrates the following: the state confesses, admits, and tacitly agrees the state has no evidence this location is on the state of Florida or any other United States territory, and two, do right acts pursuant to no law conferring his alleged extraterritorial jurisdiction to injure me at this location. The state has no such evidence and do right acts pursuant to no such law because exterior boundaries of state of Florida and all other United States territory. Did I skip a line there? Yeah, I did skip a line. Because do right did in fact injure me as I travel on the soil of Florida, located without the extraterritorial boundaries of the state of Florida and all other United States territories. And in fact, no law confers do right extraterritorial jurisdiction to injure me at this location. Thus, do right has no authority whatsoever to injure me as I travel on what is, in fact, the soil of Florida. Therefore, do right did, in fact, injure me in his private personal capacity. In so doing, the state acquires no standing to invoke court powers. Thus, the ADA is, since the beginning, acting also in his private personal capacity, acting in bad faith, and therefore engaging in barratry. Consequently, Marion County Court or any other territorial court of the state of the United States, of the state or United States, does not have the territorial or extraterritorial jurisdiction to proceed. Both the ADA and do right impede my right to travel on the soil of Florida as I freely ingress and regress to and from other sovereign, free, and independent states. Therefore, both the ADA and do right actions are repugnant to Article 2 and Article 4 of the Articles as the second organic law of the United States of America. Thus, both the ADA and do right collude to deprive me of property under the color of law. Whereas, unless the state first acquires the requisite jurisdiction over this location, then do right or the state of Florida Highway Patrol in turn have no jurisdiction to confer upon a court. Full illustration purposes only, at least one United States territorial court concurs. The parties cannot, even by stipulation, confer jurisdiction upon a court where no jurisdiction exists. Jurisdiction is established solely by general law. Evans versus State. Any action people acting as and for a court take against me before that court acquires territorial or extraterritorial jurisdiction constitutes an act of violence. It's actually domestic terrorism with no lawful jurisdiction. Finally, for illustrations purposes only, the territorial United States Supreme Court and others concur. No judicial process, whatever form it may assume, can have any lawful authority outside of the limits of the jurisdiction of the court or judge by whom it is issued, and an attempt to enforce it beyond these boundaries is nothing less than lawless violence. Again, domestic terrorism. We use domestic terrorism. It's a lot better. Violence and injury are the things chiefly hostile to peace. Therefore, these actions, absent the requisite jurisdiction over this location, force me into peonage, a state of involuntary servitude. Here, a human rights violations, leaves the state liable for additional damages and also leaves both the ADA and do right liable for additional damages, all incurring in their private personal capacity. The ADA failure or refusal to present me to the here and above demand evidence as also demonstrates the following: that using false or misleading representation of fact, the state did willfully intend to exact unjust enrichment with past communications, does, and willfully continues to engage in a systematic ongoing course of conduct to exact property affirming. The state does, and continues to do so in furtherance of a scheme which is likely to cause confusion and thus deceive as to the affliction, connection, or association of the state as to the origin, sponsorship, or approval of the state's services or commercial activities. Therefore, the state does, and continues to engage in a scheme to defraud and therefore experience benefit of the bargain. Both Do Right and the ADA did voluntarily both communicate on behalf of the state and acquire usufructuary easements for the state in property that I merely use, held in alleged defendant's name, being alleged defendant's property. Therefore, the estate has been, unbeknownst to me until now, unjustly profiting from said property. Thus, the state, do right, and the ADA have and continue to cause me injury, all of which affirm I have a valid cause of action. Covenant. So anyway, I can send this over to you if you like. And
yes, I would definitely love that. I would.
I have for you. You might want to take out Dudley Do Right and put dipshit in there. Dipshit's just it's much more poignant, you know.
You have my email from the form, or do you need me to message it?
From Super Troopers.
Fuck, I'm done.
Hey, Derrick, would you send me a copy of that as well?
Yeah, I sure can do that. Yeah, this is from our brother Lex. He's a sharp cat. Let me see here.
Would you mind dropping that in the chat? Some of us that want it.
Let me see.
Yeah, that might be easier. Everybody can just download
I'm
it.
not very computer literate, so let me see what I can do here.
Please send that to me as well on New York.
I'm gonna download it and let me see.
If you email it to me, then I can put it in the chat. If that makes it easy.
Let me do that because I just downloaded it, so now I'm trying to.
Yeah.
Let me see if I can just forward this whole damn kit and caboodle to you because I think there's other things in here that you may enjoy. 122 of probate book. Let's see. Notice of exercise of power of appointment. Yeah, because
I'm not very computer literate. If you could email it to me, I'd really appreciate it.
Hey, that will work.
I can do it for him. Once he sent it to me, I'll do it so he doesn't have to.
Okay,
focus
and
on
this other thing is for you in Florida as well, and it's
You say you want to go get some breakfast?
administrative determination declaration via tacit procreation. 21 days. Which one is this? Is this the change of address? It is the change of address, isn't it?
No, make sure you some breakfast.
All right. I just send this whole file over to you because I don't